SEBI Act with IBC. For the first half of the session, we have with us Dhanapal sir. I would briefly introduce him before we begin with the session. Sir is a law graduate from Dr. Ambedkar Government Law College, Chennai, and a commerce graduate from the University of Madras. He is currently a founder and the managing partner of S. Dhanapal Associate Firms of Practicing Company Secretary in Chennai. He has over 15 years of experience in areas of corporate secretarial and legal matter and has been monitoring corporates as well as professional with his wide experience, knowledge, and professional acumen. Sir has recently contributed as speaker and Sir regularly contributes as speaker and writer in various professional forums and journal. He is a well-known resource person, have addressed as speakers in over 200 national and regional forums throughout the country. Sir is also a regular visiting faculty and in our institute and in our other courses as well. Sir, on the behalf of all the participants and ICSI IIP, I would welcome you for this session. And before we begin, I would just request all the participants to please keep their respective mics on mute until and unless they have any query to be discussed. And to make this session more interactive, I would request them to please switch on their videos. If they're in a position to switching it on, they can please switch it on so that it is an interactive session. Sir, over to you now.
Thanks a lot, Madam, your brief introduction. Good morning, all. Hope you are all in the same.
Good morning, sir.
Today, that we are going to deliberate is on Companies Act vis-a-vis IBC. See, in fact, both acts are very important legislation of our country, as you all aware. Okay. I could see about 39 participants are here, except Madam and organizer must be.
Sir, we have total 52 registrations.
Oh my God!
I think some will connect in few minutes.
Good. I thought I'm only late, so I'm not late then. Okay, I'm on time then. So I'm giving a free hand to our friends to join. So if we would have started the session by 9:30, they would have missed a major portion of the session by now when they are joining. But okay, let them join. Anyway, we will start taking forward. And as you told, ma'am, I just wanted to take this session as interactive one, because more than I'm explaining something here, these particular aspects, we need to deliberate and understand more. Rather, I would say that it's a very important aspects that we are going to deliberate today. That too on the Companies Act vis-a-vis IBC. So before proceeding further, I thought generally, I try to understand few things from participants so that it will be easy for me, to which direction to take the session, my session, so that I'll get an idea. So based on your inputs. So I just want to understand from participants, because I hope many of the participants must be in IP. A few may be pursuing, or few must have be practicing from the beginning, very beginning. Few recently, but whatsoever, but the understanding should be the one and the same on the subject. Now, before proceeding, I just want to put this one question to you. Okay, see, I'm also learning every day. Okay, it's not that we are all now equipped. No, every day we are learning, particularly on IBC, the changes that are coming in always now and then. We keep learning only every now and then. Okay, so now I literally wanted to know from participants, just share your views, whatever it is, because let's try to exchange our views so that I will also be benefited in the process. Today, do you feel what are the required changes that is to be given effect under Companies Act vis-a-vis Insolvency Bankruptcy Code is given effect into the Companies Act, whether their respective changes whatever is required under the Companies Act has been brought in as on date. Can viewers can throw some light on this? Can your inputs on this? Whether all amendments have been carried out with respect to IBC in the provisions of Companies Act to make sure both are going in tandem. Yeah, I just you can share with us. You are also into practice only. You must be facing difficulties or situations. You may be also thinking that this particular portion should have been there in the Companies Act to enable, or should have been there in the IBC to enable for the smooth implementation of the process. Can anyone just share your views?
Yes, sir. Good morning, Mr. Dhanapal.
Yeah, tell me.
Sir, I would like to share that with regard to like issuance of shares, right? Further issue of shares. So we have the right issue, preferential issue, etc. Right? And in that, because there are other amendments in Companies Act with regard to IBC, like with regard to discounted price and etc. Right? So they specified that under IBC they can have this discounted price or other through any resolution mechanism of RBI. So in the same manner, like issuance of shares also, they can have that carve out like for the resolution plan which is approved through IBC process. So for the purpose of issuance of shares, all these provisions will not be applicable, right? So in that manner, there would have been some express provision that like issuance of shares or other mechanisms through which the structuring is done because of IBC like resolution plan. So I think that would have been better because it is expressly provided, right? So this can be incorporated like issuance of shares, etc.
Okay. Any other inputs? Friends, any
Yeah,
other?
good morning, Mr. Dhanapal.
Yeah, good morning.
In as far as Companies Act is concerned, in an insolvency company, if you don't have enough directors on the board for example, for key decisions like for adopting account, etc., in terms of number of directors, women directors, this always becomes a problem in respect of in the insolvency process, and that is still counted as non-compliance. Now, if the corporator is, this is the one issue. Second is in respect of if the corporator is a listed entity, let us say, and there are these requirements as per the LODR. If the company does not have sufficient cash flow, how is the company able to pay the listing fees, the depository fees, payments? All these become a heavy cost, and the LODR does not recognize an insolvency company. The MCA does not recognize an insolvency company. All these compliances are supposed to be carried out by the RP, no matter what. There is no, let's put it, the regulatory forbearance, so to speak, envisaged in the Act, which I think needs to be taken up by the IPS.
Can we say there's a lack of clarity in the Companies Act or in the
I think there's no forbearance. There is no recognition that these, there's no recognition that these issues could come up in this thing, and for an RP to ensure compliance becomes a tough thing. So there should be some mechanism by which these issues can be at least flagged to the IBBI and MCA, so that it is recognized, and then this particular these actions will not be construed as non-compliance of the act, of the statute.
That means enough amendments is yet to come in the Companies Act to make sure IBC is taken care of.
Absolutely.
Any input on this? Any other inputs?
Yes, sir. Sir, good morning. I am Sundaresh Nagarajan from Chennai, from PK Prevail Advisory. I recognize IPE. So instead of looking at what is not in tandem with the Companies Act or IPC, I am looking at a total sweeping requirement in terms of when you give the moratorium, when the board is suspended. See, instead of the IP should be the RP should be more focused towards resolution. So why unnecessarily you put him so much compliance and other things? When you give a moratorium, you totally give from Operation of Companies Act itself. So that will give a lot of time for us. Otherwise, see what is happening, most of the companies is 90%, why 90%? 95% companies are gone cases. There is no information, there is no tracing of promoters or registered office or books of accounts. And unnecessarily this poor RP is running around builder to post to comply with the requirement. So he give you a total, what you call, a sort of moratorium till this is completed. None of the Companies Act will be applicable.
Okay, so necessary amendment should be brought in Companies Act to see that.
Yeah, I totally agree with the previous participant, because there is not of clarity under the Companies Act. When the company went to the insolvency, lot of compliances are there. Filing of forms are not with the MCA, with facing difficulty. There's no clarity in that. Somebody resign as a KMP, there is no requirement. There is no how these forms can be filed. You know, there are certain reforms required in the, to make the both actors go smoothly.
And just one more, I will add it. In case of listed companies, it should be automatic, what you call stoppage of listing in the stock exchange. Otherwise, it's becoming the biggest gambling happening in the share market today.
Any other inputs?
I would like to add on with regard to, like, sir, this is a different class of companies, like, so that government, hello, am I audible, sir?
Yeah, please.
So, like, sir, as the ministry has used the section 462, that is for the purpose of giving various exemptions, right, to private companies, government companies, etc. So they can have also this as a separate class of companies, like companies under CIRP, right? So rather than amending the other provisions, if they are providing some exemptions through some circular or notification, right, that for the purpose, whenever the company is entered into CIRP after filing ISC 28 or through a court order, right? So during that period, these provisions will not be applicable or will be applicable through certain modifications, right? So I think that would help, like composition of board, taking the resignation of directors, because they are in dicey situations, whether to accept or not. So whether 168 would prevail, or there is some IBC with regard to which says that day-to-day management will be in the hands of the RP, right? So they are confused that whether independent director can resign or not, right? So in that situation, rather than approaching again to NCLT or to COC or putting some judgments, right? If it is better, certain exemptions are given the class of companies, that during CIRP, their ID or NEDs, and they are not in day-to-day management, they may resign, or the resignation will be accepted by the RP. So these type of exemption notification should be given, so that it will be a different class, from my view. I think they would help or in the ease of operations during CIRP process.
Yes.
My view is that actually, in SEBI, they have carried out adequate amendment that once this company is admitted into CIRP, then so and so clauses will not be applicable. For example, composition of board, minimum number of independent directors, but similar provision is not there in the Companies Act. The result is that, for example, there is a requirement to comply with the board meeting, then the IP has to run around everybody to convince that there is no need to hold the board meeting, whether it should be held or not. There is no requirement for holding the board meeting. Now, for me, since I have taken over a new company, I have to do the secretarial compliance also. No, I have to convince the secretarial auditor also that these provisions may not be applicable. If many of the provisions are not applicable, then why to engage such person to have the secretarial audit and submit to the stock exchange? It is unnecessary burden on filing and all these things. So similar on the lines of the amendment in the SEBI Act, that is SEBI LODR has been amended. Similar kind of, there is a urgency on the part of IBBI to take up this issue with the MCA, and they should list out the relevant section that the moment the CIRP starts, then these sections are not required to be complied. That would definitely ease. Otherwise, we will always be discussing all these things, that whether to comply with this or not. You see, we understand and appreciate that there are various compliances which need to be done. For example, if we take over a manufacturing company, so there are pollution control requirements. So there should not be any exemption from the pollution control requirements. Then there are compliances under the Factories Act. For example, the company is a going concern. That has to be done. But at least to start synchronizing all these things, first, Companies Act did the major act from where the things should start, although it has started from the SEBI. So this is very important because unnecessary time and efforts and energy is being wasted on these issues. Because in the normal course also, people, maybe since we are into the IBC, so we are loaded with a lot of information and knowledge and case laws and all these things. But similar, our brothers and sister professionals who are even CA, who are even ICW and CA, they are not aware of the IBC compliances at all. If they are handling as a charter, for example, even the statutory auditors, even in my case, statutory auditors are not able to digest that this company is into CIRP. Now, what is their role? Almost 4 months has gone. And I am constrained to file application under section 19(2) and also file application before the ICAI, raising issues of non-compliances by the statutory auditor and neglect, professional neglect on his part, because that person is not at all coming to discuss the issues with the IP. He's even after 4 months into CIRP, these people are interacting only with the ex-promoters. They feel that only they have employed, so why should they deal with any other? And the promoters, they are into CIRP many years before the company is into CIRP. So some promoters, they are shrewd enough to plan all these activities in advance to create problems or to hide the information. So I think this issue is not being addressed by IBVI. And this is very important for all of us to deliberate as to whether there should be immediate some action on the part of IB. Instead of discussing what should be applicable or not, there is a need to at least discuss what action should IBVI take to relieve the IPs on this.
I think then I'm the right path of taking this session, I think.
Yeah, of course. I was busy with certain other engagement, but I have spared this whole day for this seminar only. Thank you.
Actually, I got a 3 PPT to present, okay, to be open, frankly, to talk to you. I have prepared 3 different PPT where there's a connection between the Companies Act and IBC. Okay, whether there's through an amendment or through orders of the court, through judgments of the court, what are the connections, how the amendment has been made, to some extent, how it was gelling each other, that I made 3 PPT. But where it is not gelling each other, I have to prepare 10 PPT. Okay, so that's why I thought, rather, as you said, rightly said, rather I'm more focusing on, of course, I'm going to take that session also. We are going to deliberate on that aspect also, no doubt at all. But even other way, I should do justice to what I'm doing, because what here is gelling, okay, it is 5 times what it is not gelling each other. Okay, the IBC and Companies Act, as you said, you are, of course, one of our friend was taking a reference about the private placement, not applicability of provisions of chapter 3 and 4 for the CRP companies and companies under liquidation when they issue cash. Well taken point. Same the case where one of our friends said section 149 appointment of independent director, where the exemption should be given or at least some clarity should come. So same the case for many situations, whatever coming up with the moment commencement of CRP. In fact, one of our friend, the participant, has nicely pointed out, I think Mr. Prem Narayan, I believe. He was telling about that there's a notification for every category. I also feel that that's a good input actually that we can give to the department, wherein there's a notification for a private company, what are the exemptions given to the private company. There's a notification issued, what are the provision is exempted to section 8 companies, right? And same the case, what are the provision exempted to the government company. You all will agree that there are separate notification for each category of the company, little, to see that they are kept in a comfortable position to make sure, practically, which is not possible. Government has understood Okay, these are the things which is not practically possible, that they have to be kept outside of the compliances or should be given a relaxation. So I literally surprised how you are surprised. Same level, I also literally surprised. Implementing such a big law in our country, that too in a code, okay? And we are reading the media and paper which says that the government literally, achieved the purpose of about, before expiry of a CRP itself, some 2.5 lakh crores have been paid. That's what's reported. I'm telling the rough figure. They are telling, though there is much resolution took place, but still the recovery is more. That's what the reason reporting done in the media and newspaper. The recovery is more during the CRP itself as a pre-settlement, out of court or before going to liquidation, the settlement is taking place. More than 2.5 lakhs crores is getting settled there. That's what it is getting reported. Then how much attention should be given to facilitate and ease out the process? So that means there should be a notification exempting, the companies which are under CARP, the companies which are under liquidation, what are the provisions are applicable in the Companies Act, what are not applicable, or what are the exemptions given to them. At least some clarity should be given in the form of an exemption and the form of a notification, wherein you should say, clearly spell out how one more senior friend has told that the SEBI, they wherever required, they came out and they gave out, at least tried to some extent to give out some clarity. Similar way, I think we should request IBBA and even MCA to stand up and come out with such kind of clarification wherever required, because the IPs and liquidator cannot proceed further with the presumption, not even with the understanding, with the presumption what he must be doing right. That should not be allowed forever. Okay, it's okay, 5-6 years, the RP and liquidator can be allowed to manage the show and to see that he is able to carry out the role properly, with the presumption that okay, we are in tune to the provisions of Companies Act. But why it should not be made it very speaking? It should be very speaking that the RP and liquidator, what they should do when the company in CRP, when the company liquidator. At least we have to list out the provisions of Companies Act and say, these are the provisions are partially applicable, not applicable, and stand applicable. At least some kind of notification can be brought in, so that will ease out the entire difficulty faced by IPs and the liquidator. I really agree with all your points. I think our friends, Mr. Satish Joshi, wanted to tell something. Please tell me. Then I will take you through, after hearing out all of you, I will take you through what are the provisions that are going in tandem with the IBC that I will take. Yeah, Mr. Satish Joshi, probably you are there. Mr. Satish Joshi, I think you raised your hand.
Yeah, good morning.
Yeah, good morning.
See, I was just listening some of very interesting comments from seniors.
Yeah.
But I feel that everyone is seeking some exemption.
Yeah.
From Companies Act provisions or other provisions. I mean, a company which is in ICU needs attention, and one cannot say that this dose of the medicine should not be given or this dose should not be given, and it reached to that situation because of these kinds of irregularities only. So a chartered accountant can ask for that. Okay, there must be some income tax exemption also. The TDS should not be deducted like that during that period of time. So such kind of exemptions may not be good or may not be given by the government agencies.
I heard a few of friends, just a moment. I heard a few of my IP and liquidator friends that for every 2 days once there's a notice from income tax for the companies under liquidation under section 142, 147, 144. Every 2 days once there's a notice. In spite of reply is being given that the company is liquidation, right? It cannot follow the same thing what can be followed by other company. But they keep sending the same notice, keep following the same procedure, and the liquidator, literally an RP and liquidator, there is no other way, they are keep responding it. Yeah, please.
No, you're right in
And
saying so.
I'm sorry, I am interrupting. Actually, even after replying to the income tax department, they continue to issue notices to all assessees who are your supplier or either customers. And all those customers and suppliers are after your blood to furnish the information as desired by the income tax authorities. And you are always wasting time and convince them that you don't have access to the books of accounts. How to respond to these things? So that is just, I wanted to add.
Yes, sir. Yes, point well taken. Yes, Mr. Satish.
Yeah. What I'm saying that I have given thought to, in fact, I have attended 3-4 cases. So with my experience, I think that if we start in a very, I mean, when we start at that point of time, the court should also establish IP in a proper manner. For example, if suppose a case is there where IP in the case of operational creditor, where IP is not mentioned, at that point of time, the court should always ask for 3 copies, 3 sets of the records which should be filed. Because if once IP is appointed, 1 set of copies should be given to the IP. Otherwise, normally 2 sets of records are filed for one for judicial member and for other members. So in that case, but the IP has to start fresh to know about the company. So if 1 set of the document is given to the newly appointed IP or IRP, so his starting will be much easier. Number 1. Number 2, sometimes it happens that the directors and other people, those who are the stakeholders, may knowingly, I mean, they don't come forward. So in that situation, it is very important that the court should summon them or should issue them personally, so that their cooperation is sought in such manner that the IP should not face much great difficulty in starting the process. So these types of things, these are the practical things which we should understand and should try to emphasize, because we can't expect the government will give the waiver of any kind of things, waiver from one section or waiver from other section. Once they will ask these directors or the promoters to come forward personally and they issue the summons to them directly, I think that they will sensitize and understand the seriousness of the process. This is my submission.
Any other points? Mr. Vinit, I think he was raising hand for some time. Yeah. Mr. Vinit?
No, fine, sir. Fine. No.
Yeah. I think we, after hearing from our friend, I think now, at least now I understand that the real difficulties that, as a RP and liquidator, each one is facing. Of course, I'm also doing a role of a liquidator to company. So I also understand the difficulties that are being faced by all RPs and the liquidator, because now and then, as our Mr. Satish was telling, and the company is in ICU. That's how it is given to the hand of the surgeon. Actually speaking, it is given in the hands of the surgeon, right? When it is given in the hands of the surgeon, yeah. You want to tell something?
Yeah. I have one more suggestion.
Yeah.
Like in our temples, if you know about it, that even the idol is installed. So Pran Pratishtha process is generally done before we start worshipping even the idol also. So the IP's Pran Pratishtha has never been done in a proper manner, what I could make out. So they have the plenty of power, but more than that, the obligations are great. So in that confusion, because every known person or every professional person will like to be more professional in discharge of their duties. So under that pressure should be eased out. This is the submission.
Any other points?
Yes, I have one more point. As I am Nagarajan, once again, one more point I would like to highlight and also request you to cover it in your session regarding destruction of value of EPC companies, because every contract containing a clause, once the company is referred under insolvency or anything, okay, the contract will get automatically cancelled. So there should be some sort of an embargo in the Contract Act for CRP companies. Till CRP is decided, there should not be any particular cancellation of the contract. Otherwise, what is happening is once cancellation happens, nobody is willing to step in. Today, if you look at it, NARC or what is it is acquiring, most of them are only EPC companies, which are of high values, basically.
That means it should keep the contract live. The
Yes, very much, very much.
All the contracts are live, and the moratorium should also be applicable not only for the proceedings and matters, cases, also to the contracts.
Absolutely.
It should not be cancelled. That's what you are trying to say.
Yes, yes.
I think little this moratorium is fine-tuned to this cover aspect, to cover this article aspects also, then I think the problem will be solved in that aspects. Because they will not simply no, as you said, when the company should be revived, if the contract is cancelled, then where's the question of revival? Only when the things which is continue to happen, if continue to happen only, it can be revived. When the water source is stopped, the source is stopped, then how it could be revived?
Sir, I will tell you. See, from the contractor point of view, also what they will be thinking, if I am not going to cancel this contract, I need to, I cannot award this contract to somebody else. So my project is in limbo, and naturally it will involve cost overrun. So in my interest, I am cancelling it. That is the argument they will be taking it. So how to find a win-win situation for everyone? That is what we should look at it.
Okay, no, that is there, but see, here the problem here is when the RP and liquidator is given a task of reviving the company, if everybody else thinks about their profit, their gain, okay, then the whole thing, if only with the cooperation of all stakeholders involved in the particular corporate debtor, then only the entire exercise will get succeed, right? Only with the cooperation of all stakeholders. That means the status quo has to be maintained by all the stakeholders to make sure that they are not changing their stand position. That means if they awarded the contract, they continue to remain with us. Then only the RP can take effort, see that how the contract is going forward with the new hands, new management, right? So suppose the contracts are cancelled, the goods are not supplied, the service is stopped. So everything is stopped, then there is no question of companies getting revived. So it won't happen. See, it can happen only when what happens in the company continue to happen to the corporate debtor in the presence of the RP, then only it can be kept as a going concern. When every stakeholder think about that, of course, they are suffered. No doubt, they are also suffering. In the process, they will be losing their profit. Everything is there, fine. But when the company has to be revived for the betterment of the economy, society, and corporate, and workman and employee, all that. So to some extent, everyone has to sacrifice to some extent, including the stakeholders, supplier, to see that they are also traveling with the coming together with the RP or liquidator to make sure that they are also helping the system to give the to produce a better result. Because it's not that, see, we always say that with a single hand they cannot make a sound. Okay, you need both hands to make a sound. So like that, as a RP, in a single hand, he can't make any sound. Okay, because the government, the law expect RP to act, once he takes up the company, he should make sure that he is bringing a laudable things to happen in the company, that at least to revive the company. So that can't happen without support of other stakeholders. That first, the stakeholders should understand and agree and continue to cooperate, as our Mr. Nagarajan was referring. When the contract is cancelled, there is no point of reviving the company. How the company can be revived when the contract itself is cancelled? So like that, many situation comes in the company during the CRP situation and putting a hurdle hindrance to the going concern. Okay, to make sure the RP is maintaining the corporate data as a going concern. In fact, why I took up this particular aspects for discussion today is that we all, in fact, I remember same topic I I remember I spoken in 2019 also. After that, various other different topic we keep discussing, deliberating in various forum. But I'm seeing why this particular aspects alone is untouched even now in companies like. In fact, our brother, one of our brother was telling here, a participant was telling, when the company is in ICU, even the notification should not be there. It should be fully exempted. That means you should not expect that the patient who is in ICU is doing all kind of exercise, walking, jogging, to make sure everything is taken care of. How he was doing in a normal scenario when before coming to the ICU, the same thing we can't expect from the person to do. It can't happen. That means the situation changes. So accordingly, the expectation also should change. Okay, the person who is walking, who is healthy, or who is doing exercise, who is doing some pranayama yoga to maintain his health, you can't expect the same thing to be continued to follow a person who is in ICU. That's what the representation or the concern raised by our participants, and it's well taken. Actually speaking, when RP and liquidator, they are expected, of course, today liquidator, because the law is developing, evolving, the corporate data should be sold as a going concern. The days now slowly getting, means the situation is getting changed. The days are gone where the liquidator is expected to sell the assets alone. Now it is getting evolved and almost evolved that in every corporate data, now the stakeholder department and courts, they are looking at the corporate data should be sold as a going concern. How many of you agree that? Is there any answer in the Companies Act how the corporate data can be sold as a going concern? How many of you here have an answer in your hand, including me? Do you have an answer? Leave it all corporate data issuing a shares and an independent director sitting in the board and the resignation of the director, whether it could be accepted by the RP or not. Leave it all how the board meeting can take place, how the AGM take place, keeping all that time being on hold. Let's discuss on a very important other aspects also. Of course, I'm going to take you through on all those aspects in the session. But before that, I just wanted to take your input so that at least I know what to convey. I should not convey what already you are going through. There is no point. So that's the reason I wanted to first to understand from you, so that what we are deliberating should be a good output to each one of us. While this should be a good takeaway for each one of us. Not that simply I am repeating what already you are going through. That I am also repeating the same and closing the session. I don't want that to happen. We need to find out some takeaway, some solution, so that at least going forward with that clarity, we should move forward. So today the law is getting evolved and got evolved already with the many judgments and order under IBC, where the corporate data has to be sold as a going concern. How many of you has gone through this situation, or do you have any answer under the present Companies Act 2013? How the corporate data can be sold as a going concern? Can you share your views on this? Do you have any?
Yeah, Mr. Dhanapal. Can I?
Yeah, please.
You are absolutely right. This story started in February 2018 when the regulators who are the custodian of this law started with a notification circular by say circular that the IRP, RP of the liquidator are responsible for the all kind of the compliances under the Companies Act, securities laws and other laws. This started with that. Before that, even the MCA could never thought of it that whether to come out with the notification or not to give the exemption like the government companies, Section 8 companies or special class of the companies. But what's happening after that, since you are under the obligation to do the compliances, there is certain controversies. Controversies first is relating to the transfer of shares. The free transferability of the shares is the basic fundamental feature of a company, whether it is under the Companies Act or whether under the securities laws. Section 28 put the restrictions on the free transferability. Nobody has tried to deal with that issue. I have been in touch with the SEBI. We have been consistently telling SEBI, and they are also discussing this, that how to deal with this. When you are talking about a listed company going to the CRPs, the shares are being traded. How they are being traded freely? How the transfer can take place when the section 28 specifically talk about the approval of the COC to make any kind of the changes in third party rights of arise the shares are concerned. The first controversial question which has not been addressed. Second question comes when the board of directors are not existing. Then section 129 books of accounts. Yes, we can understand that we have to comply with the law and prepare the balance sheet and financial statement in accordance with the law. But the difficulty is that when you are going to make the filing, they are not director. Just by saying a notification or another circular, there is no amendment in the law. There is no amendment in any of the rules and regulations framed under the Companies Act. But straightway they say that IRP, RP or liquidator has to act as the CEO of the company. So a circular cannot make somebody as the CEO. My first point, right? It has to be by virtue of an action of the board of directors. Somebody has to be designated as an KMP to be recognized. So what they did change in the programming. Sometimes they make him that portal you can make the filing. And when they understood this point, that this is something is not going aligned with the law, what they did, they said, okay, fine, you can file the all forms in 2018, 20, they come out with another circular, taking away the earlier circular through GLN2. Now the question is arising, if the directors are not cooperating, they are not signing. They are signing, it's fine. You can file AOC4, you can file MGT7, you can file all kind of the things. But then who will sign the balance sheet and how those balance sheet will be filed in the XBRL or other mode? So these are the controversial issues which are coming out of it, and it has to be dealt with the thorough amendment in the law, right? Because you cannot force a director to sign. They are suspended, but NCLAT says that they are still under the obligation to comply with the law, right? If they are cooperating to you. This is the second issue. Third issue, you highlighted that whether you have dealt with the sale on going concern basis as a corporate debtor in going concern. Yes, I have dealt with. In one of the largest cases in India, you must have heard the Sterling Biotech. I was the professional advisor to that case. That case which was going to the CRP, failed in CRP, controversial case, was not sold for 400 crore, was sold in the going concern as a 650 crore rupees owed. And that company has also been handed over. That company was listed entity. So all compliances relating to the listing was, to the extent possible, was complied with. And thereafter, with the order of acquisition plan, acquisition plan approved by NCLT, that company has been made a private limited company. I have also dealt with many other cases in which, right? So this is possible.
Yeah.
But there are
no. I'm saying
difficulties are there because of the transferability issue, because of the authoritative issues. These are the two things which I understand. Yes. So I'm talking about just from the perspective of the interplay between the IBC and the Companies Act. Obviously, SEBI laws also come into picture, LODR also come into picture to that extent. The trading are taking place, but I do not know how the trading are taking place, how the transferability is happening, what will happen to the RT arrangements, what will happen to the depositories arrangement, and how to deal within the liquidation those arrangements. NSDL is confused. Last week I met NSDL, they are confused. They are charging to the liquidator for the, ISI 9. And there are the number of ISIN, what we are having, maybe for equity, maybe for debt listing securities, number of ISIN, and they are charging per entry basis. From where the fund will come. And you cannot just, cancel those arrangements because they are protecting the interest of the investors. The SEBI is concerned that you have to continue to protect the interest of the investors. So these are the gray areas which we need to ponder upon, look into, and definitely we have to raise these points before the specific regulators. I'm sure the IPA is also taking note of it, and IPA will raise these points. We'll, take the inputs from this session and we'll highlight what are the issues. These are the legal issues. Thank you.
Thank you, Mr. Vineet. See, the point which I was raising, of course, you covered a few aspects of that. See, the point what I was trying to literally deliberate here is that, of course, we'll be discussing in detail. I was telling, just I've got a few cases of also how the corporate data was sold already. There are many cases are there, like Topworth, and many cases are there, like Sterling Biotech, what you said, all that is there. All is, it is then the record and it is then the, public. So now the question here what that we need to understand, basically under the provisions of Companies Act, I think Mr. Prem Narayanan, I just give me a few minutes, I'll finish, then I'll take your input then. Okay. See, the idea here, the point of which I am bringing here, why I want to bring here, there is a provision in the Companies Act, okay, section 180 says how to deal with the, okay, sale of an undertaking. Okay, you know that what are the process to be followed, what are the provisions to be complied with under section 180 when the undertaking has been transferred or sold or leased out. Okay, and there is a process in place. Okay, done. And the same way, there is a provision under section 230 how a company can be amalgamated, how the company can be demerged, and how the company can get into the any kind of arrangement, and how the restructuring process can take place. Okay, then so there are provisions, there are express provisions that are available, like section 188, related party, how they have to deal with when there's a sale of assets, or movable or immobile, whatever that can be, according to in compliance with the 188, it has to be carried out. So now there is a provision in place for every situation, how a particular situation should be dealt with. In case of a transfer of undertaking, in case of a merger and amalgamation, in case of a demerger, and even in case of course, we are going to deal with winding up and all other liquidation matters. Now almost I remember from 2019 beginning, the what we are discussing about the sale of going concern started. This concept of sale of corporate data as a going concern, section 32 as a given a start by virtue of an order of honorable courts. Now, my point here is that, is there any provision there in the Companies Act today? Leave it all the orders of the honorable courts that I also aware, you also aware, and everybody aware, which is then public domain, court websites, all that. There are many cases are there. More than 10-15 matters are there where courts have taken up. Really, we have to appreciate the honorable courts have really took up the matter, and literally they were tried to give a clarity on how the sale of going concern has to be dealt with. In a few courts given in a different state, and few courts are given a different state. Okay, and of course it's ultimately left with the liquidator, and to make sure that they are complying in tandem with the IBC, in tandem with the provisions of Companies Act. In case if there is any gap, the liquidator is answerable, because whatever the court order says, that liquidator will be complied, no doubt at all. Wherever the order does not speak about, or where there is a gap between the Companies and IBC, which is not spelled out in the order, then the liquidator will be in a position, or the buyer who are going to buy the corporate data as a going concern is there. They are going to deal with the situation, see that how they are finding a solution for that. Now the question comes here, is that a provision there in the Companies Act today enabling to sell the corporate data as a going concern? In case, yes, whether the Companies Act spell out, how it spell out for the allotment of a paid placement, for professional allotment, for appointment of director, and many things, even related party transacting, giving loan, taking loan and giving loan and borrowing, all that, there's a clarity exists, right? The Companies Act throws even for the, as I was referring, the compromise and arrangement and schemes and other things. And under the provisions of Companies Act, whether the clarity exists, how this sale of going concern can be carried out in compliance with the provisions of Companies Act, in the absence of order of the honorable courts, how it should be dealt with and what are the exemptions given. That's what I was trying to take inputs from you. Yes,
Mr. Dhan,
yeah,
Mr. Dhanapal, in this regard, section 232 to 32.
yeah.
See, whenever the liquidation is started, the first try has to be section 232, 32 has to be made. That is a kind of the mode in which the company is as a going concern. But you have to make the settlement with all kind of the creditors. The difficulty is that value. In trust the companies at 3/4 of the value you require from the all class of the creditors to satisfy that. And probably that is the reason the 99% cases are switching to the second mode, going concern on the estimated value what you derive and then offer it through the auction process. So that is happening. The few of the cases has already been dealt with. So there is a provision in the Companies Act, and initially if you look at the IBC, there was no as such the concept of the sale of going concern basis. It evolved over a period of time. It started with the Gujarat NRE matter, in which CRP failed and the promoters came forward, and then it evolved. The section 29A is also applicable in the liquidation, and accordingly, IBBI also amended the regulations, giving a time frame of 30 days to first offer the company in terms of the unclad order only, right? In as Dhanapal, something is what a matter I can remember of unclad, and they came out.
Mr. Vinit, the
Yeah.
Dhanapal is me only, okay?
Yeah.
This,
Right. So
this is the case ordered in my matter only.
yeah, I know that. That's what I'm saying, sir. I also recall it.
I'm just telling you.
So, yeah, absolutely. In that case, it evolved that you can offer the company on the going concern basis first. You should try it. In all the cases, the liquidator has been given a guiding force that irrespective of the law, you should try that the company can be first sold as a going concern. And thereafter, the regulations were amended, and regulation enables the liquidator to sell it through different modes as a business as a whole, or as you said, the rightly second mode that you can do it as a demerger scheme like kind of concept. You can offer one particular business unit and you can offer the second unit and other asset you can sell. And this is the same concept which is coming back to the CRP also nowadays, that the CRP can also consider a one particular set to sell as a going concern. One particular set can be sold in a different manner, right? So recently, we have seen Deccan case, which has been upheld by the Supreme Court, in which the two kind of the buckets were prepared. One has to be sold as a going concern, another which are not active assets can be offered to the creditors in lieu of their dues. So these are the things which are evolving, but there is no specific law as such. Here, what we are hanging around is that there is a contract between the Companies Act and IBC, then IBC will pay, because this is a law, this is a code, which notwithstanding anything contained in any other law for the timing in force, including Companies Act, it will have an overriding effect. So similarly, you pointed out section 188, which is a relevant section for related party transactions. So if a company is under CIRP, if we go by the Companies Act only, it can very well carry out the related party transactions. However, section 28 of the IBC put the restrictions that you cannot carry out a related party transaction without the approval of the COC. It means it has an overriding effect. And despite that, we have section 188 enabling me to carry out related party transaction. I cannot do it unless until I comply with the section 28. So there are certain sections which I can take the advantage. The difficulty is that certain things have been clarified through circulars only, while the law has not been amended. This is creating the difficulty. What is my say? Yeah.
Over. Okay, good. See, no, I will give my inputs to Mr. Vinit, then probably you can start. See, here, I understand what you explained. Here, the point here is that there are matters are there, as you said, recently Honorable Supreme Court has went up and said what you said could be sold as a going concern. Here, the point is here, the section 230, what you are taking up, that became a third category. Actually speaking, that became a third category. One is a CERP, the category 2 is a liquidation, sale, third category is a scheme. So here, there is a clarity. Of course, I was telling, in fact, my own case that I will try to explain at the end of the session when I'm taking through that particular slot. So in that matter, in fact, that only started the whole thing, a concept of contemplating a scheme during the liquidation. Now, the question here are the input that we are really looking at is that section 230, 232, 233, all it's making it clear that we are all know that our scheme can be contemplated, how it could be executed under the provisions of Companies Act. Of course, the order of Honorable NCLAT has completely covered, brought in fact, in my own order, they brought entire section 230, the entire section has been reproduced in the order. All is fine and it's well understood. Now, scheme, of course, after that, our IBBA also went up and they made an amendment. They amended, they brought the provision of subsection 1B of section 2. All that is there. They were trying to give some clarity today. We are moving forward with some clarity based on the various orders of the honorable courts, no doubt at all. Here, the idea, the particular point which I wanted to literally focus here is that scheme, of course, we have idea. Many of us are professional, practicing professional. We would have dealt with the scheme of merger, demerger, arrangement, compromise, all that we would have dealt with. But here, the sale of going concern need not to be specifically in the form of a scheme under section 230. The sale of going concern, what is contemplated, even mini order. You can take many order, for example, top worth, as you said, Neuro, this Sterling Biotech, and many other cases are there. After that, also this has been reported, has been ordered. Many other cases also, the sale of going concern has been contemplated. And how it should be dealt with has been contemplated in the order itself by the Honorable Adjudicating Authority. How to dealt with, say, cancellation of paid up capital and issue of new share. All that is dealt with by virtue of the order. But here, is there any provision has been amended, or is there enabling provision than the Companies Act, or is there any notification circular has been brought in to see that it is facilitating? Though every RP and liquidator, they are approaching adjudicating authority now and then and trying to take order and trying to implement how you implemented other matters other by you are referring that. So here the point is, leave it all the order the honorable courts are giving, because they are giving order to make sure things are moving forward. But here, once we amend the provisions of Companies Act, that is out the entire thing actually, because the RP and liquidator will have a complete idea that how it should be dealt with. Now we have so many orders in place to make sure that to amend the Companies Act in tandem, in tune to the provisions of Companies Act. In case of a situation where the corporate debt are expected to be sold as a going concern, or by virtue of the order to be sold as a going concern. Now what section regulation 32 of IBA regulation contemplates is a 5 scenario, where the scenarios sale of going concern, sale of the corporate data as a going concern, sale of a business as a going concern. We can understand sale of a business as a going concern to some extent, because the corporate data is not touched, only business is touched. It could be sold as a, there are few cases reported for that also. The honorable courts have went up and clarified certain things in the sale of business and sale of corporate, all that. Now, how practically the sale of going concern should be dealt with in compliance with the Companies Act alone should be the point of discussion for us. Because honorable courts, to that extent possible, they are trying to give clarity. In fact, the relief in many of the order, they are clearly listing out what are the reliefs sought by the a successful bidder as well as the liquidator. Whatever relief court is granting, in fact, clearly they are making out a table and giving it order. Literally, we should appreciate and we should bow to the courts where they are trying to, take effort. They tried and took effort also to come out with the clarity, giving lot of exemption. But then too, I heard from our liquidator friends that with that order also, implementation becoming a difficulty, where many times the registry, says that the provisions of certain things that should be complied with. So that becomes, a liquidator and RP, leaving them just for, I'll tell you, I know one matter which is getting pending for more than a year, just for the reason the RP is finding difficulty to roll check the director DAC to make sure that he is filing and resigning the earlier director and bringing a new director. That because of that reason, he keeps approaching the department, keep giving a letter to the department, and department expect a speaking order for that. He is trying to approach honorable adjudicating authorities, and they are trying to give some order, and again it's getting interpreted, and just to roll check a director into that. I'm saying, of course, there are few practical difficulties with the website also, and you all know today the DIN, because of all this DIN activation, DIN deactivation, this backdoor, this thing also we are doing. integration. So all that is the practical thing which is we are facing. Leave it all that. Here, sale of going concern, corporate data as a going concern is something which is not told about in the Companies Act very clearly, how it should be dealt with, how it is very clearly spelled out in the Companies Act in case of a merger, demerger, in case of scheme of restructuring, how it should be dealt with, what are the compliance should be followed, how the application should be made, what kind of order should be passed, and what are the approval should be taken. All that has been dealt with very clearly under section 230 to 235, no doubt on that. Same way the case under section 180, it's told clearly right from section 293A under 1956 Act to today's section 180 of present Act 2013 Act. There's a clarity exists how the corporate data, how the undertaking can be sold, okay, and how it can be leased out. At least the process is in play. What kind of approval should be taken in place? But sale of corporate data is a bigger concept. It needs really a bigger attention. Of course, there are orders which we can follow. We can try to implement it in letter and spirit, no doubt at all. But unless it comes in the statute, I don't think that will solve the entire problem while transferring the corporate data as a going concern in the successful bidder. And yes, over to Mr. Narayan, please. Prem Narayan, you can share. You can give your inputs.
With regard to your 180 section 180 reference, so sir, I would appreciate because that lease or sale of undertaking, like sale of business as a going concern, right? So in that situation, suppose the corporate data is not being sold, only the business, like some business segment is being sold. So in that situation, the issue arises at the time of taking the special resolution or approval of shareholders, right? Because sir, unlike the situation of board of directors where it is specifically mentioned under IBC, that board of directors power will be subsumed in the RP, right? So nowhere reference with regard to the powers of shareholders are mentioned. So again, the issues arise whether how to take the approval of shareholders, right? Special resolution. Because this plan or whatever will come, that will not be in the favor of shareholders, in the majority will be held by these promoters. So normally they will not approve any such resolution. So suppose I want to sell that undertaking, rather, right? Undertaking a business or that segment to someone. So how to take the approval of shareholders? So these are the issues. Well, special resolution is right because I'm not going for that 230 or 232. That's not an arrangement, but simply we are selling that business undertaking or as a business going concern, which is provided in IBC regulations. But issue arises with regard to shareholders' powers and approvals. So I would like to highlight that these need to be incorporated somewhere specifically that what will be the situation of shareholders' powers, like this for like convening the AGMs. But they're saying what I will say if I'm saying no to that approval of accounts, right? Whether it will be stopped, whether the RP will not file with the authority. So they will file. So simply what they are saying when we are coming for any meeting and we don't have any say or our say whether it's yes or no, it doesn't make any sense, right? So there must be some codification or some specific provision with regard to shareholders' power also. That whether RP will also subsume the power of shareholders also, or how what he will do with regard to special resolutions where certain that is mandatory, like 180 also. He has to say only with the approval of shareholders, right? Shareholders saying no, then he has to whether he has to go to 230 matters or 232 matters, right? So these are certain issues where the powers of shareholders are not very clear. In my view, some clarity should be given with regard to shareholders' power in companies in relation to CRP matter.
Yeah, actually, the thing with the situation, what you explained, is a resolution plan, during the resolution plan. Of course, during the resolution plan, at least the resolution plan can contemplate how the resolution applicant want to deal with the corporate data, right? On approval, how you want to deal with that, he can put it across the whole thing in the plan itself. So after going through the plan, after understanding how the corporate data is contemplated to be revived, all that is inbuilt in the plan itself, which is getting nod of honorable adjudicating authority, then it is getting implemented. So at least there's a clarity exists because we have a liberty, we have a luxury of mentioning everything in the plan itself that see, subject to this only I'm taking over. Whether the same luxury is available during liquidation, selling the corporate data as a going concern without the order of honorable courts. That's the whole point we are trying to discuss and trying to understand. Any other inputs? Any participant, any other inputs? almost today, now we reached 50 participants here. I think I was expecting more inputs from you. You must be.
Sir,
Yeah, please.
Sir, once again, Nagarajan, one more major issues I have been seeing is in terms of the avoidance transactions. Sir. See, one side of it, IBB expect RPs to file the avoidance transaction and other things. Another side, the NCLT is not permitting the COC to what you call not to proceed with the avoidance transaction. See, now, you take a classic example of MSME. MSME, one side you are permitting the promoter to go and bid for it, and he is a winner. And NCLT saying you go ahead, but against him for the avoidance transaction, assuming he's what you call found some fault or guilty of it. What will happen to the resolution plan he is submitted? Is it not contrary?
See, that's why I think there's an amendment came. That's the reason before resolution plan itself, the amendment came within 120 days. The RP is given a responsibility. You must be knowing that to see that he is making out what are the avoidance transaction and give the information to the resolution applicant so that the resolution applicant be informed of what kind of situation, what kind of action or what kind of the position that he is going to take. Okay, when he is submitting the resolution plan, even after approval of resolution plan. For that, the resolution applicant should be given in hands-on information about the avoidance transaction. Then the call can be taken by the resolution applicant accordingly, and adjudicating authority also can take a decision accordingly and approve a resolution plan and also decide the fate of the avoidance transactions.
Sir, actually, it is the other way about, sir. One side, even though they have amended, but IBPI does not want the resolution plan to contain anything to exonerate the promoters. See, as a resolution applicant, successful resolution applicant, I continue to need the support of the, what you call, the old promoters. Okay, in which case, I want to give some carrot to them so that they will be with me at every point of time. Okay, so why I should not, what you call, look for waiver of personal guarantees? Why I should not exempt them? I'm not interested in proceeding against them in avoidance transaction. Why you go and tell all those things? Let the COC take a decision. Let the SRA take a decision. Why IBBA poke its notes and say you should not do all these things in the resolution plan? Why you put an embargo on it? Now you are making things. See, that is the main reason why pre-pack was unsuccessful in India, because you went ahead and told you need to give a declaration about the avoidance transaction. Sir, I will tell you, sorry for the language, which idiot will give? What are the things he has done in his life and his existing promoter? So it is a non-starter. You cannot come and grumble today. Pre-pack is not successful. See, how to make pre-pack successful. In fact, the withdrawal, the 12A and 29A need total revamping. Why you want to talk about 29A? You remove it. If somebody is willing, leave it to the lenders. If lenders are willing to get the cash from the existing promoter, who are you to come and stop it? So 29A, in this forum, I don't want to tell why 29A in a hurry was brought in, but 29A need to be removed. You leave the wisdom of the COC. Okay. 12A also what happens? Everything is over. That is, a resolution plan is submitted. Finally, and COC is accepting 12A. Today, what is the expenses involved to submit a resolution plan? Who is aware? What sort of due diligence people are doing? A resolution applicant, how much he is spending. So all his money goes into a waste. Once CRP is initiated, or once an application, why CRP initiated? Once an application is see, what is the purpose of IBC? To incipient stage, you should identify the sickness and do remedial action. So withdrawal by way of taking a post-dated check, is it a remedial action? Once it is filed, you should not be allowed to withdraw. And even before CRP, okay, everybody should be allowed to go through the pre-pack, come to the CRP. Then only it will be successful, sir.
Okay. So input is taken, sir. See, of course, here is, yeah.
Dhanapalji, so far as the MSME is concerned, this is altogether a different area. And I think government has taken the necessary steps. Also, 29 has also been relaxed for the MSMEs. So far as puff transactions are concerned, unless until adjudicating authority confirm that the transaction is a puff transaction, there is no prohibition as such. And I hardly see any case in which the adjudicating authority by the time had confirmed something like this and resolution applicant has been put to hold. So 29A was having certain purpose, and I think that purpose has already been achieved so far as the 12 big cases has already gone. I also agree to some extent, this is the time that the creditors' democracy, like the share rights, can be upheld. But coming with the Gujarat NRD cake, when Gujarat NRD matter, when the 29A was made applicable into the liquidation proceedings, sir, I think it is not going to be easy that the government is going to dilute in fully. MSME, it has already been diluted. The only challenges the MSME is going through is relating to the third party securities. The promoters who have given the guarantees or the securities. Technically, 29(1)(h), I understand, has also been exempted for them, but the creditors are facing the problem that wherever you have given the corporate guarantee, right, or you have given corporate guarantee and you are also the resolution applicant, because MSME, the promoters are the resolution applicant. So this is an issue which is before NCLAT again, because in one of the matter, they said that you cannot settle the third party securities. Otherwise, so there is no prohibition in the law to deal with the third party securities also in the resolution plan, sir. Number of the cases, the third party securities has also been, including promoters, their own guarantees and securities has been released by the banks in within their power of what you say, wisdom of creditors. So it has been done. So this is something is an evolving thing. Let us see what happens in time to come.
I think we can't completely take away 29A also, because in maybe few cases, as you said, may sound better, but few matters, of course, that only protects the company also in
Yes.
few matters.
Yes.
In few matters. So I don't think directly we can jump in and tell that the government, no, you take away that.
Yes. I agree. I agree.
It cannot be tailor-made. Okay.
I agree.
Some understanding has gone in,
Yes.
and government has brought in something, and we only know about Big 12. That may be next level of Big 12 also.
Yes.
That will be
Power sectors are waiting.
medium level of Big 12 also. So
Yes.
I think better to be that. But as you said, wherever we find difficulty, always honorable courts are ready to give relief for that.
Yes.
Only
Yes.
time is they are taking little time and try to understand the whole situation and to give relief.
And MSME, they are giving, sir. It is a specific loan for MSME.
They are giving relief. So wherever okay, they are giving relief. And this particular aspect, what we are discussing, IBC versus Companies Act, that alone, it is literally a big challenge. And I'll tell you, probably the RPs and liquidator who have dealt with the matters, who gained experience with a few matters, would have been comfortable today. But who are going to do it first time without order of A. If order of A is there is a shield.
Correct.
There is a shield. I agree, no doubt. There's a shield. Then too, I know many times the department, because I myself gave many advices to few companies, where in spite of the order, they struggle with the department to just to change few things in the ministry records. Till they are telling that no, you go and get something this, that, X, Y, and all. But that XY, demanding XY is a matter of time for the department. For us to get that XY, it takes 6 months to 1 year. I'm just telling, in a situation where normally things are moving across, right? But the entire thing should be within 330 days time. That's what the CERP has to get over as per the IBC. So what I'm trying to say here, though the courts, without action, the courts, literally honorable courts are taking up and giving you a solution, no doubt at all. They are literally taking up. When reading few orders, I literally get surprised only. Good that the courts are taking up, going to this level and giving exemption and all, right? So they are taking a chance only, actually speaking, because when one order, if it is questioned, then only we know what exactly legal position of the entire order.
Very true.
I'm telling, when one order goes to the level of Honorable Supreme Court and everything read and everything is questioned, then only we'll be knowing that what is the exact legal position, what we have done based on that Honorable Adjudicating Authority order. So I don't know, fortunately or unfortunately, I don't think anything has went up to the level of Honorable Supreme Court to get it questioned or to get it clarified whether whatever the RP or liquidator are implementing, whether it is a sale as a going concern or sale business as a going concern or whatever may be the category, but whether all are as get a blessing of MCA, whether all is getting a blessing of MCA, and tomorrow is there any assurance to RP and liquidator or the successful bidder that there won't be any single proceeding against those companies, because there is a provision brought in after, as you all know, Section 31 has been brought in, and Supreme Court, Honorable Supreme Court, in a matter of Johnson and Mishra case, they made it very clear that the moment the association plan is approved, it binds all the authorities, and you should not go and unnecessarily disturb the questioning the successful the resolution applicant after the approval of plan for past liabilities. At least some clarity is brought in by virtue of that provision. At least they are reliefs. Of course, our brothers and friends are taking this as a reference only and trying to, and got many orders from honorable adjudicating authorities. I know, taking this as a reference, they got many orders for the case of liquidation. But till it is only in the form of taking orders and implementing, because how like we are implementing the schemes by virtue of Section 232, same way we don't have that the freedom, that luxury, to say that yeah, Section 232 permits me to implement in this fashion. Same way we are not in given that luxury when implementing sale of corporate data as a going concern, sale of business as a going concern. So that level, if the provision is inbuilt, then I think that will make the entire situation. I'm saying even if it went up to the level of Honorable Supreme Court also, at least there will be a provision be inbuilt by the time, so that whether it's a liquidator or whether it is a AA or whether any other court for this matter, they can always say there is a provision inbuilt in the law itself. So there's nothing to again to vouch the whole thing. But today everything can be vouched again. That's what I'm trying to put across to you as a point, so that you will also give your inputs on this. Whether the matter which has already took place, the matter which is already taking place, which will be taking in future, all that will be vouched again. That's my question. In the absence of provisions of the Companies Act 2013.
Dhanapalji, I think the questions since morning we are pondering upon is another colleague has very, very aptly said, and I started with this only, that the biggest controversy and inconsistency between IBC and Companies Act is the shareholders' right, free transferability and their rights during this AIRP or liquidation. Because court talks about the suspension of the power of board of directors and authorities being entrusted to the committee of creditors during this AIRP. It never dealt with it. It has nowhere also dealt with how to deal with the shareholders' right. Obviously, there is no denial that once the resolution plan is approved, it is binding on all stakeholders, including shareholders. And because of NCLT, ultimately Section 230 or 232. So how to deal with the situations? I think the specific exemption or clarification is required, that how to deal with the shareholders' power, like 188 contra to the Section 28, transferability of the shares under LODR and trading place without approval of the COC. This kind of inconsistency in the law, particularly relating to the shareholders' rights or transferability, is required. Right, sir? I remember the first resolution plan of the country when it came, Synergy Dure, everybody remember. And I was fortunately again the professional advisor of that case. So when that plan in 2017 itself came on the table, people started questioning to me that how, Minister Vinit, you can say something in your plan, right, in which you have given your go-ahead, it can be a merger and amalgamation. How it can be a merger? You will find, you go to the groups of the 2017, you find multiple questions being raised to me when I raise my hand that this is the first plan which has been approved by NCLT. And I'm fortunate enough that to be the part of that. So I said where it is denied, because this is a complete restructuring plan. Merger and amalgamation is the basic feature of it, right? If you are acquiring a company through a merger in terms of a resolution plan, I think this is the best way of restructuring. And that had not only been upheld, but has also taken shape in many cases.
Yes.
So time tested, sir, time evolved, like liquidation in going concern, how to do it. Yes, there are the certain issues where rightly observed. There are issues relating to the accounting. There are issues relating to the taxation. There are other issues relating to the how to deal with the claims, particularly government claims, and assessment taking place during liquidation when there is a complete moratorium of section 33 subclause 5. Nobody can have any kind of proceeding, but government authorities are doing a lot of assessment and sending you. Who will make them understand? So I think the time will come when we will reach to that level also, that will be settled down.
Yeah.
But yes, you have very, very aptly taken this topic today and have deliberated on the basic aspect of the inconsistency between Companies Act and IBC. You have very well highlighted, and we all agree to this, that certain amendments are required, not only clarification. By virtue of a circular, you cannot make somebody as responsible to do all kind of compliance. You cannot make somebody as CEO to do everything, while your portal is itself not supporting that CEO. When your portal is also not supporting, when you do go for the compliances, your roll check is not happening. When your portal are not supporting your AOC4 and XBRL document are not taking signature of the RP, they are asking directors. And on one side, the ROCs are issuing notices to the IRP and RPs after the implementation of resolution plan, why you have not complied with the law. So this is a fallacy. This is a fallacy which has to be understood in the context of the law. And I think the programming of the systems and the flow has to be created accordingly. This is what I understand with my experience, and which you have also highlighted.
In fact, last week I happened to meet one of the group company head, the MD, the company which got revived, a bigger company which got revived after approval of resolution plan. In fact, they were screaming this now. See, the approval plan has been approved by AA and it has got blessing of everything and got implemented and got again kickstarted. It's a bigger company, listed company. Okay. Now the sales tax today, the department raising a liable demand of so many hundreds of crores and thousands of crores. And they are saying that after I'm genuinely implementing everything properly, after today, this level of demand, how to deal with that? Whether I can concentrate on the business, that too reviving a company, and that too a listed company, which is doing a turnover in thousands of crores, and reviving a company. Today here the department starts quoting some recent orders, judgments. What I should do? Do I concentrate there, or where I will get a hope to revive the company? Because what law exactly says, if the demand what is today raised by the authority, in case upheld, then what is the position of the person who has bought the company through a resolution plan?
So Dhanapalji, my question again coming, and I want to understand for my colleagues also, let us discuss.
Yes.
That the law talk about that RP is under the obligation 2018 circular I'm talking about to hold the annual general meeting of the company also, whether it's a listed company or low listed company. It means you have to prepare the accounts, you have to get the balance sheet signed, or you have to sign the balance sheet. So whether you have to sign the balance sheet or you have to get the balance sheet signed, first question, then who will do the adoption? Shareholders. Who are shareholders? Majority of the promoters. You have made them corner if they are not adopting the balance sheet. Who is responsible for that non-compliances? These are the two issues I want to understand. How we are going to deal with these issues and how the law actually evolving in this matter.
See,
who will sign the balance sheets? Our first question, where directors are not cooperating. And what about the section 129, which talk about the accounts has to be signed in the following manner?
Yeah, this what means by telling it's practical difficulty, and everyone is facing.
Yeah.
So, sir, Deepakji, because I am going by the experience
we are discussing at various platforms, but there is no solution to it.
There is no solution. So somebody has, Dhanapalji has also highlighted, So I think Deepak ji, IPA people must be here. I'm sure they must
Yes,
be
we
taking,
are
because they have this
facing
kind.
practical difficulty.
Deepak ji, I was keeping myself silent because of the last 1 year I was seeing, because at the part of system, sometimes you cannot, but today probably I cannot. This is too much.
Yeah.
No, it has to be raised somewhere. Somebody has to take the inputs. This is not a point that we are sitting and just discussing, taking credit over and going back, nothing else.
No.
I
Yeah,
believe
yeah,
that we
yeah.
have to give a solution to our fellow brothers who are suffering.
Exactly.
Look at the liabilities
Correct.
the IPs are taking for everything. Everybody is coming and just making me scapegoat. Not only the resolution applicant has also started taking a ride on the resolution professionals. You are responsible to do all compliance, do all kind of the filing and to regularize the portal. The portal which they cannot regularize, they are expecting from RP to regularize. And Dhanapal ji is right. Many cases under implementation are pending. 31st yesterday, sir, there was an implementation. You can't believe, last 4 days, day and night, we worked that how to have a director on the portal by which enabling the issue of the shares on 31st and then can be utilized by the banks in the late night, 11:30 it happened.
Correct.
And still what is happening that the MCA whole team is sitting and nobody is able to update that version 2 to version 3 database. So
Same way in NCL.
these are the practical side. These are not the legal issues.
Yeah.
These are the issues which has been created by the service provider. We are specifically on the issues which has been created by law, inconsistencies created by law, and what can be the way out of it.
There are two things here. One is absence of legal provision. Other
Yes.
is implementation issues.
Implementation issues.
These both are not addressed.
Yes, both are not addressed.
Both are not addressed actually.
Yes.
At
Just
least
to
only
issue-
addressed, okay, little we can breathe and see that we are implementing it.
Yeah,
Both
Jain Sahab is also there. So Jain Sahab, just to issue a circular to say that you are responsible for all kind of the compliances under Companies Act and other laws, for the timing enforce may not suffice the purpose. You can make somebody responsible, but it will not happen.
Yeah.
We really want the turnaround of the companies and resolutions within objectivity to maximize the value of the asset and the country at large, right? We have to come together with a complete solution.
See, we need
Not only this, even this regulator IBBI and this
Yes.
NCLT after the IRP. You know,
Everybody found one person to issue the
Yes.
notice IRP. How it will serve the purpose? It will increase the litigations and will increase the revenue of our fellow friends in the court of law. That's it.
yes.
So IPA team must be here. I'm sure the IPA team must be taking some inputs. They will try to prepare some note that what are the inconsistencies which has been pointed out by the professionals and how to deal with those inconsistencies under the Companies Act and LODR. Both way. We are there to help you out to make the presentation also. At individual level, I am making to SEBI and they are considering.
So, Vinitji, to answer your point, what you were asking about balance sheet, this is a problem from the beginning, not
Yes.
today.
Yes.
You know that there was no provision in the Companies Act, but RP was expected to do everything.
Dhanapal ji, lekin the problem is started when they say you are CEO, you are responsible.
Yes.
So long I am not responsible, then let the problem be there. I would say let no AGM, nothing. Let there be a cooling period, moratorium inapplicable for everyone. But moment you say no, you are responsible, then you have to give a solution to me.
See, what I'm saying, there is a power. See, I will try to explain you. The Companies Act 2013, they makes it clear what is the powers of director, what is the duties of directors. Same way, Insolvency Bankruptcy Code, it makes it clear what is the duties of the RP, what is the duty of the IRP, what is the duties of the liquidator. Here, what is missing is only the cross reference.
Yes.
The missing is cross reference. If they can do some arrangement where the cross reference is brought in, that will solve all the problem.
I think
problem here is they are trying to only give solution to certain issues whenever it has go to the knowledge.
I think, sir, I think Dr. Dhanapal, there is one more legal issue to this. The legal issue is that IBBI can only register you, can only regulate you. They cannot register company, they cannot regulate directors, they cannot regulate promoters, they even cannot regulate the bankers whom they are trying, COC. So for everything or for anything, they say IP. That is a difficulty. Unless until the IBBI is also having that power, we have to understand their point also. Moment they have got that power to regulate, they would have done it. So this is the Ministry of Corporate Affairs, which is the super regulators for all these bodies.
Yes, correct.
Right, sir?
They can-
Regulating directors, regulating shareholders' rights, regulating the, IBBI professional body, administrative body, right? And there is a coordination cell between the various ministries. So Ministry of Finance has one cell that talk about Ministry of Corporate Affairs and the SEBI, including the part of the,
Both Companies
stock
Act and
exchanges.
insolvency, both in Companies Act and insolvency,
Yes.
both are coming within the domain of,
Yes.
you said our.
Yes. So as a Ministry of Corporate Affairs, as an administrative body, so far as IBC is concerned, sir, has to undertake this activity to facilitate and come out with a complete model, so far as the shareholders' right and duties of RP, IRP concerned, and accordingly e-forms has to be recasted.
So this is the reason I don't want to today take it as a monotonous session where, see, I know all brothers and friends and all, everybody must be knowing Companies Act
Yes, yes,
and
yes.
IBC. Without that, they are not practicing. It is not something that we are going to really improve their whole knowledge. More than improving knowledge today, because which everybody will gain today, but facing difficulties, how to deal with the difficulties, faced by the RP and the liquidator, when the question comes, when the gap comes between the Companies Act and IBC, how the difficulties, how the issues that can be faced, how it can be sorted out. That is the only thing literally today it is high time for us to understand. We know that both of us, all our friends, everybody of here as a participant, I know I'm sure everybody today would have understood IBC and Companies Act in a fair way, fair level, how to deal with the situation. But only thing is, wherever there is an absence in the legal profession, our brothers are left with no other option. Same way, wherever the difficulty is implementing the practical things, updating a Minister of Corporate Affairs or brothers and friends. So this only I thought today I should really take it up and take inputs so that I'll also be in a better position to, in future, if opportunity comes, to explain to the authorities. At least we can explain, because this is the issue, omnibus issue faced by all RP and liquidator. It is not the issue faced by one particular company or one particular professional, what we are talking about. So good that we had deliberated. I think we can take some 10 minutes break. Post break session, I wanted to see where it is gelling each other, where there is a connection between the IBC and Companies Act. Let's leave this topic of where there is no disconnection. Where there is a disconnection, let's stop. Enough we discussed. Probably we will all collect our questions and we will request our ICSI IIP to represent. We will try to see post break session where and all the Companies Act and IBC is getting a connection, and where and all the provisions are gelling each other. We will see after 10 minutes. Ma'am, with your permission, can I break for 10 minutes? Madam, are you there? Sister ma'am? Okay, I think madam is not there. Okay, we'll break for 10 minutes. We'll again, we'll continue, we'll resume the session. Thank you. Shall we start?
Sure, sir.
Yeah, ma'am. Now I would like to share my PPT, which in fact we were deliberating other things. Now I think we need to understand what are the things that is interplay between that IBC and Companies Act. So to take you further, of course, this is a PPT which I just prepared for the basic understanding, but the basic idea of this particular PPT is that I wanted to show what exactly the changes that has been picked out in the Companies Act, and because of the introduction of Insolvency Bankruptcy Code, what are the provisions has undergone changes in the Companies Act. Of course, as per the schedule which I am going to take you through. This insolvency, you all know that the implementation of insolvency, and I think I don't want to just to take you through all these routine things. So just a moment, yeah. So these are the routine things that we do, moratorium and managing affairs and duties of all that. Very importantly, I wanted to take you through the changes with this only. I was referring that the duties of RP is very clearly prescribed. Same way, duties of directors also is has been defined under the Companies Act. What are the duties of the directors? The only thing is that cross references is missing. If there's a cross amendment or cross reference or cross application of the provisions, then probably the whole situation would have been taken care by with that notification. This is a resolution plan fast track. I just wanted to take you through the final thing. Yeah. Now coming to the amendment of the Companies Act by IBC, I'm going to take you through the schedule 11. Of course, this exercise you would have done in the beginning itself when the provisions of Companies Act IBC has came into effect, amending the Companies Act. Here, the one particular point I always used to say, why this particular IBC Insolvency Bankruptcy Code 2016, why this has been implemented and introduced as code? Why not act? Can I have inputs of the members? Of course, in the pre-break session, it was very effective interaction by members. Literally, I was happy that more interaction took place and we could able to share our views. This is an opportunity and platform where we can see at least virtually and share our information. Can you tell me that why this is Insolvency Bankruptcy Code? So when you see other enactment in India, okay, like Companies Act 2013, okay, but why that Insolvency Bankruptcy Code alone? Why it should not be an act? Why it should be code? Have you thought of it? What the purpose the government or authorities are trying to achieve by bringing it as a code and not as an act? Any idea about it? Any inputs on this? Yeah, please.
Yeah, sir, when we are when in any act or in any statute, they want to incorporate many or synergize many other acts also. Like only for insolvency bankruptcy code, they want to make the amendments to Companies Act, Income Tax Act, or they are having the impact on other acts also. So rather than the simple act, they are making in a form of code, like single window clearance basically. So that way, rather than putting the act form, they are putting in the form of code.
Yes, Dhanapal ji, it's a complete set of the rules actually. Complete set of the rules to deal a particular issue, right? So that is something is called a code.
Yeah.
Like civil code to deal with a civil kind of the situations in complete, which has overriding effect.
Exactly.
So a complete solution, a complete set of the rules to be codified in a law is called a code.
See, that's what this is what exactly. If more than I am telling the same thing, I thought, okay, participant says that will reach better. See, the idea from, in fact, whenever I get an opportunity to address on code, insolvency code, I always used to highlight this particular point. What? See, if you see in India, now we have Civil Procedure Code and Criminal Procedure Code and insolvency bankruptcy code. Is there any other code in India? There's no other code in India. I don't think so. Okay. So what that civil procedure code addresses, it addresses entire civil matters within the jurisdiction of our, India. Of course, there are many laws applicable, and enforceable, but what this particular civil procedure code and what is the particular criminal procedure code does the job. In fact, it is a guiding force to the entire statute in our country. That's the whole idea of it. In fact, the civil procedure code only, even the Companies Act 2013, certain matters can be dealt with only, with the provisions of the civil procedure code. And certain matters has to be dealt with only with the criminal procedure code. In terms of punishment and all that, criminal jurisdiction under Companies Act 2013, because the definition of fraud has been inbuilt in 447. Now, there are a lot of scope in the Companies Act 2013 where criminal jurisdiction plays vital role. Okay. So therefore, when criminal procedure side of the Companies Act should be dealt with, or any other for this matter, whether it's a Companies Act or any other act for this matter, the entire guiding force or entire guiding light is that only as criminal procedure code in case of criminal side, and the civil procedure code in case of civil side. Suppose a land dispute, a land issue, or any other issue, any rights or anything is violated, all this is certain things comes under the civil procedure code. Means the act is different, but still how the matter should be dealt with is as per the civil procedure code by the courts, right? So same way, the insolvency bankruptcy code, the lawmakers are very clear. Here, only the authorities who are in the enforcement, whether it's income tax authority or GST authority or any other authority for this matter, they only should understand, okay, what is the relevance and what is the importance of INB code. See, INB code, basically why it is not enacted as an act. It can be Insolvency Bankruptcy Code Act 2016. Why not act? Why it should be code? See, this itself shows the supremacy. This itself shows the importance of the law to the entire country. It doesn't require any more explanation to any authority to say IBC is in the upper hand. It has a supremacy with respect to all other enactments in India. So we need not to keep on go and explain section 238 overrides. Need not. In fact, irrespective of that, as a specific provision says that it overrides the entire, notwithstanding anything certain in any other law, it overrides. Irrespective of that, the moment the government, by introducing the particular piece of legislation called Insolvency Bankruptcy Code, they brought it as a code, not as an act, because the code is in a higher orbit than an act. As our friend was sharing also, Mr. Prem Narayan, that the idea of bringing the code is another. Also that in case of an act cannot by default, it will not amend another act. It need a separate parliamentary procedure is being followed in that to amend any piece of legislation in India. So, and by bringing an act, and another act cannot be amended. Whereas the special power is given to the code, whereby, because that's a guiding force, whereby it could amend other enactment by virtue of the introduction of the code in the country. That's why you see the moment the code got implemented, okay, in May 2016 in India, wherein the corresponding 11 enactments stand amended. See, that is the supremacy of the code in India of the Insolvency Bankruptcy Code, INB code, where though we keep explaining to the time and again to the all authorities that the code has got supremacy, it has control. Of course, because of the practical difficulty that RP and liquidator we are facing, because we are given a responsibility of revive the company.
Hello?
Yeah, ma'am, tell me. Ma'am, I think you have to mute, I think. Somebody, yeah. See, we have given a responsibility to revive the company as a RP. We have given a responsibility as a liquidator to maximize the return and maximize the assets and give the maximum distribution to the stakeholder. That is a paramount duty given to the RP and the liquidator. Because The code gives that responsibility to the RP and liquidator to see that the company either is revived or it is sold as a going concern, or if not possible, there is no option is available, then at least assets are sold and with the maximization of the asset, and it is distributed to the maximum to the stakeholder by following the process and provisions as prescribed under section 53 of the INB code. Therefore, the INB code per se says that what is the relevance of by being introduced in our country as in the form of a code, not in the form of the act. So one should appreciate and understand, okay, I'm saying the authority, that why the purpose of bringing the code is that the other enactment should see that insolvency bankruptcy code is a guiding force, a reference for the other acts to be implemented in our country. In fact, it overrides the provisions of entire laws of land. That's what the section 238 of INB code says. So idea of bringing this kind of code is that instead of going into amend, say for example, section 170 of Income Tax Act got amended. Like Companies Act, we are going to see all the provisions what are got amended. Like that, instead of going and amending every act by following a individual and separate parliamentary procedure to amend the law, by bringing a code, the government ensured the entire law amended in tandem at the same time. So that's the intention of the code, bringing it as a insolvency bankruptcy code. Fine. Now, how this, by virtue of this code, how the company has got stood amended, that only our focus is going to be today. Now, Schedule 11 of the IBC, you all know that. By introduction of Schedule 11 of this IBC, the provisions of Companies Act got amended. How it got amended? I want you to take you through. Of course, these things and all we have already, understood, and we started. We are in the phase of implementation. Okay, so I know all by now would have been familiar, but this is just to see that we are all refreshing our memory. We are refreshing our knowledge. Of course, we all must be knowing by now with our own experience that what are the changes that took place and what is the interplay between the Companies Act and IBC. Of course, previous session was really an effective session where literally we deliberated about all what are the difficulties, what are the real issues, where the authorities' attention is required to touch upon the provisions of Companies Act. That's very important. Now we are going to try to understand that what are the areas authorities and the legislator have touched upon and ensure the provisions of the Companies Act stand amended. So by virtue of inserting, for introduction of the INB code, if you see section 2, subsection 23 got amended, whereby it got substituted. That's why I'm telling my idea is not to take you through each and everything, because we all must be by now knowing that what are the today provisions that are available, for the corporate, for the stakeholders under the provisions of Companies Act, and what are the provisions that are available under the Insolvency Bankruptcy Code. But we'll try to recapitulate, try to, recollect what are those things that are brought in by Insolvency and Bankruptcy Code. So what happened by introduction of this section 2, subsection 23, the definition of company liquidator, okay, class 23 got substituted. With that, what is the effect? What was the existing provision? The liquidator can be appointed by tribunal in case of winding up by tribunal, or the company or creditor in case of voluntary winding up. So how it got replaced? Got substituted by virtue of the Insolvency Bankruptcy Code. The liquidator can be appointed only by the tribunal in accordance with the section 275. So this is the amendment that has been brought in section 2, subsection 23. Similar way in same section 2, subsection 94. If you see original thing, what is the real impact? How that Schedule 11 introduce the changes. A new class 94A has been inserted in the Companies Act 2030 to bring the liquidation under IBC 2016. Okay. Now, if you see what was the original section the Companies Act, the winding up was only covered under the Companies Act. There was no other law. As you all know that the Insolvency Bankruptcy Code has subsumed many of the Act also. And of course, you all know that the BAFR Act also has been subsumed, and also Provincial Insolvency Act and Presidential Insolvency Act. Both the enactment has got subsumed by the insolvency bankruptcy code to make sure that why it is subsumed by those code. The reason being the code has been seen as a complete code of our country to address entire financial failure of the country. The idea of bringing the code is not to just to see that a particular aspects of certain aspects alone is taken care of. No, the idea of the government to bring such a wonderful piece of legislation called insolvency bankruptcy code. Though there may be an implementation problem, all this has to be addressed. That's a different story altogether. But the piece, whatever the legislation per se, it's a wonderful piece of legislation, and it gives a complete remedy for the entire financial failures in our country. That's why the government felt that why there should be a different enactment to make sure that there's a single code to avoid duplication. Because of this, no recent as I was referring, the show cause notice are being given. All that this is getting duplicated only. To avoid this duplication only, this particular code has been brought in to see that there should not be a multiple proceeding existing in different forum under different tax for the different purpose. To avoid that only, this particular complete code has been brought in. Okay, the authority or any government body, if they understand the purpose of this law, then they will not trouble liquidator or RP, by issuing show cause notice or by asking the details and by for want of doing assessment that which they ought to have done 8 years back, 10 years back. Now they are trying to do it now when the company is in liquidation. Okay, so RMC they now starting the assessment because the law provides for that. So they are trying to exercise their powers even when company is in CRP or liquidation, irrespective of whatever the results. In fact, the purpose of the code, if the government understands, then they will not repeat this kind of practice, because that is going to duplicate only. It is not going to leave anywhere. Okay, it is only taking away the time of the RP and liquidator. So the idea of bringing that only. So if you see now, by bringing this code, they ensured the Provincial Insolvency Act Protection Act is subsumed by the Insolvency Code. The same way BFR Act also subsumed by the code, and also the provision relating to winding up that was inbuilt in the 2013 Act under section 270. Okay, whatever pertaining to the default by the borrower, that respective portion and SICA portion alone has been removed, plugged out, and has been provided in the Insolvency Bankruptcy Code, and rest of the provision has been retained by the Provisional Companies Act 2013, which we can see in detail. Now, if you see, same way, if the insertion also took place in section 8 and subsection 9. We see the existing provision now, how it got modified. So if you see the there was a rehabilitation and insolvency fund formed under section 269. What happened now that after introduction that got insolvency and bankruptcy fund formed under 224 of the INB Code 2016. Similarly, we see the reduction of capital. If you see section 66 talks about reduction of capital under 1956 Act, it used to be section 100. Now 13 Act, it is section 66. Now, if you see reduction of capital, for the word is unable within the meaning of section 271 subsection 2 to pay the amount of debt claim word. For that word, what it gets substituted. For that word, it got substituted commits default within the meaning of section 6 of the INB Code. So that those kind of failures are taken care of by the provisions of the Insolvency Bankruptcy Code. So therefore, the existing provisions you see before the changes, section 66 subsection 8, that triggers only when the commission of default in payment of debt and claim of a creditor occurs. Okay, but if you see how it got substituted, the word commits default within the meaning of section 6, that is sufficient in respect of amount of is claimed. So that's how it got inserted in section 66 8. So similar way, if you see the duties of registered writers, section 66 and subsection 7, what was the impact given? If you see after the word liquidator has been appointed under this act has been inserted. With that, what kind of changes before the insertion? How it was? Unregistered charges shall not be considered by the liquidator appointed under the Companies Act. Now, same has got changes. Unregistered charges shall not be considered by the liquidator appointed. So wherever Companies Act alone provides for the liquidator, now the liquidator who has been appointed under Insolvency Code also has been added in addition to the liquidator under Companies Act. Similarly, we see the insertion of section 117 of section 3 class F has been modified. How it has been modified? So for the word section 304, the word section 59 has been substituted. What is the impact of it? Which deals with voluntary winding up, which is fully omitted. Okay. Then section 3, so what it was earlier providing existing provision, section 304 provided for circumstances where company can voluntarily wound up. Okay. Now, how it got changed now? The word section 59 stood inserted in section 117 of section 3 of F of Company Act 2013 in place of the word section 304. That was the old section, previous section. Okay, of the Companies Act. Means that has to be changed in tandem with the provision of Companies Act so that section 59 takes care of requirement of the voluntary liquidation of the Companies Act. Similarly, if you see section 224, winding up in pursuance of the inspection report. So here also if you see I have got a 3 PPT. Once I finish this, I will take you through the other aspects of compromise and arrangement, how the Companies Act and Insolvency Code goes in tandem. That's why I'm trying to rush up this so that once I finish this, I'll take you to that compromise and arrangement, how it is possible today, both in Companies Act and IBC Code. And apart from that, I want you to take also what is the interplay between this in cross-border merger and cross-border insolvency. That also I wanted to address. I have a separate PPT for that. So that's the reason I thought I can finish it quickly so that I can move on to next slides. Then we will discuss further. So now, if you see section 224(2), winding up in pursuant to inspection report, as you all know that section 224 provides for winding up pursuant to the inspection report. Now it became Insolvency Bankruptcy Code. Now, when this particular point is coming up, one question is coming to mind. Probably, I think I have an active participant today with me. I thought I can put whether after commencement of CERP or liquidation, what it may be, whether the Ministry of Corporate Affairs has got power to issue show cause notice to initiate inspection investigation under section 206 of the Companies Act. I wanted your inputs. I think your friends can deliberate on this. At least you can share through that so that it will be useful to other friends who are dealing with the matter, who have got the notice, the Ministry of Corporate Affairs. Have you encountered any of such notices? Inspection investigation under section 206 of the Companies Act. When the company is in liquidation or CERP. Have you encountered or have you come across any such situation?
Yes, we have got the notice. I have got the notice in one of the clients.
Is it right?
210, yeah.
Exactly.
Yeah.
See, do they have
Investigation.
power to do inspection investigation when the company is under liquidation? What is the role of the liquidator in that case? Because as one of our friend was telling that the books of account is not accessible. In many of the cases, books of accounts are retained by promoter. Of course, our friends are approaching under section 19 and under regulation 9 of liquidation regulation with the honorable court to get the remedy to hand over all the papers in many of the cases. In that situation, whether the RPR liquidator will be in a position to give all the details to them, or will the detail given will serve the purpose, will do a process? Can they do a complete process with that document which is available without touching upon the promoters? Is it permitted? Let's try to understand this. Is it permitted? Then what extent it is permitted? Inspection, investigation, then can it be investigated?
In my case, the RP has given the statement, whatever document he has got from the promoters or the company, he is giving only that. That's all.
Okay.
Not more than that. But
Okay.
they were not sufficient to conduct the investigation as per the IO.
Okay. In case another question comes here, fine. Whatever the documents RP and liquidator is having, they are submitting it. So first of all, my question, I'll put the question this way. By virtue of the moratorium under section 14 and also moratorium under section 33 of subsection 5 of the Insolvency Bankruptcy Code for in case of liquidation, there was a moratorium wherein no proceeding should be initiated. Whether this 206 inspection or investigation, whether this can be deemed as a proceeding or not for the purpose of those sections, because that is going to end with the show cause notice and action. Otherwise, there is no need for inspection unless it ends with action. Is it a proceeding? In which case, is it not barred under section 14 or section 33 of 5? I just want the inputs only. Let us not jump into conclusion. We'll try to understand. Since it has come, I thought I can check it. Any points? No idea.
So there are two viewpoints on this. If the company is under CIRP, I think they can issue the investigation. They can do the investigation or something. They can give notices.
Okay.
But action, yes, until moratorium is there, the action they may take later or depends on the future of that CIRP.
Okay.
But liquidation, the situation changes when the company is going for a natural death in liquidation.
Yeah, correct.
So there's no sense of serving show cause notice or something like that.
Fine.
That's my view. This is a view.
Yeah, fine. The next point is coming here. After completion of inspection investigation, to whom the show cause notice could be issued based on the documents provided by liquidator or RP, and whether the inspection investigation can be completed and whether show cause notice can be issued to the ex-promoter. Because ultimately the show cause notice has to be issued to the ex-promoters. Right. So
Yeah, they are issuing it, yeah.
Will it be right in law when the document furnished by the liquidator, the document whatever available by the RP and liquidator, those documents are given, right? Unless the promoters are given opportunity or promoters are mandated to give the document, then only the inspection can be complete. So I think in companies at this point also lacks clarity. That's what I wanted to this point to put across to you. The idea why I'm discussing this particular point is that we need to have a clarity on this aspects also. If at all any show cause notice to be issued for violation of the Companies Act during the company, was very operative, during the company was operating. When it comes to CRP or liquidation, of course, CRP is almost like a going concern. So we can't too much stretch. It is almost a going concern. So suppose a company is in liquidation. Okay. Whether the authority for the violation that was rendered by the management, ex-management, the violation carried out by or whatever the violation done by the ex-management, can they issue a show cause notice to the ex-promoter when the company is liquidation? That too after completion of this kind of inspection and investigation. That's a big question. So there should be a clarity in the Companies Act that what could be the recourse or what should be the recourse to the authority or inspector or right from section 206 to section 215, what should be recourse? Of course, section 210, 211, all that about SFIO and powers, all that. So I'm saying including covering their powers during the company, when the company is under CRP liquidation, to what extent the inspection investigation can be carried out, whether by inspector or under the section 211 or 212 of the Companies Act by SFIO, what level, what extent they can go. So that clarity is lagging. In fact, if you see section 212 makes it very clear, the moment SFIO enters into the matter, okay, all investigation irrespective of anything, not only in the Companies Act, for any other act for this purpose, the moment SFIO steps in under section 211, 212 of the Companies Act, all investigation should be handed out to the SFIO. And there should not be any parallel investigation that will be conducted when SFIO is investigating the matter company or under Companies Act. So similar way, some clarity should emerge under the provisions of Companies Act. What should be the legal position when CRP and liquidation comes? What should be the legal position for inspection or issuing a show cause notice or scrutiny, issuing show cause notice, doing investigation and issuing show cause notice and filing a complaint with magistrate court to make sure the punishment for the offence committed prior to the CRP period. That clarity also should emerge. Hope you also agree with me. Okay, so now moving to the next one. So this particular aspect also, there's a gap between the Companies Act and Insolvency Code that we need to understand. With my understanding, I could able to see that a clear gap between Companies Act and IBC with respect to these aspects. So coming to section 230, subsection 1 and 6. Here, this only whole thing, I would say.
Can I question you?
Sorry?
What is your view on this, basically issuing the notice in case of investigation? Because I'm handling one case with a company which is under liquidation, and the IO has given someone to every previous directors, KMPs, CFOs, company secretaries, okay, and the matter is under investigation. Now, what's your view whether they can do or not? What's your view on this?
No, you also given a summon to directors. Are you given a summon?
IO has given someone, na? Investing officer.
No, I'm asking who has given summon to director? You officer.
IO has given. IO has given, na?
Officer. Okay, fine.
Yeah.
So see, here the question here is they have to first of all see the documents under section 206. Then they have to come to 207, 208 and complete their entire process. If need be, they have to seize also under section 209. So all these things should happen step by step, and after exhausting section 206, then 207, then 208. So here, my point was originally that show cause notice, if the authority is having all the details in hand already, then they can very much issue show cause notice to the ex-directors, because it is offense committed prior to the CRP. Okay, but if the authority is not having all documents with them, so they are not in a position to conclude that some violation took place or offense committed by them, then probably if the documents whatever provided by the liquidator and RP, if they are really make out that some offenses took place, then they can issue show cause notice. But if they are having a half detail in hand, I doubt they will not prefer to issue a show cause notice. Even if they issue show cause notice, they can only issue show cause notice asking for further detail which was not given by the liquidator. Okay, so I don't think they can file a directly complaint without completely ensuring that they are satisfied with the records available with them that ex-management has committed a offense or committed a violation. Without that, I don't think it would be proper on their side to file a complaint on them. So if they are very sure, very clear with the records available with them that yes, offense has been committed by ex-management, they can very well issue a show cause notice. I don't think that will, just because of CRP and the commencement of liquidation, the offense whatever committed before the commencement of CRP should be absolved. I don't buy that idea. That should not be the intention of the legislature. If you have a different opinion, the participant can share. The idea here, whatever the violation took place, whatever the offense committed prior to the CRP, I don't think should get absolved. The promoter should not get absolved, ex-promoters or directors who committed the offense, I'm saying. Should not, I don't think they will be absolved from the action or any action against them. Just because of a CRP is initiated or liquidation is complete.
That's the main point.
Sorry?
That's the main point. They cannot be absolved. That's the main point. Yeah.
Yes, offense is an offense. Offense committed is offense. So I don't think insolvency bankruptcy code will be a savior to the management who committed an offense. I don't think so. That should not be the. I don't think that must be the intention of legislator. Probably the law should evolve, and the courts, honorable courts, should come out with the clarity on these aspects also, that what is the legal position for the offence already committed. Because if you see, if it's a running company, if the offence are compoundable, we are going and compounding. Okay, if it's not, offence are not compoundable, then only the matters are getting reaching to the magistrate court by way of a complaint by the authority. So when the company in CRP, the directors cannot go into the compounding. They don't have a power because they have suspended director. Then RP cannot go for compounding for the sake of director. It's not a role of the RP. The RP is supposed to revive it and give to the another management. Probably the other management can approach and go for compounding or whatever they can do. Probably I don't think RP can keep doing for compounding on behalf of director. He can't do that job. Saving the ex-management who was committed an offence by going for compounding. Or if suppose offence is not compoundable, then I don't think during RP can take up all that in hand. So what I'm saying, the RP is given a responsibility of identifying avoidable transaction and approaching honorable adjudicating authority under section 43, 44, 45, 46, 47, section 66. Okay. I think that role, that duty is given on part of the RP and liquidator. And I think here the MCA have to come out to the clarity how they will be dealing with it.
Yeah. There are also clarity required in respect of compounding, as you rightly said. So I think these also some things should be forwarded to the regulators for the clarity.
Exactly. That only I said. In many of the actions of the Companies, out of 470 sections of the Companies Act, at least some 300 sections may need a relook with respect to the IBC code. Fine tune has to be done, or at least some kind of exemption. Or I think one of our friends said, why exemption when companies in ICU? You should completely exempt. So I don't think that it will be practically possible, because we have to manage, balance both the law. So I think some kind of exemption and some kind of relaxation should be given in case of a company under CRP, if the company is under liquidation, not that fully company will be left free. Probably to some extent it should be left free, but not completely. So I think we have to wait and see. And many of the sections of the Companies Act has to be touched. Otherwise, there will not be a complete solution for the company which is undergoing CRP or company which is under liquidation. Now coming back to the our changes, in the took place that in Companies Act. Section 230, if you see, as I was referring, this is the starting point. If you see under section 230 subsection 1, because Honorable NCLAT has took this as a reference. In fact, not some other case, in my own case, where that was the first case where the Honorable NCLAT felt the scheme has to be tried by the liquidator. In fact, that was a detailed judgment given to the liquidator. What are the steps to be taken by the liquidator? So the root cause, the spark has come to the Honorable Court is NCLAT is only this particular portion of section 231, which uses the word, which includes the word liquidator, and there was an amendment made that liquidator is not only a liquidator on the Companies Act, treated under the provisions of the Insolvency and Bankruptcy Code. This only gave a spark in the minds of the honorable members. That why not then scheme is possible under Companies Act when the company is in liquidation, because the section 230 of the Companies Act, when it permits, and required amendment also took place, that liquidator for the purpose under section 230 subsection 1 and also 230 subsection 6, liquidator is only not the liquidator for the purpose of Companies Act. The liquidator, what is contemplated under section 230, is also refers to the liquidator for the purpose of who has been appointed under the Insolvency Bankruptcy Code. This only gave a spark to Honorable Court, which went on to say that when section 230 says liquidator also includes liquidator of the Insolvency Bankruptcy Code, why not scheme is possible under section 230? Then only the Honorable Court gave out order stating that the liquidator is directed to follow the process of coming out of the scheme, inviting a scheme wherein should explore the scheme first, the scheme proposal as a first measure. Then in case of failure, then move on to the liquidation of sale as on a going concern basis. Even that order only talks about going concern. In the very beginning, I'm saying. So here the idea is that by virtue of this amendment in the provision section 230, the liquidator, what originally was contemplated for the purpose of Companies Act, has also given extra cloth to wear, that the liquidator who is referred in 230 is not only that liquidator, also liquidator under INB code is a starting point for us today. Made every liquidator to explore the scheme option under section 2 and 1B of the insolvency regulation, to make sure that liquidator proceeding further first with the scheme option before going into the say liquidation sale. Now coming to section 249(1)(e), similar thing. This is to enable that for removal of the name of the company for the word being wound up, whether voluntary is being wound up under. They changed the chapter 10 because since chapter 20, the responsibility of chapter 20, okay, the legal provisions of chapter 20 has come into the IBC code. Therefore, they thought, okay, no longer it is okay. Since it has come to IBC code, then suitable amendment should be made in section 249(1)(e) also. Then almost 253, 269 fully omitted. You know that the rehabilitation and sick companies, all the provision as completely, as I was referring in my lecture, that it's subsumed by the insolvency bankruptcy code fully. Therefore, all the matters, as you know, that all the matters which were pending before BFR also stood transferred to the adjudicating authority to hear out the matter and to dispose the matter after introduction of the insolvency bankruptcy code. Now coming to section 270, this is very important section 270 under the Companies Act. What is this mode of winding up? Earlier, see, in fact, this fully it is substituted with the the provisions of part 1 shall apply to the winding up company by tribunal under this act. This was the mode. Originally, how it was there in the Companies Act, it was originally there by tribunal, winding up by tribunal, or the voluntary winding up. These two methods were there under 270. But after introduction of insolvency code by virtue of schedule 11 in the insolvency code, what happened in INB code? It replaced saying that the new provision of section 270 that enables only winding up of a company only by the tribunal by bringing out the scope of voluntary winding up outside the purview of Companies Act. That's why today we are doing the voluntary liquidation under section 59 of the insolvency bankruptcy code. Because of this particular amendment took place. Now coming to very important portion of section 271 of the Companies Act 2013. This is very important to note. Originally the 217, if you see section 217, there was a scenario when the company may be wound up by tribunal. Scenario 1, if the company is unable to pay its debt. Scenario 1. Scenario 2, if the company by special resolution passing a special resolution to wind up the company. And scenario 3, if the company has acted against the interest of sovereignty and integrity. Scenario 4, winding up of the company under chapter 19, which is related to BAFR, which we are discussing. As I end this thing, it will be wound up under BAFR. So enabling provision. So, and situation 5, application by registry. Okay, by. Then if you see another point, yeah. Now if you see one more point, just an equitable that the company can be wound up. That's another situation. Just an equitable ground that this company can be wound up. Now, if you see how that existing provision of the Companies Act 2071 stood amended, okay, that stood the changes took place in a manner wherein the provision of specific, that means the circumstances what are specified under class B, company by special resolution, class C, company has acted in the interest of sovereignty and integrity, and E, winding up of company under chapter 19. In fact, this is very important note, class A and D alone has been picked out and brought under the INB code. What is it, class A? If the company is unable to pay its debt, that has been brought out in the in fact, it was carved out from the Companies Act and has been inserted in the Insolvency Bankruptcy Code. Same way, what else? One more thing carved out is that winding up of company under Chapter 19, which pertains to company which ventured into BAFR, which gone into BAFR. So those companies, if it is not getting revived, then there is an enabling provision to wind up the company. Okay, under BAFR provisions. So therefore, if you see, these particular two provisions alone has been brought in by brought in within the scope of the Insolvency Bankruptcy Code. If you see, very simple way to understand this particular amendment, how to in an easy manner to understand. What was the focus of the government? The focus of the government is that, see, any financial failure, okay, any financial failure should be addressed only through this code, only through INB code, not otherwise. Okay, that's the intention of the legislature. That's why they brought this INB code. So what happened out of this sixth ground? With respect to financial failure, is only A and D. Because A is unable to pay debt, D is already become sick. That means financially he is not sound. So this two scenario alone is best suited to carve out and bring into the scope of the Insolvency and Bankruptcy Code. That's how the legislator also has done. So he carved out this A, class A of section 71, class 1D of section 271, carved out from the provisions of section 271 and inserted in the Insolvency and Bankruptcy Code to see that all these financial failures are brought within the scope of the Insolvency Bankruptcy Code, because the entire financial failures is addressed by virtue of the Insolvency Bankruptcy Code incomplete, because they need not to go for any other law or any other remedy to address the financial failure. So that's the reason. At the same time, if there is a violation by the company, okay, and if the company is acting against the interest of sovereignty and integrity, this is nothing to do with the Insolvency Bankruptcy Code. Okay, and the same the application by registrar or tribunal to wound up the company. Suppose they have not filed continuously there is a non-cooperation, they have not filed, then they can struck off also. So what I'm saying, wherever if it is related to financial failure, the legislator is ensured it is brought under INB code. Wherever the government felt that giving the power, what are the powers already given to the authority, means the regulatory authority and tribunal under the existing provision of the Companies Act, that they have not touched upon, because that power anyway they require. Suppose the company completely does not cooperate to the registrar of companies, what will happen? Because registrar company should have some control, that if you don't comply it, then there's an option available under section 271 for me to wind up. At least there's a just and equitable ground is there. So what I'm trying to say here, their authority, whatever the powers given in the hands of authority to wind up the company on the ground other than financial failure is retained in the Companies Act. What are the ground that is pertaining to financial failure that leads to winding up has been carved out from the provisions of Companies Act and brought under the provisions of Insolvency Bankruptcy Code. This is the real changes that took place by virtue of Insolvency Bankruptcy Code. By carving out the provisions of Companies Act, they ensured that all financial failures, all defaults are captured, articulated in the provisions of the Insolvency Bankruptcy Code, so that other regulatory aspects are retained in the Companies Act 2013. So now coming to next 272. Here if you see, who can file a petition? This amendment under section 272. The company, creditor, contributory and all, these are the kind of people who are permitted to file a petition. Now if you see, what are the existing persons specified under class A? Class C, Class E, Class F, and Class G, who were earlier entitled to present petition of the company to be wound up by 271 of 271 Companies Act are permitted to enjoy same privilege. They are permitted to enjoy the same privilege. A, company can file, even it is retained, company can file by passing the resolution, as you all know. The winding up can be initiated by the company. Okay. And a creditor. The only difference is that section 10. See, in case if you want to go for voluntary winding up, okay, section 10 talks about the CERP by corporate. Suppose a company want to go for a voluntary liquidation under section 59, that should not be default. That should not be default done by the promoters management of the company or by the company per se. That should not be default. Then only they are entitled, because that we are declarative solvency should be given for proceeding towards the voluntary liquidation under section 59 of the INB code. But in case of default, what will happen? Suppose there is a default. The management gives up. No, we are not able to go for, we are not in a position to run the company. We accept our default. We are not able to, we are not in a position to settle the money. Then what is the recourse available? Because the section 59 gives remedy only when the company is solvent, not sick. Then only they can go for voluntary liquidation. So thinking that only, the provisions of Companies Act gives powers to the company. By passing resolution, you can initiate a voluntary winding up, not liquidation. There's a subtle difference between the winding up and liquidation. Okay. So under Companies Act, the company by passing resolution can initiate winding up. Under Insolvency Bankruptcy Code, same the case, by passing a resolution, the company can initiate voluntary liquidation. So this is the provision which has been retained in the Companies Act for the companies which are defaulting. Okay, which is defaulted. Section 59 of IBC for the company which has not defaulted and solvent company. So this is a big difference. Therefore, companies permitted, and if you see Class C, because creditor is not permitted. Why creditor not permitted? Anyway, they are given a weapon, say section 7, 8, and 10 under Insolvency Bankruptcy Code to initiate a CRP process. Then why they need a remedy under Provision of Companies Act? They don't need a remedy under Companies Act. So since they have given a very effective weapon under Insolvency Bankruptcy Code under section 7, 9, and 10. Okay. Now next, Class C, contributory. They are given same privilege. They can still file a petition for winding up under Companies Act. Same the case E, the registrar can do. I told you that since whatever the authority powers given to the registrar to initiate winding up, to approach authority, means adjudicating authority for winding up, to approach honorable NCLT for winding up, that is given to the registrar. That is retained. It's not touched. Same way, if you see any person authorized by central government, okay, for him also what are the powers given already, it is retained to the central government also. So therefore, if you see the specified under person specified under Class P of section 272 alone now carved out from section 272 and taken to insolvency provision, Insolvency Bankruptcy Code, to see that he is initiating the process under section 7, section 7, 9, 10. Now moving to next one, section 275, appointment of liquidator. Again, this is another important thing we need to understand. See, if you see here, so appointment of liquidator, if you see the original provision, section 275(2), what it says, appointment of liquidator and permit such appointment only from panel maintained by central government consisting of name of all that. Now, if you see, it is substituted. After Insolvency Code, the Bankruptcy Code has come into effect by virtue of the 11th schedule. The provision has been substituted that section 275(2) is now substituted enabling appointment of liquidator by the tribunal only among the insolvency agency to be constituted under INB code, IBP. Okay, so those are enrolled, registered with the IBP, enrolled with the IPA. They are the liquidator, the court, they have to make sure that the liquidator is appointed only from the list. The tribunal should ensure the appointed liquidator only IP, who is enrolled with IPA and registered with the INB, IBPA. It's a very important thing that we need to understand. Same way, removal of liquidator also, it has been, there's an amendment change that the code, contemplates that establishment of insolvency, bankruptcy, all that you know that. So just to see that there's a separate new set of professionals are introduced to the entire corporate world, to see that entire financial failures are given a special attention focused by that particular set of professionals called insolvency professionals. Now, if you see Section 230 of Companies Act about the jurisdiction of tribunal, okay, originally what it is, any suit proceeding, any claim, any application, all that is covered now. Now see, INB Court, it has introduced changes in a way that any scheme submitted under Section 262 falls outside the purview of tribunal under Section Companies Act. Why it is? Because the entire rehabilitation of the company is omitted. It has been brought under the within the scope and ambit of the insolvency and bankruptcy. Now coming to 289, powers of tribunal on application for stay of finding up. This is fully got omitted, as you know that this is not the requirement in case of, since this amendment has been brought in IBC 2000 changes such a way that the power of tribunal on application for stay of finding up, which now it falls outside the purview of tribunal under company as matter related to that rehabilitation as coming under INB code. Now if you see Section 304 to 323, how it is. Similar way what I was dealing with. This voluntary winding up is fully omitted because the equal provision Section 59 has introduced under the insolvency bankruptcy code that takes care of entire requirement of voluntary liquidation. Now, if you see the application of insolvency rule winding up of insolvent company, that also got fully omitted. Why? The INB code has introduced changes to ensure application of insolvency rules in winding up as per provisions of Section 2 that we come here to for outside of the entire purview related to liquidation, which is covered under IBC. Which is covered under IBC, need not to be part of the provisions of Companies Act. Same way, there is a little very effective change has been brought in whereby Section 326 varying the overriding potential payment. It got fully substituted. You all know. Now we are only giving, distributing. So the law today in INB code mandates the liquidator to distribute, to see that the fund is distributed as per the priority which is provided under Section 53 of the INB code. So this has got a real impact. Earlier, this completely shuffles the priority which is earlier given under Section 326 that got completely shuffled by virtue of introduction of Section 53 under INB code, where you all know that priority to all debts, workman dues and secured creditor, and after that the unsecured creditor, and the waterfall mechanism provided that way that only the insolvency cost and CRP cost and liquidation cost. Then after that, it takes off the secured creditor, then unsecured creditor, then operation creditor, then it flows. As for the waterfall mechanism given under Section 53. That's a very effective change has been brought in by virtue of amendment under the provisions of insolvency code. Same the case, a new clause inserting the provision that Section 326 shall not be applicable in the event of liquidation in Section 327, so that to exclude the complete applicability of the provision of Section 226 and 327 in case company is under liquidation under within the ambit of INB code 2016. Same the case for provisional payment. The equivalent provision has been brought in. The meaning of relevant date also got changed to bring reference to the voluntary winding up under IBC to replace the reference to voluntary winding up under the Provision of Companies Act. So what happened then? Class C to the explanation after subsection 7 of 327 of Companies Act should be altered by virtue of that. Same way, section 329, if you see, now this new section 329 is substituted to replace the present provision of 329. What is that? So any transfer of property, more property, not all these things, if you see, made within a period of 1 year. Today, what we see in section 43, 44, 45, 46, 47, 48. Same similar provision which was there in the winding of 329. So what happened not after introduction of the INB code to replace the reference of voluntary winding up under section 329 under the provision of Companies Act. So accordingly, class C to the explanation after subsection 7 of section 2327, it's to be altered so that the provisions of INB code take control of it. So here, if you see 334, transfer after commencement of winding up to be void, after commencement of to be void, it's fully substituted to remove. What happened? Why INB code has introduced changes to ensure voluntary winding up falls subject. The entire thing pertains to voluntary winding up since it is coming under the territory and domain of the section 59. So whatever the corresponding provision of the Companies Act has to be substituted and to remove it. So that's how the whole amendment relating to voluntary winding up is done. So same thing only, whatever the explanation I gave to the voluntary winding up only, same thing is applicable to these provisions also, voluntary winding up. Wherever voluntary winding up, since the provision of 59 is inbuilt, the requirement of these sections it loses its importance in under the provisions of Companies Act. If you see in this section 370, pending legal proceeding. This is what we were talking about the moratorium. Section 14 of the INB code, same way section 33 subsection 5 of the Insolvency Bankruptcy Code. Wherein if you see INB code 16 has introduced changes to ensure winding up within the purview of section 370 of the Companies Act, this thing, as well as the winding up in accordance with the provision of also covered under section 370. That means the effect is same. So whatever coming under Insolvency Code, the provisions of section 14 and section 33(5) takes care. Whatever winding up comes under the provision of Companies Act 2013, provisions of section 370 take care of it. That's how the clarity has been emerged. Now if you see 372, INB Code 2016 has introduced the changes to ensure the winding up under under the Companies Act, as well winding up under IBC. Both are. So wherever only the winding up under Companies Act, the word under Insolvency Bankruptcy Code also has been introduced. Another importantly, if you see section 419, which talks about benches of tribunal, it has been amended to remove the reference of the rehabilitation of the companies and provide establishment of benches of tribunal to exercise jurisdiction under INB code. This is very important provision which enables to establishment of benches of the tribunal under section 419. So this is the same case for the appellate tribunal 424. Then 429, same the power to seek the assistance under section 429. It is amended to remove the reference to Swiss company, same manner which I explained in connection with seeking assistance of the chief metropolitan magistrate, and to more particularly to amend the reference to bring the reference of INB code. Same the case transfer proceeding. Now all I think earlier there was the exercise was going on of transferring all that. Now all got settled now. Section 468, same the case for reference made to for the voluntary winding up for companies, whether members are by creditor has been removed under subsection 2 of section 468 of the Companies Act. Similar way, if you see schedule 5 in part 2 in section 3, if you see special provisions to pay remuneration up to 2 times of the amount permissible under section 2 in part 2 of schedule is given in case of resolution plan has been approved by the National Company Law Tribunal under insolvency. That enabling provision also has been inbuilt. These are the actual changes which has been brought in. Now I want you to take you through next slide. I think we will, any doubts we will discuss. I'll take you through next slide. I think I know I'm left with the only a few minutes because I'm already cross. I can take another 5-10 minutes, no? With your permission.
Sure, sir.
So I wanted to take you through corporate restructuring and what is the interplay between the Companies Act and the INB code. Okay. So if you see, we all know about corporate restructuring. I need not to too much explain about that. All our practicing professionals who are dealing with that by now. We have come to a stage where settled also in IBC doing corporate restructuring. Earlier, we used to do corporate restructuring schemes, amalgamation, merger only under the position of Companies Act. Now we have settled to the level in under code itself how to do restructuring. That level, the authorities and lawmakers have trained us actually. So I think we need to better understand so that in our implementation we do it in a proper manner. So these are the corporate restructuring thing. All you must be knowing, merger, amalgamation. Now all these things were originally possible only under the provision of Companies Act. So here the learning for us is that what originally was possible only under the Companies Act today made it possible under the provision of Insolvency Bankruptcy Code also. That is the whole idea of bringing this particular presentation before you. So these are the ways how many compromise arrangement can be done, how many ways of corporate restructuring could be done. Okay, merger, amalgamation, acquisition, compromise, arrangement, reconstruction. Not only that, demerger, slum sale, joint venture, strategic alliance, reverse merger, finance section. All this could be done today under Insolvency Bankruptcy Code. Probably the scheme or whatever the scheme applicant submit, it provides for. So it is possible today. So these are the laws which has to be complied with Companies Act, Security Law, Insolvency Law, Pharma Regulator, Income Tax, and Competition Law. These are the authorities, of course, we all know. We have to deal with the RD, ROC, OIL, and Stock Exchange, SEBI, and Income Tax and Competition Commission, all that. So if you see that, what is this? What are the aspects generally involved in that? These are the aspects is generally involved. You must be knowing that. Now, after our Insolvency Code got introduced in 28th May 2016, and we know that the code was providing only to provide a resolution plan in the beginning. Then thereafter, it was only contemplating about a liquidation in case company is not in the result of the resolution plan within 180 days or extended period of 270 days originally. So then, or otherwise, it resort to the liquidation. It ends up the liquidation by virtue of the order of the AA. So that was the original position. Okay. Now, if you see, the position got altered. Okay, that's what we are trying to deliberate. You see section 230, it talks about providing all kind of provisions how the restructuring can be done, all that it is providing. Now, very importantly, how there is a type, means I could say I won't say marriage, it is an alliance between the Companies Act and insolvency with respect to INB code with respect to this particular aspects. Okay, what is this? By introducing a changes in the definition of section 5 of subsection 26 under the heading of plan, it brought out enormous scope and changes. A small correction changes only has been made in the code that completely brought in entire process of section 230 to 235 within the ambit of Insolvency Bankruptcy Code. In fact, the days when we used to handle the schemes and amalgamation under earlier 1956 Act, okay, section 392, section 399 earlier. If you see section 232, 235, the corresponding act provision under section 2013 Act, the entire advantage and the entire privilege, entire benefit, okay, which is given under section 232, 235, has been brought in and extended by amending the provisions of section 5, a definition called resolution plan, by inserting a word that resolution plan may also include provision for restructuring of corporate debtor, including by way of merger, amalgamation, and demerger. My God. So I think fortunately or unfortunately, the word demerger we cannot see anywhere in entire companies. That of course the provisions of section 230 provides for inbuilt enabling demerger. Section 230 read to 232 enable demerger also, but not expressly spelled out that. But if you see here, it says merger, amalgamation, and versus demerger. So by bringing a inclusion, okay, that restructuring by way of all these methods, now the complete scope, complete privilege benefits are completely open now for the companies which are undergoing the CR. Now any resolution applicant need not give resolution plan only on a particular fashion. He can give a resolution plan, either to merge a company, demerge a company, and amalgamate or do any kind of restructuring, and it may include any of these things in the form of a resolution plan. That's an enormous freedom in the hands of the resolution applicant today, after this amendment, to give a resolution plan. So resolution plan, what it can provide for transfer of all or any part of assets. It can also provide for sale of all or parts of the assets. Same way the case, if you see that here, regulation 37 of the insolvency resolution process, that also corporate process regulation 37. If you see the changes here, BA, class BA, restructuring of corporate data by way of merger and amalgamation and demerger has also inserted. Okay, and wherever required, now by virtue of this changes made in resolution plan and regulation 37, that if you see, there is an enormous scope has emerged in the insolvency bankruptcy code itself to see that how a scheme can be contemplated, not only in the Companies Act and also under the insolvency and bankruptcy code. This is the first honorable enclave order in the matter of Binani Industries Limited with the Bank of Baroda, which clarified the objective of the code as under. The first objective of the code is resolution. The second order of objective is maximization of value of assets of the corporate data. And third objective only, it says, is promoting entrepreneurship, availability of credit, and balancing the, as I was referring, the balancing the interest. Now, if you see, another important judgment about Swiss ribbon case. In this, the honorable judges, they made it very clear. The Honorable Supreme Court made very clear that if you see the preamble of the code, the preamble of the INB code, Insolvency Bankruptcy Code, does not provide for liquidation at all. If you can go through the code, you can easily understand. It is not using the word single line about liquidation, single word about liquidation. That's what the observation made by Honorable Supreme Court in Swiss ribbon. Therefore, liquidation should be last resort unless there is no other option. So therefore, the revival is a fundamental objective of the INB code. That's what the point that they conveyed. The another matter which has come out, SC Sarin, Mr. Amit Gupta, here also they were directed liquidator to proceed further in accordance with the law and see the possibility of reviving the company, okay, in terms of section 230. And with the case, I was referring this case only, Honorable Enclat in the matter of Vice Chairman Prasad Saddam. It is my own case where the Honorable Enclat made it very clear the scheme has to be contemplated as part of the liquidation, and they made it a mandate today that every liquidator should take steps to see that they are taking effort first to see that a scheme is contemplated. In the absence of that only, the liquidator has to proceed further with the liquidation process. In this particular judgment, Honorable Enclat said very clearly that we hold the liquidators required to act in terms of aforesaid direction and take steps under section 230 of the Companies Act. If the members of corporate data or other creditor, class of creditor like FC and OC approach the company through liquidator by making proposal to payment to all creditor, liquidator on behalf of the company will move an application under section 230 before AA. Okay, in terms of observation as made in above, on failure as above, the steps should be taken, okay, for outright sale of the corporate data so as to enable the employees of company. So this is what the order passed by the Honorable NCLAT in the matter of Shriram Prasad Mr. Dhanapal. Same the thing has been brought in, and subsequently, Mehal Holmes case also, it also, the Supreme Court held that what is the purpose of the Insolvency Bankruptcy Code and what should happen. Also, it said that the liquidator, should propose, could propose a compromise with the creditor, and he should make sure that efforts is, put in by the liquidator to revive the company. So these are the, ways how the Companies Act has been, brought within the scope of Insolvency Bankruptcy Code to take maximum benefit which are available under the Companies Act to the company. What are the benefits given under Section 232, 235 and the Companies Act to be brought in under the provisions of Insolvency Bankruptcy Code. So after seeing all these orders, Insolvency Bankruptcy Board, they went on to amend, introduce a provision, Class 2B, wherein compromise arrangement, where they made it clear, the regulation they made it clear, where a compromise arrangement is proposed under Section 230, it shall be completed within 90 days under the order of the liquidation under subsection 1 of 33. Time taken on compromise arrangement not exceeding 90 days shall not be included in the liquidation period. So any cost incurred with liquidation in relation to compromise shall be borne by the corporate debtor where such a compromise arrangement is sanctioned by the tribunal. Further, such cost shall be borne by the party who is proposing the compromise where such compromise amendment is not sanctioned under Section 230. So this is a very effective provision which has been introduced after those orders which I was sharing earlier. So after that, this particular provision has literally made a clear connection between the Companies Act as well as Insolvency Bankruptcy Code, wherein the code itself has provided for compromise and arrangements. So these are the permitted cross-border merger which I wanted to discuss. Of course, I have a separate PPT for cross-border merger, how it can take place. Why I am talking about cross-border merger? There is a reason for it. Because it is not that cross-border merger which is contemplated under Companies Act is stopping with that. In fact, you must be knowing the matters. Just a moment. In fact, I wanted to show some of the checklists which was there in my own book. There's a checklist is there, so I thought I can show you. I don't know, time won't permit. So why I wanted to highlight this? Because I have to first take you to down before discussing this. What is that? Right. So this cross-border merger, which is contemplated under the provision of Companies Act, subsequently the RBI also under FEMA, they permitted Section 234 of the Companies Act, Section 234 of the Insolvency Bankruptcy Code. Please note the cross-border merger, Section 234 of Companies Act permits, and same cross-border insolvency, Section 234 of Insolvency Bankruptcy Code permits. So what happened now? When cross-border merger, what is permitted under the provision of Companies Act, as I was referring, Section 232, 235 can be taken, can be drawn for the benefit of Insolvency Bankruptcy Code by the corporate debtor, by the resolution applicant, or by the liquidator. Now the provisions of the benefit of Section 234 also can be taken. How it is? The same thing has been discussed in one of the matter. I wanted to show you that case of in Jet Airways in India, State Bank of India. You must be knowing where there's a Dutch administrator has initiated the matter in Netherlands court. He has initiated the insolvency proceeding against the Jet Airway, wherein he got an order that the Dutch administrator wanted to implement same thing in India. Okay, you want to attach the assets of the Jet Airways of India, but our Honorable Mumbai bench of NCLT has dismissed the matter. They have not considered their plea of the Dutch administrator, saying that there is an absence of provision. But when the Dutch administrator went up on appeal to Honorable Enclat, Honorable Enclat has permitted a continuation of Dutch proceeding alongside with the proceeding in India after securing the cooperation of Dutch bankruptcy administrator. So, pursuant to the direction of the Honorable Enclat, the resolution profession and Dutch administration mutually agreed upon a cross-border insolvency protocol based on 1997 municipal model law has been entered into between the resolution profession and Dutch administrator. So they both together ensured that by virtue of that agreement, they mutually they try to implement both the insolvency proceeding both at the Netherlands as well as in India. That's a real this thing has took place by virtue of the Jet Airways. Clarity has emerged for cross-border insolvency through Jet Airways matter. Even another matter is Videocon matter. In fact, this Jet Airways matter went up and clarified it is possible. Parallel proceeding is possible, and they in fact after that there's a separate insolvency application has also been filed in India in Jet Airways parallelly when this proceeding was going on. So today, when cross-border insolvency also is gaining momentum, that means scope is getting increased. Now we can even think through of cross-border merger also in this kind of cross-border insolvency. So that means we can make use of section 234 of Insolvency Bankruptcy Code and section 234 of the Companies Act 2013. Both work together to see that we are making out a proposal whereby the corporate debtor really benefits by virtue of the cross-border merger through cross-border insolvency option. Same the thing has happened in Videocon industry also. In this matter also, Honorable NCLT has ensured that all the assets, foreign assets of the Videocon should be completely gathered together for the benefit of the entire stakeholders. So this is the important thing which I wanted to cover. So I done with my presentation. If anything, any clarification required, because I already breached 30 minutes of others' time. So I thought I should wind up with this. So if any questions, I'm there to take it and share my views on that. Any questions on this topic? I can take it up. Ma'am, if there's no question, can we conclude?
Sure, sir. I would just request once last that if there is any question amongst the participant, they can ask, sir, or we can conclude the first session.
Fine, ma'am. I think looks like participants are exhausted today. I should not expect any more interaction from them. Good. But there's a very active participation. I was really happy to take today's session. It's very healthy and very meaningful deliberation took place. But it should not stop with the deliberation. It should come into effect. Then only that will be a great help to insolvency professional fraternity, because I know each and every insolvency professional fraternity is struggling a lot to carry out their job properly, to make sure they are complying the provisions of the law. I know, I agree, because I am one among that. Thanks for the opportunity.
Thank you so much, sir.
Dr. Dhanapal, for your wonderful presentation and great deliberations which has taken place. I'm sure ICSI IP has taken note of the many of the inputs which we have gathered today.
Yes.
Right? So let us work together. Let us try to convince the regulators also to understand the difficulties faced by us. We are with them. We also understand their point of view, but things can only move when the kind of contrast we have, it can be resolved.
Absolutely.
Yeah, thank you so much. So we had a great deliberation. Thank you so much. Yeah.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, Mr.
Thanks a lot for this interactive session.
Thanks, ma'am. Thanks for
Have a
the
good day, sir.
Thanks a lot. Thanks a lot.
For the second session, we can have an half an hour break, and then we can start around 1:30. So ma'am has already joined, but she insisted that we should have a half an hour break and then we can start.
Okay.
All right. Thank you so much. Thank you. Good afternoon, ma'am.
Good afternoon, Trishla.
Ma'am, how are you?
Fine.
Ma'am, shall we begin with the session now?
Yeah, sure.
I think it's 1:36, so we can.
Yes.
Good afternoon, everyone. Now I welcome you all to the second half of the session. And in this session, ma'am will be dealing with the interplay of SEBI Act with IBC. I would just briefly introduce ma'am. Ma'am is a qualified company secretary and she graduated, she's also a law graduate from DU. Ma'am is both an insolvency professional as well as a registered valuer. She cleared her exam in the first attempt itself. And ma'am is currently a practicing advocate as well and a frequent speaker in various forums as well as our institute. Ma'am, I welcome you on the behalf of ICSI IIP and you can begin with the session.
Thank you, Trishla.
Welcome.
Thank you. Good afternoon, everyone. I hope you all have joined back after an interactive session of Companies Act with IBC. Can I have a little bit in chat box, Trishla? Are they able to speak or unmute
Yes,
themselves?
no, yes, ma'am. They can unmute themselves.
They can
have
unmute.
allowed, yes.
Okay, fine. So all of you are qualified, all of you are insolvency professional right now. I used to take classes even before you became insolvency professional in ICSI IPA. Yeah. So one of you two might know me if they have taken session from ICSI IPA or in ICSI RVU. Good afternoon, everyone. Let's have an interactive session. Yes. Prem Narayan Tripathi. Yeah. Kamal Ahuja, yes, he IPA, good. So tell me first of all, what you have faced in your practice, if any one of you have come across a case where there is a conflict between the implementation of SEBI with respect to any corporate sector, any corporate debtor undergoing insolvency. Any one of you have any particular case you have noticed? Anyone? Good afternoon, Rajni ji. If you can unmute, you can switch on your videos too. Because then it will be really a good session to interact for. At least I could know with whom I am talking. Isn't it? I won't ask anything, okay? But still, if it's a request, I am waiting. Any one of you who could switch on your videos. Yeah, Rajni ji, good. At least I could see the faces if anyone could. No one interested in switching on videos. My God. Okay, no issues. Let's start with the today's topic, which is.
Madam.
Oh, namaste ji, namaste.
After a long time.
Yes, after a long time. Yeah, Nagesh Babu, I remember.
That's what. Happy to see you, madam.
Yes. When did you qualify?
2 years back only, madam.
2 years back, at the same time.
Oh, same time. And
Wonderful.
subsequently, I qualified for RV also.
RV also, you must have taken classes then, right?
No, I did not take, madam.
Okay. So you are registered for RV?
IP, both IP and RV also.
Okay, great. Wonderful. So how is practice going on?
I'm more into company secretary only, madam, because this all the only I'm giving guidance to my bank, Canara Bank, because they are giving me enrollment for 3 years now.
Wonderful.
Guidance is required for zonal wise. I'm looking after the zonal wise only.
Okay.
Actually, I'm not that much in practice into IP, but still I'm giving guidance to my local branch managers after retirement also.
Wonderful. So that there are various purposes of doing this IP, but still I believe that it's a long journey that we all used to update ourselves and
Definitely.
add on one or the other qualifications, right?
Thank you, madam.
Really happy to see you, Nageshji.
Thank you, madam.
Yeah. Let's start with today's topic is interaction of SEBI Act with IBC. Right? Anyone else who also wish to switch on videos can switch on, please. I'm just sharing the PPT. Purushottam ji, at least switch on the videos. Good. Thank you. I hope PPT is visible.
Yes, ma'am.
Yes, ma'am.
Sure. I just want to convey one thing. When we are speaker at any forum, and you speak also, participants also participate, then it's really fruitful. And it's an inspiration for us also to give whatever knowledge we have regarding the topic. So you are all welcome to interact simultaneously. Today, I am going to take up your session, which is with the topic Interplay of SEBI Act with IBC, which is in the ICSI Institute of Insolvency Professional Workshop. Let's start it. My introduction is being given by Trashla, sorry. Interplay of SEBI Act with IBC is basically when I am talking about that how two acts are interacting with each other. It means I am looking for where they are in harmonization, whether there is any conflict between any particular provision of these two acts, whether they are dealing with the same subject, who is the regulatory authority under both the act, and what are the powers and functions of the regulatory authority in their respective acts. If I am looking for all this, then whatsoever an authority has been vested with the powers and functions, then it has to exercise it. But if it couldn't exercise because of some other act, because of some other law, then conflicts started arising. We have to look for then which act has come before or which is on later on. As far as SEBI Act and IBC are concerned, we are basically concerned with section 28 capital A and 11B of the SEBI Act, which are with an interaction with section 14 of the IBC, section 29 capital A of the IBC, and section 238 of the IBC 2016. Before starting with any particular interplay of the acts, I would like to look into what is the basic objective to be achieved for the enactment of these particular acts. And when we look for it, we always see first in the interpretation of the statutes, preamble of that. Most of you are aware of the preamble of IBC, and we are also aware with the preamble of the SEBI Act 1992, that is the Securities and Exchange Board of India Act. This was an act which was enacted after Harshad Mehta scam, and an act which is to provide for an establishment of a board. See, the preamble itself is providing for this, not only for the establishment of a board, but is also defining what are the roles of the board under the act. If I look for the roles of the board, first is protective role. That is to protect the interest of the investors and in securities. And we look for that in these things, in these matters, SEBI is really aware. There are so many penalties, there are so many punishments that are being implemented. Even the prohibitions are there on the persons who are involved in insider trading or violating other laws or playing fraud with the money of the investors. Next is the promotory role for the development of the securities market, as well as regulating the securities market. When it performs the role of regulating the securities market, it is basically regulating its intermediaries also. Companies also which are taking advantage of listing in the stock exchange, as well as the other matters connected therewith or incidental thereto. When I look for preamble of the IBC, preamble of the IBC is laying down the objective of IBC, that is to reorganize and resolve the insolvency. So we all know the basic objective of the code is not to wind up a company, not to wind up an infrastructure which is already established, but it is to revive an infrastructure, give it in the hands of a new management who could run it efficiently. And all these processes are well time bound with an objective of maximizing the value of the assets of the persons who are involved in these corporate persons. If I look for only the corporate persons, who are stakeholders in corporate persons? If I look for SEBI, SEBI is protecting the interest of the investors. And who are these investors? These are the persons who have invested in these corporate persons, which have undergone in CIRP or undergoing the liquidation. Apart from the objective is to balance the interest of all the stakeholders and to establish an insolvency and bankruptcy board of India. So another regulator is being sought in IBC, which is known by the name of IBBI. We are interacting with now two regulators who are exercising their powers and functions with respect to their own act. How is this IBC linked with SEBI? Preamble itself is linking IBC with SEBI, saying yes, it has to balance the interest of the stakeholders which have one component as an investor in the corporate sector. To begin with, directly going into the code, I came to an interaction with the SEBI Act at the place when I read section 29 capital A, which is dealing with persons who are not eligible to be resolution applicant. Can any one of you tell me how is SEBI Act coming into role when section 29 capital A is there? Is there any mentioning of SEBI Act in section 29 capital A? Any one of you?
I think there's a fit and proper person. I think some concept of fit and proper person is mentioned in this 29A, because once we are conducting that diligence, so there is a requirement. So I think SEBI Act is also saying that he should not be prohibited from dealing in securities market, all these things. So the person who are restrained from dealing in securities market, the same type of person should not come as an applicant for the purpose of resolving that company. So they are actually in line with that also.
Absolutely perfect. One thing is this is particularly mentioned in the section itself. When we are reading the section, it is saying a person shall not be eligible to submit a resolution plan if such person or any other person is acting jointly or in concern with such person. Directly it is saying if it is prohibited by SEBI from trading in securities or accessing the securities market. So if someone is being prohibited under SEBI insider trading regulations, then the person cannot be a resolution applicant. The person could be an individual, it could be a corporate. Now, a person under subclause subsect D is saying that if anyone has been convicted for an offense which is punishable with imprisonment for 2 years or more under any act which is specified under the 12th schedule, and a period of 2 years has not expired from the date of his release from imprisonment, in that case, the person cannot be a resolution applicant. Now, who are the persons? Which are the acts under which this punishment is looked for? 12th schedule, when you look for the 12th schedule, it says that if anyone is punished for 2 years or more under the Securities Contract Regulation Acts, under the SEBI, directly saying if you are punished under the SEBI Act, then you will not be eligible to be a resolution applicant. One is this direct prohibition, other is the prohibition through the Prevention of Money Laundering Act 2002. How is this Prevention of Money Laundering Act dealing with the SEBI particularly? If I look for what is the objective, prevention of money laundering is preventing the money laundering, and it is providing for confiscating the property which is derived from the offense of money laundering. In PMLA, first thing is a scheduled offense should be committed. And from that scheduled offense, something should have been earned, which is known as crime proceeds. And these crime proceeds should be projected as an untainted proceeds for constituting the offense of money laundering. So what PMLA is prohibiting is this conversion of money laundering. And what are these scheduled offenses? For which offense, if you commit and earn something, are classified as crime proceeds in the PMLA. PMLA paragraph 1 says that if somebody has committed an offense under section 12 capital A read with section 24 of SEBI Act, then and he is earning something which is crime proceeds and trying to convert into legal money, then we call it as a scheduled offense under PMLA. So if anyone has committed a scheduled offense in SEBI, then again he is not eligible to submit the resolution plan as per the clause D falling under PMLA. So what are these 12A? They are saying that if anybody is committing an offense of insider trading using manipulative or deceptive devices, or substantially acquiring a control in a company without following the provisions of the SEBI substantial acquisition regulation, in that case, the person is said to have committed a scheduled offense falling under PMLA and therefore is debarred under section 29 capital A2. So directly and indirectly, why they have taken it like so seriously? Can anybody tell me why is this SEBI taken so seriously? Because this is a hub where the people are committing the offenses of defrauding with the money of the investors. And the purpose is of both the IBC as well as the SEBI. SEBI directly and IBC indirectly is to protect the interest of investors. So anyone who is committed on an offense which is related to purchase or sale of securities through deceptive devices, through fraudulent techniques, or he is engaged in any practice which is constituting a fraud in public or insider trading, or he is communicating sensitive information to others, then he will be subject to punishment under SEBI Act, which is saying that without prejudice to any award, if any person contravenes or attempts to contravene the Act, SEBI Act or rules or regulations, then he shall be punished with the imprisonment of 10 years or with fine of 25 crore or both. And if he fails to pay this penalty, then he shall be again eligible for a punishment for a term from 1 month to 10 years or with fine of 25 crore. So apart from SEBI, this person would not be eligible under IBC to submit the resolution plan. Now comes, this was one part which is saying that, okay, if you are a culprit in SEBI Act, you cannot be a person who can come in IBC and try to take an infrastructure, a corporate debtor undergoing CIRP. No, according to us, you are financially not sound, you are not a fit and proper person, so you are not allowed in section 29 capital A. Now, how is IBC interplaying with the SEBI's recovery powers? What are the powers of the SEBI? Powers of the SEBI as a market regulator under the SEBI Act with IBC is insofar when they are clashing, because there are non-obstant clauses in both the Act as well as the Code, which are competing with each other. And because of the non-obstant clause of IBC, SEBI's power of enforcing recovery is now questioned. They are not able to enforce their recovery power. When the SEBI was invented, we all know that it was an era which recognized an introduction of creditor in control regime. The most important, the role that is being played in IBC is of section 14, and this section 14 is supported by section 238. As soon as an application of any application with respect to any corporate debtor is admitted by NCLT or the adjudicating authority, there are three things that are being done. First thing is the moratorium, appointment of insolvency resolution professional, and a public announcement. Moratorium means prohibiting the institution of suits. First of all, if some dispute is there and moratorium is declared, then one cannot go and institute a suit against the corporate debtor. Second prohibition is continuation of pending suits. It means if any suit is pending before any adjudicating authority, court of law, or tribunal, then the same cannot be continued, provided the both are suits as well as the proceedings are against the corporate debtor. Not only this, apart from that, no judgment, no decree, no order of such court of law, tribunal, or arbitral panel could be even executed. Simultaneously, corporate debtor is prohibited from transferring, alienating, or encumbering or disposing of its assets or any legal right or beneficial interest therein. Only essential goods or services are allowed to be supplied during moratorium period. And if government wish, it can, in consultation with any financial regulator or any other authority, including SEBI, can say, okay, for these transactions, moratorium is not applicable. The order of moratorium has a life. What is the life of this moratorium? It starts from the date when CIRP commences. That is the date when application for CIRP is admitted by adjudicating authority. And it ends till the CIRP is completed, that is 180 days or 270 days or 330 days as far as normal CIRP process is concerned, or at any time during the CIRP, if the adjudicating authority approves the resolution plan under subsection 1 of section 31 or pass an order for liquidation of corporate debtor under section 33, moratorium will cease to have an effect. It means moratorium has a life starting from CIRP till completion of CIRP. But if in between A approves the resolution plan or passes an liquidation order, the moment the resolution plan is approved or liquidation order is passed, moratorium shall means mandatorily it should cease to have an existence. Once the moratorium prohibition is lifted up, now can anybody proceed with the suit or proceedings against the corporate debtor? So what it is saying, once the moratorium kicks in, corporate debtor is shielded from other proceedings. This is what everybody is interpreting. That once a moratorium is kicks in, the corporate debtor is shielded from other proceedings, including recovery proceedings, as well as any other proceedings before a court of law, tribunal, or any other authority. When section 38 is read with it, that is the non-obstant provision, says that IBC holds priority over other laws. It has an overriding effect over them if they are inconsistent. Underline the word that if other laws are inconsistent with IBC provisions, then IBC provisions would prevail. Moratorium is assuming a considerable legal significance, as it in India there are so many laws which are working. We are working in a multi-regulatory environment where there are more than one regulatory authorities. Then moratorium is giving a power to IBBI, but if it is conflicting with the role of other regulatory authority, whether it be the SEBI, whether it be the ED under PMLA or under income tax, everywhere it is presumed under section 238 that IBC would prevail. Even when Insolvency Law Committee looked for it in 2018 in its reports, it specifically gives an observation with respect to section 14 of dealing with moratorium, that why the mere determination of the amount may not have been the intent of the code. It may not be prudent to provide explicit carve out from section 14 with on-ground evidence at this stage. So what this committee observed, that what the section 14 is envisaging. Section 14 is saying that you cannot enforce any recovery proceedings. And they are saying we cannot provide any exception to this section 14 right now. Even in 22, when Insolvency Law Committee submit a report, it said, stipulated that there is no requirement to introduce any exception to the process of moratorium. So till now, ILC is not ready to accept and to give any particular exception where moratorium would not apply. Now this section 238 is having a non-obstant clause, is conflicting with the SEBI's recovery power. What are these powers of SEBI recovery? They are mentioned in section 28 capital A. If we look for the SEBI Act, section 11 capital A of the SEBI is giving power to the SEBI that to protect the interest of the investors, SEBI is empowered to specify the regulations with respect to issue of capital, transfer of securities and other matters incidental thereto, as well as the manner in which the matters to be disclosed by the company. And they shall be, means it is mandatory for the companies to make the disclosures specified by SEBI, otherwise SEBI is empowered to levy penalty on the companies. In fact, by general or special orders, it may prohibit any company from issuing prospectus or any offer document or advertisements from soliciting money from the public. It may specify the conditions subject to which money could be raised from the public by issue of securities through prospectus, offer document or advertisement. When we look for 11B, 11B is a power, it is giving a power to the SEBI for recovery. What it is saying, that whenever SEBI feels, whenever it is after an inquiry, SEBI is satisfied that in the interest of investors or for the orderly development of security market, or to prevent the affairs of intermediary which are detrimental to the interests of the investors, or to secure proper management, that is for the investors' protections, for development of securities, for regulating the role of intermediaries, for the proper management of intermediaries, SEBI is empowered to issue some directions. And in these directions, one of the direction is that it can direct the company with respect to the matters which are stated here, that is with respect to the matters dealing with the raising of money from the public, as may be appropriate in the interest of the investors in the securities and the securities market. Simultaneously, it is having an explanation that SEBI's empowered to issue direction shall include and always deem to include the power to direct the person who has made profit or averted losses by indulging in the transaction or activity in contravention of the provisions of the Act, regulations made therein, to disgorge an amount equivalent to the wrongful gain made or loss averted by such contravention. What does it mean? That whenever SEBI is giving any direction to any company with respect to the matters of the issue of the prospectus or dealing with the transfer of securities or matters of disclosure, it can also direct a person who has made wrongful gain by contravening the provisions of the Act or regulation, that you return back the money that you have illegally earned. You return back the money that you have illegally earned from the contravention of the provisions of the Act or regulation. This is the main power which SEBI is now not able to implement in case the company is admitted for CIRP. This is where judicially there are some cases where they are going positive in favor of SEBI. There are some judicial pronouncements which are going in favor of IBC, but till let's see, let's go through the journey of those judicial pronouncements. Section 28 capital A. Before going into that, let's understand what is the Section 28 capital A, which is now much in news. Section 28 capital A is giving SEBI's enforcement power meaningful and empowered to recover dues from defaulters. What was happening before 2014 that SEBI was able to unearth scam. It was able to impose the penalties, giving the disgorgement orders that return back the wrongful gain you have made. But if the orders are not followed, SEBI was not having any power to recover straight. It has to look for other courts, basically the High Court's assistance for the recovery process. Here then the discussion was there. And then in 2014, this Section 28 capital A was introduced, which is saying Section 11B is SEBI's trusted Brahmastra, in which SEBI is taking action in the market that whatever illegal gains you have made, refund it to the investors. That is where SEBI's recovery power is. Section 28 capital A is giving the means of recovering the orders given under Section 11B. Let's go through what it is. The genesis of this Section 28 capital A was discussed in depth on June 16, 2020 in a committee which was constituted by the SEBI under the chairmanship of Justice Anil Ardave, and the title was Measures for Strengthening the Enforcement Mechanism of the Board and Incidental Issues. The objective was that SEBI has power. Okay, it can levy penalty, it can levy the, it can give the order to return back the money, but it is not armed with the power to recover, just like income tax tribunal can recover, just like civil court can give the directions to recover. SEBI did not have the power to recover the amounts due. The absence of recovery power basically jeopardized its ability to recover unpaid penalties. The committee said that many orders directing disgorgement in the IPO scam were not complied with. What was the option available? That file prosecution in criminal court, or it can maximum impose that, okay, for this much time period, you will not be allowed to, you are prohibited from transacting in the securities market. Though they were meant to act as a deterrent, but SEBI was not able to recover the unpaid amount from the violators. Instead, it has to incur huge cost for conducting all these proceedings. When this was realized, SEBI discussed it with the central government, an amendment was sought to empower it to recover unpaid monies due in line with the provisions of income tax. So SEBI says, okay, the way the IT Appellate Tribunal has the power to recover the money dues, the IT Act is giving the power to its adjudicating officer to recover the penalty which is not being paid by the defaulter. We should also be given the power. This power was being given by an ordinance through intersection of section 28 capital A. So, and the similar power were there in the SCRA, Securities Contract Regulation Act, and the Depository Act to provide SEBI with power to recover the amount dues. So section 28 capital A was not there initially in the Act. It came through an ordinance in 2013. And then again with an ordinance, and then it became a part of the Act itself. The object and reason specifically says that now the purpose why the section 28 capital A was inserted is to empower the recovery officer to recover the amount against the person who failed to comply with the direction of the board for refund of money or with the direction of disgorgement issued under section 11B or failed to pay any fee due to the board. So that power was being given just like given in the Income Tax Act. And then further a note was given which says, what is the meaning of recovery power? Giving it to the board. It means now you don't need assistance of any other legal forum for recovering the money that is being given by you in your order to be paid by the defaulters. They are saying for that you can attach the movable as well as immovable property of the defaulter. Simultaneously, you can sell them. We all know that if we look for the Transfer of Property Act also, even if there is a mortgage of a property, what was happening earlier, that the lender was not able to recover the money because it has to knock down the doors of the court or then the DRT tribunal that gave me an order to recover the money by selling this property. But they are saying now, SEBI need not go to have recourse to any court of law. Just recollect it how it is going to conflict with the corporate debtor who is undergoing CIRP. That SEBI is having a power to take the property of the defaulter and sell it without any permission anywhere. And it can even attach the bank accounts of defaulters. In case a person fails to pay the penalty which is imposed by the adjudicating officer or fails to comply with any direction of the board for refund of money or with the disgorgement order which is issued under section 11 capital B, or where a person defaulter fails to pay even a fee due to the board. So for all these four causes, SEBI has a power to recover without assistance of any court of law. This is where the penalty is imposed, and if the directions are not complied with or there is a default in the payment of fee to the board. What are the powers? Attachment and sale of the defaulter's movable property. Even they can seize defaulter's bank account. They can attach and sell defaulter's immovable property. Defaulter can be arrested and he can be detained in prison. A receiver can be appointed for the management of the defaulter's movable and immovable properties. Right? Subsection 3 of section 28A is a non-obstant clause, which is saying recovery of the amounts by a recovery officer pursuant to a non-compliance with the direction issued by the board under section 11B. Means if the board has given a disgorgement order under section 11B and the defaulter has not deposited the undue illegal gains made by him, then whatever will be the recovery order given by the recovery officer, it will prevail. It shall, word used is, it shall have precedence over any other claim against such person. Now, this is a non-obstant clause which is giving an absolute power to the SEBI. SEBI report has rightly affirmed that there exists no bar on this SEBI report has also rightly affirmed one more thing, that when a CIRP, when a corporate debtor is being admitted during the CIRP, what is prohibited? Is determination of the default amount prohibited, or is taking proceeding against the corporate debtor prohibited? There are two things. One, whether we can determine the liability even if the CIRP is undergoing, even if a corporate debtor is undergoing CIRP, or we cannot take any proceedings against the corporate debtor. SEBI report said that it has relied on the report of ILC, and which is stated in unambiguous term that a moratorium under the IBC did not bar any proceedings which is concerned only with the determination of liability of the corporate debtor. The same was affirmed by SEBI in its reports that there exists no bar on determining the liability of a corporate debtor during corporate insolvency resolution process under the scheme of Section 14 of the IBC. Now, let's discuss the conflict that is going on between the two sections, Section 238 and Section 238 read with Section 14 of the Code, and Section 28A of the SEBI Act, which is dealing with the recovery power of SEBI. SEBI's authority is to recover the money that is given under subsection 3 of Section 28A, and the conflict is with the moratorium provision of IBC, which is saying, I am here, so everybody is prohibited from directly taking action against corporate debt. Now, question, what is the question? Which law? Whether SEBI recovery power will prevail or IBC would prevail, which authority would be given the priority, which non-obstant provision would prevail, because recovery is subject to Section 238 of IBC, which is saying that the provisions of IBC shall prevail over any other law inconsistent with any of its provisions. Now, the relevant question here is whether, we will say that the code itself is very clear, everything is clear, then why these judicial cases are coming again and again? They are coming because still they are not clear with the point, and SEBI is enforcing that my authority is given, I have recovery power, it should not be overshadowed by Section 238 non-obstant clause. That's why SEBI is issuing the recovery order. Now, in this battle of the non-obstant, what is the general presumption? We have looked for many of the cases which are going in PMLA, many of the cases going in RERA, under the income tax. They are in conflict because corporate debtor has undergone CIRP, and now even these government authorities are having the issues that they are not able to recover their dues, though they are being given power under their respective act. So how this court could take their recovery power? What was being held in PMLA by the Supreme Court? Supreme Court has clearly given one particular thing, that in Solitaire India Limited versus Fair Growth Financial Services Private Limited, Supreme Court has held that where two special statutes contain non-obstant clauses, the later statute would prevail over the former. Why? Why would always later statute prevail? Because it is presumed that at the time when the later law was being drafted, the legislature were aware of the non-obstant clause in the earlier law. They knew that the previous acts enacted have their non-obstant clause. Still, they have given this non-obstant clause in IBC What is the purpose behind it? Purpose behind it, we are aware of the previous, but now this non-obstant clause in later law means we intends to override the non-obstant clause of the earlier law. As far as that IBC is concerned, IBC was enacted in 2016, while PMLA in 2002. Therefore, they say, okay, the issue is coming to a logical end, and IBC code would prevail over PMLA. The same concept is being followed even if Income Tax Act is concerned, even if Customs Act is concerned, or even if PMLA is there, means any recovery mechanism in anywhere, though the acts are enacted by the same legislature, but still IBC is being given preference over all other previous acts. If we go through the judgments, we will see that how they are, there is not clarity, particularly with respect to it. Supreme Court has given one particular judgment when the two statutes are not consistent. What should be the test that yes, which one should override? This was given by Supreme Court in Kishore Bhai Goyal versus State of Gujarat. We will read it in a particular judgment also, that you should go for the three tests. The first test is whether there is a direct conflict between the two provisions, whether the legislature intends to lay down an exhaustive code, whether with the intention of the legislature is yes, now the new code is there, new act is there, so all the earlier laws which are dealing with the same subject matter, they should be replaced. Is this the intention of legislature behind enacting the new code, the later code? Or whether the two laws are occupying the same field, whether exactly they are working in the same field, because my interpretation of statute says we should follow the rule of harmonization. To the extent we could harmonize and read the provisions of two laws, we should read it together. So this was the three tests that was being laid by the Supreme Court in Kishore Bhai Goyal versus State of Gujarat. Now the jurisprudential journey so far. In section 14 has a word that proceedings or any suit you cannot institute even before a court, tribunal or any other authority. So now the question is, what is the meaning of this other authority? How are you going to interpret the word other authority? Is this word other authority phrase used in section 14 applicable to SEBI? Is SEBI coming within the purview of this other authority? And that's why DBAR is prohibited under section 14 from initiating any proceedings against the corporate debtor which has been admitted for CIRP. A very well-known case which is aptly laid down the provisions for particularly with respect to powers of SEBI, enforcement powers of SEBI. This is with Anju Agarwal RP versus Bombay Stock Exchange. The RP for Shri Bhavna Paper Mills Limited, the corporate debtor was the CIRP was passed by the adjudicating authority, that is NCLT Allahabad bench, where the adjudicating authority held that regulatory authorities are not covered under the moratorium. See, what is conflict is that various tribunals, various forums holding different opinion for the same concept. Which one is going to be final? No one knows. Every judiciary has its own interpretation. That's why NCLT Ahmedabad held this other authority word does not include regulatory authorities. So moratorium is not applicable with respect to proceedings of regulatory authority. And it clarified as follows. The words that are being used with respect to section 14 is that section 10 application was admitted on the application of the corporate applicant, that is corporate debtor. And now he seeks exemptions from statutory compliances as required by the Stock Exchange, Central Depository Services India, and National Security Depository Services India Limited. It is pertinent to mention that in section 14, it is specifically mentioned that what are the areas where the order of moratorium shall be effective. It is holding regulatory authorities are not covered under the moratorium order as provided under section 14 of the IB Code. Given the moratorium issued under section 14 of the IB Code, regulatory authorities are not debarred from enforcing the regulations which are prescribed under their rules of the Bombay Stock Exchange, SEBI LODR regulations, or CDSL and NSDL India Limited are not debarred from compelling the corporate debtor company to comply with the regulations. So they are saying once a corporate debtor is admitted to CIRP and moratorium is declared, it does not mean that it has not to comply with SEBI LODR regulations requiring the corporate debtor to make appropriate disclosures under the regulations to the stock exchange at the regular interval of time that is being specified. Even they have to follow the instructions and the directions of their CDSL as well as NSDL. It is nowhere prohibited. Section 14 is not applicable for them that they cannot give any particular direction. What happened before neglect? The same order was being appealed. They said that section 14(1)(a) of the IBC is also applicable to the provision of SEBI. Now, when the SEBI went to the neglect, Bombay Stock Exchange went to neglect, it says the appellant said this RP appellant appearing for the corporate debtor submitted that section 14(1)(a) of the IB Code is also applicable to the provisions of SEBI regulations, LODR, during the moratorium period. That's why no compliance of the regulation is required. They say there is no need to submit the audited accounts of the company. There is no need to submit any quarterly disclosure. There is no need to submit any particular event that is happening in the corporate debtor, and that is to be reported to the stock exchange. It is alleged that respondent Bombay Stock Exchange has threatened suspension of trading. One thing what they argued is no need to follow any regulations in SEBI LODR. Second thing they argued was that the respondent Bombay Stock Exchange threatened suspension of trading of shares of the CD, which is against the provision of section 14 of the IB Code. So now next was that Bombay Stock Exchange has no jurisdiction to suspend trading of shares of the corporate debtor, which is admitted to CIRP, though corporate debtor is not following any regulations, but you cannot suspend the trading, nor can impose penalty because it is clearly prohibited under section 14 of the IB Code. Third, they brought into pick section 238, which says that IB Code will have an overriding effect upon the provisions of the SEBI LODR regulation. They place reliance on the decision of Honorable Supreme Court in Innovative Industries Limited versus ICICI Bank. That was the case that was discussed at length, which is discussed at length, the objective of the code, everything was discussed at length. And it was held by the Honorable Supreme Court that any proceeding under any law against the corporate debtor cannot be proceeded once moratorium is in effect. So what was their argument? No need to follow SEBI LODR regulations. Stock exchange cannot suspend the shares, trading in the shares. No penalty can be levied during moratorium for non-compliance of the regulations, SEBI regulations. They were there. Now, what was the argument that were given by the SEBI and the stock exchange referring to? They refer to sections. One is section 14, other is section 17 to subclause E of the IB code. They said that section 14 is not applicable, nor to the SEBI or to the Bombay Stock Exchange, and that's why they cannot be prohibited for taking action in terms of the SEBI Act and regulations framed there. Reliance was placed on section 28A capital A subsection 3 of the SEBI Act to suggest that the said provision will prevail over the IB code. Referring to the decision of High Court of Honorable High Court of Delhi in a criminal appeal, it is submitted that offender of ill-gotten asset shall not be perceived to be sharing the loot. The one who has performed an illegal act, he has gotten asset through the illegal means, he is sharing the loot of the breaking the provisions of the law, he cannot be allowed to take the benefit of the provisions of section 14. That were the arguments that were being before NICLAT. Now, NICLAT gives an observation. It read section 14(1) clause A, saying that on the IC date, when adjudicating authority declare, it prohibits this again, the institution suits, pending suits, proceedings, which are going up here before any court of law, tribunal, arbitration panel, or other authority. Then they look for section 17, which is dealing with the management of affairs of the corporate debtor by interim resolution professional. They said that subsection 2 of section 17 is empowering the interim resolution professional to act. What is this? It is saying that from the date IRP is appointed, he shall vest, the management of the affairs of the CD shall vest in the interim resolution professional. So when the management is vesting in IRP and subsequently in resolution professional, what does it mean? It means that they have to comply the laws. They have to comply the regulations. IRP, this is further given in subsection 2 of section 17 that interim resolution professional who is vested with the management of the corporate debtor shall be responsible for complying with the requirements under any law for the time being in force on behalf of the corporate debtor. So what does NICLAT conclude? It concluded that the interim resolution professional is responsible for complying with the requirements under any law for the time being in force on behalf of the corporate debtor. It means even it includes SEBI Act 1992, SEBI LODR regulations framed therein. So it is the duty of IRP to fulfill the requirement of the SEBI Act as well as SEBI LODR during the moratorium period. Now the question arises for consideration is, if he fails, if IRP fails to perform the duties and penal order is passed by, can penal order be passed for imposing the penalty on corporate debtor, or any recovery can be made in terms of section 28 capital A of the SEBI Act? NICLAT observed that, okay, IRP is responsible. What happens if he fails? If he fails, will a penalty be imposed on the corporate debtor? Or SEBI itself can take the recovery power and attach the accounts of the corporate debtor, or can attach and sell its movable or immovable properties? Because it doesn't need the assistance of any other court of law pursuant to section 28 capital A. Now the learned as the SEBI and the Bombay Stock Exchange section, they are saying that our section 28A will have overriding effect on the provisions of section 14 of the IB code. But this submission cannot be accepted. They said that the submission that section 28 capital A will override IBC code will not be accepted. Why? Again saying that defining section 14(1)(a), then section 28A, and then section 238 was being again analyzed by it in the reasons. And then they said, they came to a conclusion that section 28 capital A of the SEBI Act is inconsistent with section 14 of the IB Code. What was held that they being inconsistent with section 14 of the IB Code, it was being held that section 14 of the IB Code will prevail over section 28 capital A of the SEBI Act, as well as SEBI cannot recover the amount including the penalty from the corporate debtor. And same is for the Bombay Stock Exchange. It cannot take any coercive step against the corporate debtor, and nor can it threaten the corporate debtor for suspension of trading of shares. So what is the crux being held from here? Once CIRP is there, once moratorium is announced, IRP or RP has to perform the duties which of fulfilling the requirement of the regulations. But if they fail, but if he or it's an entity fails to do the same, even then SEBI cannot exercise its recovery power. It cannot impose any penalty. Even the stock exchange cannot delist the securities of the corporate debtor. Nothing like can take place. So it's just purely corporate debtor is protected from all sides pursuant to section 14 when you read it with section 238. Now, what would happen? They said Bombay Stock Exchange, why they are saying that Bombay Stock Exchange cannot delist the securities, even though there is a failure on part of IRP to fulfill the regulation. They say the shares of the corporate debtor, if listed with the Bombay Stock Exchange, can be dealt with by Bombay Stock Exchange. But if you look for section 18 of the code, the interim resolution professional, while taking control and custody of the assets, including tangible and intangible assets, he is empowered to take custody, but he is not empowered to sell them. He is empowered to have control, to collect all the assets of the corporate debtor, but he is not empowered to sell them. It's COC, which is an authority to decide for everything. His role is to collect the resources, and he cannot sell the shares of the corporate debtor during the period of moratorium. If some assets, including shares, are to be sold, the provisions of IB Code have to be followed. Committee of creditors approval is required. Therefore, dealing with the shares of the corporate debtor by the Bombay Stock Exchange during the period of moratorium normally does not arise. That's why Bombay Stock Exchange cannot delist them. The shares can be transferred, as in case of CIRP, only in the manner prescribed under the IB Code, SEBI Act, and the Companies Act. That's why it cannot be suspended or delisted. Now, what would happen to the penalty for non-compliance? Non-compliance is there, it is admitted. Penalty can be levied, okay. But how you are going to recover the same? Do you have a part to attach the assets and sell them? Do you have a part to attach the bank account? They said that the case that was taken into account was Director of Income Tax versus Synergis Dure Automotive Limited, in which it was held that the statutory dues, whether due to the central government or to the state government, arising under any law for the time being in force and payable, come within the meaning of operational debt. So if any penalty is imposed or any amount is payable to SEBI, it may claim as an operational creditor, but cannot recover the same during the resolution process. That was in this way, they have modified the order of the NCLT and outrightly saying, yes, IBC code would prevail. SEBI, IRP, it's the duty of the IRP to comply with the regulations and the requirements of the other laws which are applicable to the corporate debtor. But if he fails, you cannot take any action. You cannot levy the penalty. You cannot enforce the recovery mechanism. you can come as an operational creditor in line. And now file your claim to recover your penalty as an operational creditor. The same view was held in PMLA also. ED can claim as an operational creditor, but it cannot attach the assets of the corporate debtor. The assets of the corporate debtor has to be returned back to the corporate debtor. The same when it was the case of Bhanuram and others versus HBN Dairies and Elliott Limited. This view then was echoed by NCLT in Bhanuram's case, which was concerned with SEBI's attachment of properties of HBN Dairies. SEBI had earlier held that HBN Dairies is in violation of the SEBI Act and rules in relation to collective investment schemes. HBN Dairies has launched a scheme so that in which it was collecting the money from the investors, and it was a kind of Ponzi scheme that was not registered with SEBI, and it was totally in violation of SEBI regulations. So SEBI had given an order for refund of money to the investors. Next, NCLT held that since the provisions of the SEBI Act were in conflict with the IBC, the omnibus provisions of section 14 of the IBC would eclipse SEBI's power and nullify its actions of recovery by virtue of section 238 of the IBC. So what is the message going? That you commit the fraud, and then if at the instance you are admitted into CIRP, then whatever the fraud is being done in the name of the corporate debtor, it can no other regulatory authority can take the action because of the section 14 and section 238 of IBC. Where properties of the corporate debtors were attached by SEBI, NCLT absorbed that it is the statutory duty which is imposed on the interim resolution professional that he has to run the affairs of the corporate debtor on a day-to-day basis. We know that IRP is vested, IRP has to fulfill the obligation to run the corporate debtor as a going concern. And for that, he will need the property of the corporate debtor. So NCLT overruled the decision which is given by the Securities Appellate Tribunal and ordered SEBI to deattach the properties of the corporate debtor, even if such attachment order was issued prior to initiation of the moratorium. See, what is the effect IBC giving? IBC is saying, okay, you have played fraud, you are directed to refund the money of the investors, and the SEBI has enforced its recovery mechanism and attached your property. But after that, even if you are admitted to CIRP, the same property will be deattached, and this has to be handed over to the corporate debtor. Whatever is your claim, submit it as an operational creditor. That is what is the view held till now. Now, SEBI filed an appeal against this order before the Supreme Court. By an order dated 17th June 2019, Supreme Court, though granted a stay on NCLT decision, it has granted a stay on NCLT decision, but it mandated that SEBI shall hand over the title deed. It said, okay, don't return back the property that has been attached, but hand over the title deeds so that you cannot create any encumbrance, you cannot sell the property. Attachment is okay, but till now the order is saying that SEBI cannot dispose of those assets that are being attached by him. This is the only order which is till now passed by the Supreme Court in a case where the conflicting provisions of IBC and SEBI are coming into picture. What is the stand of Supreme Court as far as this section 14 is concerned? We have seen in IB Innovative Industries, it has held that section 238 would override all other laws which are inconsistent. Supreme Court, while adjudging a conflict between Maharashtra Housing Area Development and IBC, Supreme Court in Rajendra Bhutta case versus Maharashtra Housing Development Authority highlighted that purpose of section 14 was to introduce a statutory status quo. That is, whatever is the legal points, whatever are the legal battles, till the moratorium is declared, stayed at the same point, stayed in the same position in which they were. And now the corporate debtor is protected from all those proceedings during the moratorium so that IRP can perform his duties in an efficient and time-bound manner without any hindrance from third parties. Because it is assumed that if legal battle would continue, and IRP had to go and attend the same, then how is he going to focus on resolving the insolvency? That is the main objective of the code.
So, madam, how to deal with the properties which had been attached by the regulatory bodies in the resolution?
See, this we are coming into pick. This is again section 31. You know, there has been amendment that been inserted, which is saying that whatever is being done till now, the new promoters, the new management cannot be affected with the any proceedings that has been initiated before the resolution plan.
Is it automatic that the approval under section 31 of the NCLT is automatic approval and no further steps are required, or the resolution applicant or RP has to take the step to get it detached?
No, he has not to take the step to detach. They are, whenever these are the cases that are being filed by RP itself for the corporate debtor, and they are saying you have to detach, but till now the position is not clear.
So that is why I'm asking the question.
Yes, that's why I'm saying I have seen even in this what it is saying. SEBI has till now said, okay, keep these assets, but you cannot sell it.
Then what to do with the assets? To keep the assets if I cannot deal with the asset?
Yes. See, to the extent they are the cases, let us conclude this in the last, but to the extent I feel, when from the legal point, if you look from the investor's point of the SEBI, you would say this is a right action. But as an IRP, I have to perform my duties, and it is my duty to collect all the assets.
The collection of the assets without any encumbrance or without any attachment is my, keep them free from any kind of this. Is it my duty, or I have to give it on as is where is basis and RA has to take it? This is a question. Who is responsible?
See, you have to collect it, and then it is the decision of COC how to deal with the same.
COC cannot take this. COC can only approve the resolution plan, cannot deal with the attachment part of it.
When you are giving the details, you will declare that this property is being attached. And as far as moratorium is concerned, it is taking all the assets without attachment. It is saying whatever is your claim, submit it as an operational creditor.
But even authorities are attaching within the moratorium also.
That's where the problem is coming. No? Till now, the judgment is saying come as an operational creditor.
The major issue is SEBI and you talk about PMLA.
PMLA, even the income tax recovery mechanism.
Yeah, that's why
again and again judgment is saying you can come as an operational creditor. You cannot attach the property.
Yes, and section 238. If you look into Rambo kind of situation.
Yes.
This is as as you have rightly observed that this is a legislation which has come as a new generation legislation, taking into consideration the non-obstance clause. But how then the Rambo could have come into picture then?
That's how I'm saying that they till now, if you go through the judgment, see, whenever any law is there.
So what is your guidance? What is your guidance to the fraternity?
See, I was looking into the act, and I was going through the two. I said there are two phases. Both are to protect. One is to protect the investors. Other is to protect the whole infrastructure. So if going by the major economy viewpoint, I would always say that it's IBC that would prevail, because it is not protecting only the investors, it is protecting a whole infrastructure in which the economy resources has been invested. And the purpose of the code is to protect that infrastructure.
The objective of the code is to maximize the value of the asset of the corporate debtor. not the
It
whole.
is to before maximizing the value, the objective of the code is to resolve the insolvency. And if you go behind the legal intent, it is to run the infrastructure as a going concern.
Yes.
How would it run it if other is going to attach the assets?
That is the point. That is the point.
That's why, as far as I am concerned, I would definitely go by the view that yes, these assets cannot be attached. Obviously, the corporate debtor is admitted to insolvency because some fraud is there. There is some mismanagement. But objective is to protect this infrastructure and give it in the hands of a new person.
There has been
run it efficiently.
Management. That's why there has been IBC, ma'am.
Yes.
So that has been Section 14 moratorium.
Yes.
Time and to collect the assets and hand over in a peaceful manner without any hindrance, without any attachment. But things are happening different way.
That's why we are having all these judgments.
I think even the law has only become applicable to other persons, to the private parties. For government, there is no law. For all the government authorities from different corners are coming.
Yes. In fact, the government authorities are coming and they are challenging it.
Correct.
That's why the issues are there. But had it not been there, how would have we read all these judgments? Had it been so clear, being an RP, we are facing it. That's why we are filing the issues. Our viewpoint always say that Section 238, Section 14 is in favor of IBC. We would always say this.
The Ministry of Corporate Affairs has submitted within the court, in the Rambo also another judgment, Manish Kumar matter. In the PML, in the Supreme Court, the Ministry of Corporate Affairs through Ministry of Finance has given a detailed statement before the court in affidavit that IBC is prevailing, but nothing is happening. Still the matter is pending. And the
even Nirmala Sitharaman ji in her speech has stated that IBC code would prevail. Specifically in a meet of IBBI, when she was there, she has highlighted the importance, how much important IBC is there. So it's only IBC. If it is in conflict, IBC would prevail. That was her statement.
But the statement is fine. But what is
I know we are all facing this issue in the practice. But it is now up to us how we are going to present our case.
No, I think that under these circumstances, a contempt of the court or a contempt of the authority should also be explored. Because if every now and then Supreme Court is saying, I mean, they are upholding the previous opinion, I think before going for any action, one should go for the contempt proceedings also.
See, you are right at your point that you can go for the contempt proceedings, but I don't think so that IBC is in a nascent stage. It is growing year by year. There are so many changes which are being implemented in it every year. So you cannot directly go to, we are waiting for the Supreme Court final judgment on this.
Madam, how do you see the legality, as you have mentioned in your last slide also, the trading which are taking place during the CIRP period? You have highlighted that when stock exchange is not even empowered, you have given the reference to it, right? Because Section 28 of the IBC.
See, this I am not saying this was being held by neglect in this case.
But then how the trading is taking place?
In practice, what neglect said, trading is almost nil. Trading doesn't take place in these cases. Who is going to trade for a corporate debtor which has been admitted to CIRP?
It has been in many of the cases.
No, it's not the case. Even in the case of Reliance Capital, the trading is going on.
Yes, in many cases. I have the RP and the liquidator in many cases where the trading has been taking place.
See, it's the investors who are trading. It's not on behalf of the promoter. They cannot trade. RP is prohibited.
Who will authorize? Who will authorize those? Because Section 28 does not allow. How the Section 28 have been overridden by the stock exchanges to allow the trading?
See, they are saying to the stock exchange, you don't have power to stop this listing. You don't have power to stop this trading.
They can do it.
No, Vinitji, who stops shareholder from trading? How can somebody stop shareholders from trading?
That is the question, sir, here. Since morning we are discussing this because the shareholders' rights are unfettered right. IBC is not putting any kind of restrictions on the shareholders' right unless until the resolution plan is approved under section 31, and that becomes binding on all stakeholders.
Yes, absolutely. But where you are facing problem, because in my case, I have gone to SAT and they have allowed trading. In that case, SEBI, the stock exchanges have suspended the trading. And I filed a case before the SAT and I clarified all the provisions of IBC, and they directed the BSC and NSC to suspend the notification which they had issued.
Yes, they should not do it, sir. It is not in the interest of
It is a settled. I have won this case in the SAT.
Yes. But
nobody can stop trading from the nobody can stop shareholders from trading the in the equity shares of any corporate debt.
We all are in the favor that there is no law which restrict their rights to transfer and to deal with the shares in the IBC. The problem is section 28 again, I'm saying, sir. When look at the screen, the madam has put up over here, because NCLAT has probably went into the details of the section 28 and said that approval of the committee of creditors.
That is only for the resolution professional.
Yeah, dealing in this. No, RP cannot. RP cannot give any kind of this approval. RP is just a facilitator in the CRP process, nothing else.
IRP cannot sell the shares except in accordance with the provisions of IB code and approval of COC.
RP don't have the shares. Shares are with the shareholders. These are not my assets, madam. These are my liabilities. In fact, in my liability head, I am my investment only.
No, madam, there are two. I think we are talking about shares, but you are maybe referring to investment by the corporate debtor in the shares.
Correct.
Maybe.
That's a different thing. That is my
That's a different thing. What Vinitji is saying, he is saying the equity shares of the corporate debtor. So there are two different things. I think you are referring shares as an asset, which are reflected as investment in the books of accounts of the corporate debtor.
Unfortunately, we have kind of the RPs who could fight with the stock exchange and ask a favor for the investors to open the trading. Otherwise, invariably, they are suspending the trading.
Because no, Vinitji, I can share with you the case which I have fought for Syntex Industry shareholders, and the suspension was revoked.
Yes, this should be, sir. Because otherwise, how they will get the exit somewhere? Their exit should not be stopped at any cost.
That's what is being held by NCLAT in this case also. That you cannot stop trading. You cannot threaten them to delist the securities.
Delist is altogether different and suspension is altogether different, madam. What they are doing, they are not doing delisting at all. Unless until we file a formal application or the company goes to the liquidation, then there is a committee which considers this. What they are doing for non-compliances, past non-compliances particularly, or non-payment of the fees particularly, which is the major issue. And because it has to be dealt with as a part of the claim, which is an operational claim, synergy dure, the first claim itself clarified. So what they are saying, since you have not paid the fees in the first part, you have also not filed the various financial statements and the documents with the stock exchange in terms of the LODR, your trading is suspended. So this is detrimental to the interest of the investor. What the sir is talking, that he went ahead and said, whatever may be the non-compliances, whatever may be your claim has to be dealt with by the RP in accordance with the IBC. But you cannot put any restriction to these investors not to trade their shares. So, but still we are hanging around it at how to deal it and how to deal with the NSDL, CDS, and then it went to the liquidation, goes to the going concern sales, where again the trading is continues in liquidation in few of the cases.
Sir, in this, I would say these are the issues still going on till now. I have looked for the Supreme Court judgment for the same also, but there is no such judgment that could be found till now.
Yeah.
It is still in pipeline.
That's
so
right.
We have to wait for the final verdict of the Supreme Court.
Fine, Preeti ma'am, please continue.
Ma'am, I have one query. Can I raise?
Yeah, sure.
Ma'am, this is in relation to like attachment of property, right? So you have shown one case wherein the property was attached by the SEBI before the CIRP. Then CIRP started. Then RP has applied for the de-attachment, right? So, and there are other cases like where the attachment being asked during the CIRP. So during the CIRP, it is very clear that 238 would prevail, right? So during the CIRP, no authority can attach. That is very clear, including the SARFASI also. But however, the question is that before the CIRP process, if the properties are attached, whether RP should go for detaching the property or whether the 238 would come into the picture, because the SEBI at the time was correcting their attachment, right? So they can't be asked for detaching just for running the affairs of the company. Otherwise, this is susceptible to be misused by all any corporates. Right? Right? So what would be your view with regard to the attachment of the property before CIRP?
See, there is a judge case also which has decided that even if property is attached before the commencement of CIRP, even in this case also, they have said, okay, it has been attached, but once the moratorium is there, it has to be detached. And even the Supreme Court has said, okay, this decision is being stayed by the Supreme Court. NCLT's decision is being stayed. It has not given the direction for detachment. It has just stayed the decision. And it has asked the SEBI to hand over the title deeds. This is the status quo till now.
But ma'am, is this not like action, like your authority, like being retrospective use of that moratorium period? Because otherwise, it's like very, it should not be like this situation, right?
So one thing, tell me, in PMLA also, in everywhere, whenever there is property attached, they are attached before the declaration of moratorium.
Yeah.
And even then there are judgments which are saying this has to be given back to the RP and you come as an operational creditor.
So like we have to go through that judgments, like so
Yes.
the present precedent is this. Okay.
Yeah.
Okay, thank you.
So what is the stand of Supreme Court with respect to this section 14 is that to maintain the status quo, so that IRP can perform his duties in an efficient and time-bound manner without any hindrance from third parties, observing that as opposed to the Sikh Industrial Companies Act, which is forming a major part of the erstwhile insolvency regime, the statutory freeze under IBC is a temporary one only. That is from the admission of insolvency petition to the insolvent approval of the resolution plan or liquidation. Supreme Court held that it should be strictly adhered. This moratorium period should be strictly adhered. That is the verdict of the Supreme Court with respect to section 14. So if you will go through the judgment, Supreme Court view with respect to section 14 and section 238 for IBC is consistent. But with respect to SEBI, it is not clear. In Mr. Bhor Singh Dhillon versus Rohit Sehgal's case also, the neglect held that SEBI could not recover any amount, nor can sell the assets of the corporate debtor. That the decision that was there that to hand over the title deeds, it was being said that okay, but you cannot enforce the recovery mechanism. Because the resolution professional is required to act in terms of section 17, subsection 2E of the IBC for complying with the requirements under the SEBI Act. And if he fails, even then, you cannot bar by virtue of moratorium any the corporate debtor to deal with respect to the trading of the securities of the corporate debtor. No such suspension could be there. If any penalty and anything is there, come as an operational creditor. So the same was the view of the Innovative Industries Limited, in which they have said that non-obstant clause should be read in its widest terms possible, so that any right of the corporate debtor under any other law cannot come in the way of the IBC. See what a widest possible interpretation could be given to section 238. Till now, with this judgment of Innovative Industry, what we and you as a RP or IRP can interpret is that whatever is the right of the corporate debtor, it cannot be taken away because it is under the shelter of IBC. Very beautifully, it is said that if the moratorium is imposed by the Maharashtra Act to continue for 1 year, the whole scheme and the object of the code would be set at naught. Because there was the conflict between Maharashtra Act as well as this IBC code in Innovative Industries say, and a moratorium was imposed under the Maharashtra Act for 1 year to 15 years. So they said the whole code, the object of the code would be defeated if you are going to accept the moratorium that is imposed by the Maharashtra Act. That's why the non-obstant clause should be given the widest possible interpretation. For all the reasons, the tribunal was consistent, appreciate that yes, there was a repugnancy between the provisions of the two enactments, and the section 238 is going to prevail over the Maharashtra Act. Reading section 14, again I am repeating, in the light of the object and purpose of the IBC, undoubtedly conveys that the bar imposed during moratorium shall be applicable to all regulatory bodies, including SEBI and stock exchanges. Similar way was the speech of the finance minister in Rajya Sabha also, which has specifically mentioned analyzing the contradictions between the SEBI Act and the IBC. The finance minister in Rajya Sabha debate, when there were the questions about the effectiveness of IBC, she has commented that IBC has actually an overriding effect. For instance, you asked whether IBC will override SEBI. Section 238 provides that IBC will prevail in case of inconsistency between two laws. Actually, Indian courts will have to decide in specific cases, depending upon the material before them, but largely, yes, Section 238 is going to prevail in case of inconsistency between IBC and any other law. This was upheld by the finance minister also. So by this, we can draw a conclusion. We can say that the intention of the legislature behind enactment of section 14 and 238 in IBC is that whatever are the provisions, whatever are the recovery mechanisms of any other act, they would not come in the way of IBC. That is the conclusion we all can draw till now. But there are few decisions which are held by the NCLT and NECLAT in which SEBI powers is being upheld. And please stop here itself ourselves, because these are the decisions which are held till the level of the tribunal and the appellate tribunal. No final conclusion, no final verdict of Supreme Court is there with respect to the SEBI overriding the other, so overriding the section 14 and 238. But still, the lower are refusing to recognize the interpretation of the law for that, or the verdict given by the Supreme Court. The first case that has given it is Shobha Limited versus Sadashiv Lajman Jogalkan. So Shobha Limited and Sadashiv Lajman versus Pan Cards Club India Limited. Are you able to see this judgment?
Yes, ma'am.
Okay. In the NCLT, the Mumbai bench, this was a petition filed under section 9 of IBC. That is, it was filed by the operational creditor for the PAN card club. The operational creditor has issued notice to the corporate debtor under section 8 of the IBC, wherein the amount claimed to be in default was 6 crore 25 lakh 42,000 something. When the documents were produced, NCLT came to the observation that a petition reflecting a public notice issued by SEBI was there, which revealed that there is an order which has been passed by SEBI, and it was upheld by Securities Appellate Tribunal also against the corporate debtor who have collected huge money from the public in the name of holiday plans. The debtor council, after making all the submissions, has submitted that now pass an order under section 9 of the IBC. Though SEBI and SAT, SEBI has given the order for recovery and SAT has upheld the same order. Still, there was an application under section 9 in IBC. what was the conclusion of the NCLT? It said that SEBI has come to a conclusion that it is like a Ponzi scheme, which requires an initial investment and a promise well above average returns with no risk. The modus operandi in this scheme is the operator generates the return to investors through money which is paid by new investors rather through any legitimate business activities. So they say this is kind of collective investment scheme which needs to be registered under SEBI, but it was not registered and they have manipulated the money of the investors under the name of this scheme. That's why SEBI gave an order to the company and its director that they shall abstain from collecting any money from the investors pursuant to this collective investment scheme. They shall wind up the existing collective investment scheme and refund. The order of refund was being given by to the company that refund the money of the investors and give an acknowledgement that submit an acknowledgement that you have refunded and investors have received it. Simultaneously, they have said that corporate debtors shall not alienate or dispose or sell any of the assets of the company except for the purpose of refund to the investors. See, if just understand this order with the view that if the same application is being admitted, can this order be imposed? They shall provide full inventory of their assets, property details to the SEBI. Simultaneously, it said they are debarred from accessing the security market for a period of 4 years, and a criminal case was also filed against the company, its promoters, directors, and managers for cheating or for the criminal breach of trust and misappropriation of public funds to initiate and with a reference to MCA that initiate the process of winding up of the company. The order was upheld by the Security Appellate Tribunal. So all the assets are being attached. Everything is being, they have said that these are being attached. Now the petition under Section 9 was being filed. See, this order has already been given. This was upheld by SAT also. After that, a petition was being filed under Section 9. What was said that if you will go through Section 238 of the IBC, obviously anything inconsistent. Now the word that was being highlighted was that the provision of the code shall effect notwithstanding anything inconsistent therewith contained in any other law. So what they said that the section, they interpret this section in the way that the provision of the code have an overriding effect, but this overriding effect is with respect to other laws. And if you want to apply this overriding effect, see, there's one thing that I really find very different, means something that is not expected, that they have explained that this overriding effect is with respect to other laws, not with respect to the provisions of this code. This is a simple interpretation. I think this is not a contradiction anywhere, but still this was being mentioned in there in the judgment. Finally, to apply this overriding effect, they said the provision of other law or instrument governed by other law shall be inconsistent to this provision of the code. Then deductive reasoning can be as long as other law or jurisdiction under other law is not inconsistent with this code. Section 238 cannot be invoked because triggering point for application of this section is inconsistency of other law with this code. So they are saying that the word notwithstanding anything contained in any other law for the time being in force under Section 238 only speaks of the law inconsistent to the operation of the code, and this is not a blanket overriding effect. In Kishorbai Kamchand case, we have done this. Earlier, the 3 points that were being taken by the Supreme Court while dealing with the inconsistency, they said that presumption against repeal is by implication that the legislature, while enacting the new law, is presumed to have complete knowledge of the existing laws on the subject matter. Therefore, when it does not provide, if the new law is not straightforward giving to repeal the provisions of the earlier law, then the intention is clear that it does not want to repeal the existing law. But this presumption would apply only when the provisions are inconsistent or repugnant to the provisions of the earlier act, so that the two cannot stand together. If they can read, go for the harmonious interpretation. Again, the three questions that are being answered in this case. First question was if there is a direct conflict between the two provisions. They said that going by the test, there is no direct conflict between the SEBI Act and the IBC, because SEBI is dealing with the investor protection issues, while bankruptcy code is dealing with the creditors issue. The juror relationship between the parties is also different. In SEBI, it is between the investors and the company, and in IBC code, the relationship is that is being there is of the creditors and the debtors. So what the NCLT states that it don't find any subject matter which is in conflict between the two statutes. So first thing is over, they are not contradictory. Now, overriding effect in this law, they said this is not a place where you are bringing in a non-obstant clause, always knowing the existence of other laws. If you want to give a complete overriding effect, then either repeal the earlier law expressly or expressly mention that what is the overriding effect in purview of the Kishore case. What they said that the objective is to maximize the value of the assets and pay off the creditor so that money will come into circulation. But for this, can you knock off the gullible victims, which is 51,55,000, which have paid more than 7,000 crore of rupees, believing the papers which were not having recognition under law. So here it analyzed whether you want to favor the creditors or you want to favor those who are victims, which are innocent, the public, which has given the money to the collective investment scheme. By going to the 238, they say only when other laws are inconsistent, but they said SEBI is dealing with the investor protection and IBC is dealing with the creditors and debtors. So there is no overriding effect. There is no legislative indentment that could be called for replacing the SEBI Act. Again, I am saying this is NCLT, which came to the conclusion that there's no inconsistency between the two. They are occupying different fields, not the same field. So you cannot you cannot occasion the presumption that IB code has come to replace the SEBI jurisdiction. If for any reason the jurisdiction under the IB code is stretched out, it will truncate the jurisdiction which is conferred upon the SEBI to deal with the subject matter, which is altogether different from the creditor and debtor issue. See what now there's a different view that is being upheld by NCLT in the Shobha Limited case. They are saying they are altogether different. So SEBI power cannot be taken in the IB code. Though we all know this is altogether a different judgment, but still it is there. So they are saying there is no such contradiction between the two. Now, adjudicating authority, if there is any such doubt regarding the admission of petition, and see, they are saying section 14 has not come into pick. Now we are at the stage first that whether to admit the application or not. So the first question that is being taken into account by NCLT is that when SEBI has given an attachment order, SEBI has exercised its recovery mechanism. The order has been upheld by the Securities Appellate Tribunal. Can an application under section 7, 9 or 10 be filed? And if filed, can it be admitted? Because section 14 will come into pick only when it will be admitted. Otherwise, it will not come into case. So say this case was being resolved at the first instance when the application was being considered by NCLT. It says that SEBI in this case is trying to recover the money because of the fraud of the debtor, which has raised a fund of more than 7,000 crore from the investors. Code has no overriding effect. There is no use to extend the jurisdiction of the code and nullify the order passed by the SEBI. And that's why the investors' interest should be protected. That was what was being held in this particular case of Shobha Limited. They said what was held is the point to be considered is property may be common, but when there, this is one of the case with respect to Sarfasi that was said that the property may be common, but the law is operating in different rights and liabilities. That's why the non-obstant clause will not work. And what it said, these are the same assets which are required by the creditors. And these are the same assets which are required to be given to the investors. The angle is different. So as far as this judgment was concerned, they said outrightly they rejected. They said operational creditor, the one who has filed the application as an operational creditor is not an operational, he is also one of the investor. Because the agreement with respect to which the collective investment scheme was made, it was itself illegal. So there is no juror relation. The one who has filed the application as a creditor, in fact, in law cannot be recognized as a creditor. So SEBI, whatever the SEBI has given the power, that was being upheld, and the person who has filed the petition under Section 9 was held that he is not an operational creditor and he is not falling within this jurisdiction. That's why the SEBI's power will be was upheld, and the order was upheld, and Section 238 was not allowed in this. This petition was dismissed. This was the case of Shobha Limited, right, where the three provisions were considered of the Kishore Bai case, and it was held that no, let's protect the investors of interest of the investors, and the same order was upheld by the NECLET also. But if you will go in the related matters of the Nitin Suresh Sadgare and others versus PAN Card Club, NCLT Mumbai bench initiated CIRP against PAN Card Club for failure to repay money due to lacks of investors, and stated that initiation of CIRP cannot be impeded by an existing SEBI order. So now, what is a conflict for us is level of the tribunal is same here, but one bench is giving a different decision and other bench is giving a different decision. So what to follow? That is a question for us. If you go through this case of Nitin Suresh Sagarke in NCLT Mumbai Bench Tribunal versus SEBI, here the situation was different from the Shobha Limited case. Shobha Limited case was a case when the petition was filed under Section 9 as an operational creditor. In this case of Nitin Suresh Sadgare, the petition was filed as a financial creditor under Section 7 against PAN Card Limited. Just mentioning highlighting what is being considered here. They have considered the Shobha Limited case also. This is a list of those who were acting as a financial creditor. Yes. What was the submission that the financial debt was raised with respect to the investments made by the petitioner in collective investment scheme? Now the view that was being held that, you know, in RERA also it was being held that home buyer is a financial creditor. Similar in this, they are saying, I am an investor, I have given the money to earn the time value of money. That's why being an investor in CIS, I am a financial, whatever is the money being paid by me, it's a financial debt for the company and I am a financial creditor. SEBI in its order has directed the respondent to refund the monies to the investors within 3 months. Thereafter, respondent has preferred an appeal before Securities Appellate Tribunal and challenged the order. But Securities Appellate Tribunal upheld the order of the SEBI to refund the monies. Now the petitioner submit that if you will go through the perusal of the order, then it is clear that investments made by the investors were accepted. The respondent PAN Card Club has accepted, yes, the money that he has accepted was for the timeshare scheme of the company. So it is held, it was concluded, means the petitioner has said that's why whatever I have invested, it is against the consideration of time value of money, and my debt is a financial debt. This application is filed by SEBI, in which the schemes operated by the corporate debtor were in the nature of CIS, and the same was upheld. See, what has happened, that whatever order was given by the SEBI for recovery mechanism, that was same filed by the Securities Appellate Tribunal, and e-auction notice have been issued. After that, this petition was being filed. However, the e-auction notice was stayed by the Honorable Bombay High Court till then, when the petition was filed. Shobhan Limited case was referred here. The difference was carved out. They said in Shobhan Limited case, the matter was filed under Section 9 and it was dismissed because there was a pre-existing dispute. Second thing was, there was no legal agreement. There was no legality of that CIS scheme. The neglect has held while upholding the order of the NCLT that CIRP under IB code cannot be nullified by any order passed by SEBI, nor can be a ground to reject the application. But what was the reason for rejection of the application was highlighted here, that because there was a pre-existing dispute, that's why they have rejected that particular petition. So they said, on plain reading of the court, it is crystal clear in that the neglect has held that SEBI, as far as the order passed by SEBI, is not a bar. That's why this is a answer to your question, that the order for attachment has been given before the moratorium is there. But still, that will not work out once the petition is being considered by NCLT and it is being admitted. And while admitting such an application, any particular plea, that order has already been passed by SEBI. That's why this CIRP cannot be initiated. This will not be considered. This was later on held. See, these are the judicial pronouncements which are taking place over a period of time. At the first stage, they are taking other decision. After a period of time, some other bench is giving it another justification for the same. So it held that the CIRP for failure to repay money cannot be impeded by an existing SEBI order. Further, if you will go through the Rufit Industries Limited versus BSE Limited, NCLT Mumbai ruled that non-obstant clause can be invoked only when other laws are inconsistent. A very small one. If you look for this Rufit Industries Limited, this was a case that was being filed in case of Rufit Industries Limited. And this application was filed by the resolution professional, which has submitted the application to assail the order of delisting, which was passed by the Bombay Stock Exchange for delisting the shares of the corporate debtor along with the other companies. What was the relief prayed by the resolution professional? In this, resolution professional plea was to declare the order of the Bombay Stock Exchange and National Stock Exchange to delist the shares of the corporate debtor and consequential impact that they are under SEBI's delisting regulations, declaring them as illegal and void in provisions of section 14 and 238. So one plea was that the order of the stock exchanges to delist the securities of the corporate debtor during CIRP to be declared as illegal and void because of the provisions of section 14 and 238 of the IBC. Then they said that to direct that there is an instruction that is being given, direct the respondents not to deal with the shares of the corporate debtor pending moratorium granted by this tribunal. And it also requested to direct the respondent to list the shares of the corporate debtor back on the stock exchange, operated by them pending validity of moratorium passed by this bench. And then they said to declare the provisions of SEBI laws, including delisting regulations, to the extent such provisions are inconsistent, that they will not be applicable to the companies which are being under CIRP. Direct plea by RP that declare them that they are inconsistent, and that's why they won't be applicable to the companies which are undergoing CIRP. The same thing which Viniji was saying, that we have to separately make an application. In this, we can see, yes, the application was being filed by the resolution professional. He has made not only the stock exchanges as party, but SEBI also as a party, Ministry of Corporate Affairs as the party, for the order that is being given under securities contract regulation to delist the shares of the corporate debtor. This application submit the corporate debtors is not under liquidation. The applicant submits that the whole-time directors, promoters, and group companies shall be debarred from accessing the company's securities from the market for a period of 10 years. And the corporate debtor, if debarred from access to securities for a period of 10 years, from the date of compulsory delisting, it will affect the revival of the corporate debtor. He is saying, okay, you can give this direction with respect to the promoter or whole-time director, but not to the corporate debtor. The applicant also propounded that for the power that is being conferred upon the RP under section 35 subclause 2, that he can consult with all the stakeholders regarding the distribution of proceeds. He says that delisting of shares shall not be permitted, because once they will be delisted, their value would come to 0. Now, what was held that since RPI Council has made an argument that by delisting, shares value gets diminished, now the point for consideration is listing or delisting is the domain of the stock exchange, which is governed by the SCRA securities rules and regulations, which is coming from SEBI. Can they be interfered by RB under the garb of prohibition, which is given under section 14, saying that RP is given power to consult any stock stakeholder, including the shareholders entitled for distribution under section 53 of the code. Now the question for determination is, can RP make such an application taking into account section 14, section 35 and section 53 of the code? They said that liquidator has a power to consult the stakeholders who are entitled for distribution of the assets pursuant to section 35. But this is limited only with respect to exercise the power of distribution of the proceeds under section 53, not in respect of the governance over listing of the shares of the corporate debtor. This is purely the falling within the purview of the securities contract regulation. Even though there is an amendment in section 35, but these amendments stay the ongoing CIRP? What they are saying that it appears that power has been conferred upon the insolvency resolution professional only to include how he has to deal with the interest of stakeholders in the statement prepared by him. It is limited only to deal with preparation of the statement and not to interfere with the governance, which is coming under other enactment, by stretching out to debar the other authorities from exercising the powers which are endowed upon under respective laws. By going through the notice that is being given, the stock exchange have taken action as this company failed to comply with the provision of listing agreement. It goes without saying that every listed company shall abide by the listed agreement. If and when any listed company violates, they have the power to delist the same. Moreover, before delisting the shares, the listing committee considered the explanation of the corporate debtor, which has been submitted far before declaration of the moratorium, which is given against this company. If at all corporate debtor has any grievances, he should go to the stock exchange. He can file an appeal before the Securities Appellate Tribunal, but NCLT is not an appropriate bench where such kind of plea could be raised. See, entirely different view. Earlier, they were saying you cannot delist, but an entirely different view was there. The notice given by the BSE is a sequel to the delisting order already passed, but once a company is delisted from one stock exchange, because that company has been delisted from NSE, that's why it is compulsory that the other company also give a notice for delisting the same company. Now the bench put to the RP that you are filing this application to stay the notice of delisting under which particular section. Section 14 was mentioned. They again repeated that this provision is regarding which, if at all, what was they concluded, if at all combined reading is given to the prohibition, it appears it is a prohibition to proceed against the company with respect to the dues payable by the company and not in respect of other violation under various enactments. All actions and messages there are of the same kind. So you cannot apply this omnibus provisions of prohibition and restrictions when they are violating the other provisions except for the due amount. If you are strictly applying it, you will say, yes, it is prohibited. But if you will go into the genesis, applying the doctrine of justum generis in section 14(1) subclause A, you would say this code is basically a code dealing with the debts payable by the company. Therefore, what all prohibition and overriding effect is spoken of under section 238 is to be conceived as an effect to be given only with respect to dues payable by the company, but not to with respect to the other working aspects which are falling in the domain of other act. Therefore, you cannot say that you run the company under CIRP free enough to flout the other laws. This cannot be the intention of section 238. Non-obstinate clause can be invoked only when other are inconsistent, and it is being held in this particular case this is not inconsistent. They can delist. So you will say, what is the final conclusion? In each and every case, now we have to present our case. That why we are saying, and obviously if we don't want to get it delisted, and even anyone would go by the earlier provision that during the CIRP, though this was a view that was being held in a particular case by NCLT, but still the view that is previously held is there. I just wish to tell you how much contradictory decisions are being held till now with respect to the same matter as far as SEBI's recovery powers are concerned. If you will go by the Supreme Court ruling in Harshad Govardhan case, where the court was called upon to adjudicate, these are all which are favoring SEBI power. The court was called upon to adjudicate a conflict between section 65 capital A of the Transfer of Property Act and section 13 of the Securitize and Reconstruction of Financial Assets and Enforcement of Security Interest Act. The court laid down in unambiguous terms with respect to SARFAESI that although assets governed by both the statutes are the same, both the laws are operating in different fields, rendering the non-obstinate clause unenforceable because they are in different fields. So you cannot say that non-obstinate clause of one particular act is unenforceable in view of the non-obstinate clause of the later law. Even the Supreme Court in Damji Walji Shaw case versus LIC ruled that in proceedings before specialized tribunals with exclusive jurisdiction, the provision relating to moratorium will not be applicable. And section 20 capital A of the SEBI Act is providing exclusive jurisdiction to itself and the adjudicating officers in respect of the issues that can be decided by them. Therefore, if you will go by this view of the Supreme Court, you will say moratorium will not be applicable. The issue also stands settled with Delhi High Court's ruling in Power Grid Corporation of India Limited versus Jyoti Structures Limited, where it held that moratorium provisions would apply only to debt recovery actions against the corporate debt. So
Madam,
now, yes.
This Delhi High Court jurisdiction is applicable because what I understand that normally for these matters, Supreme Court is referred.
Yes, the court provides it for the Supreme Court, but still you know, there are many of the cases that are being given verdict by the Delhi High Court regarding the same, because the issue might be different, but when they are deliberating upon this, they are saying, yes, this moratorium is applying only to debt recovery actions against the corporate debtor.
Madam, High Court is the court of constitutional court. It can entertain. The constitutional court, it has the power actually. Anyone of is affected.
That's why I am saying see how Supreme Court's power, constitutional power, Supreme power under Article 32, High Court power, constitutional power under Article 226.
226, yeah. Yes.
It can always be invoked.
Yes, it will always be constitutional powers.
Constitutional powers. So if you say how home buyers have gone to Supreme Court or this, they are always invoking their constitutional rights.
Yes.
You cannot stop them from approaching the highest court in the tribunal. Whatever is the procedure, that whatever are the forums that are being settled in the court, apart from that, I would say it's a skill of professional.
The writ jurisdictions actually.
It's a skill of professional, right?
Yes.
If you are filing a case in High Court, then I should know under which particular clause I can go.
The writ petitions, ma'am. It is only the writ petition.
I know. That's why I'm saying this writ petition. This is what I am applying. Because I know that under this writ petition, you can go. Now, there again, the argument will be there that this is not coming within the jurisdiction of the High Court. This will be the first argument. Am I right?
Yes, that can be.
Yes, but this is what is the professional skill of leading our case. And that's why judgments are there. Judge feel, yes, this is coming under your constitutional rights. They will go ahead and they will give the part. Even in IBC still, this is in nascent stage. That's why even the Supreme Court is interfering here. There's so much interpretation going with each and every case to get some final conclusion with respect to some particular issues. Like with RERA, it is almost settled now. With the process, this SEBI's some judgments we are all waiting. It is evident post the NCLT ruling in Rufet Industries that companies under CIRP cannot flout laws by virtue of moratorium, because the prohibition under section 14(1) subclause A is with regard to the dues payable by the corporate debtor and not in respect to other violation under various enactments such as SEBI Act. Will you agree with this?
Madam.
Throw some light on this. What will you agree with this?
Yes, ma'am.
Yes.
As in IRP, if I am working or RP I am working, then it is almost settled that you have to file GST returns, you have to file ITR returns in time, you have to fulfill the regulations.
Yes, ma'am. Actually, the moratorium is for the purpose is that if there is any claim against the company, that should be put to rest. That will be decided by a mechanism. So other actions would continue, like the other assessment of the income tax, of the provident fund authorities. You talk about other regulators would continue to do it.
Yes, this is very much clearly settled that I cannot shirk off my responsibility and say, okay, this is moratorium, I am not going to comply it. It means it is my duty, even if I am not complying with it, okay, you cannot impose penalty, you cannot exercise your powers, that we cannot say. So you have rightly come to the conclusion, this is only with respect to any claim in the company. Moratorium is there, not to flout the laws.
No, section 14 is because the operation of the company should not suffer because of those legislation. That was section 14 is there.
Yes, section 14 says we should not suffer. Even what is the purpose of settling the management? What is the role of the management? That it should run properly.
Properly, exactly.
And this is the same role of the RP and IRP.
Exactly.
And how are you going to run it properly? In most of the cases, even we don't know about the business model of the corporate debtor. It took time to understand it. And simultaneously, we all are very clear in the concept that we have to comply with the legal part also. So as far as I would say, I can say stop this debt recovery actions, but rest, I have to follow the rules so that we don't need to fight for if somebody, even if exchange is delisting, we should fulfill. They are asking what? During CIRP, they are asking only for the compliance of the regulation. They are not asking for the money from you. So that's the only part we have to do it. Now it is no longer a new subject, res integra. We call it as a res integra. If something new is there in the law, we call it as res integra. But now we are saying the mechanism for recovery of penalties under IBC is now no longer a new subject. It has been settled. Statutory dues arising under any laws are recoverable as an operational creditor under Section 5, subclause 21 of the IBC. NECLAT has affirmed this in Synergies Dure Automotive Limited as far as income tax recovery proceedings were there. Even for the PMLA cases we have discussed, this has been settled. NECLAT has also settled this in the ruling of the Maharashtra Seamless Limited versus Shri Padmanabhan Vekantesh, when it held that the penalties which are imposed by SEBI can be claimed as operational debt, but they are not recoverable during CIR. But now the question that comes to the conclusion for the authorities is, what do operational creditor get in resolution of this CIRP or if the company undergoes liquidation? What do they get? If somebody is an operational creditor.
Anyway, it will get, even in CIRP, if there is a resolution plan, they get a very small share.
They get a very small share.
Okay. In liquidation, though, hardly they will get because
hardly they will get anything.
Yes.
Yes.
That's the status.
That's the status. So saying that you come as an operational creditor, is it okay?
See, because the dues are arising out of the operation of the company, no? So that's why treated as operational creditor.
They are admitted on the practical ground. If you say that I am giving for the operations of the company, that's why I shall not be paid if the company is undergoing CIRP.
No, madam, there is nothing in the CIRP. Even the operational creditors can be paid 100%, depending what the COC decide and what the RA propose.
But in most of the cases, they don't get.
So probably that is the reason that the new amendment had been proposed, that if you take anything beyond the liquidation value, that will be distributed in ratio of the claims. This is the reason they are going for amendment.
Yes. And there was one amendment also that if a resolution plan has to be successful, it shall provide first for the operational creditors, yes, then to the dissenting financial creditors, and then to the financial creditors who have approved the resolution plan.
Madam, actually that was not working. See what present law talk about, that you have to pay in priority to the operational creditor what is there is due, right? And what is available to them in accordance with the liquidation value, that is 0. So there is no point. So that's why they have said that anything you are getting as a premium over the liquidation value should be distributed amongst all the stakeholders in the equal ratio. So this is something is a new thought. But here what is haunting all of us is that after the synergy jure, it has been settled that government is a operational creditor. We all have been very easy. They have been doing assessment. We have been taking claims on the record and let it be decided. With the Rambo, what is happening? Section 32, Section 38 of the various state government. If you look at the state laws of any state, VAT, because the government forget the VAT has gone before the 2016 and GST has taken place. They have come on the forefront and everybody started claiming themselves as to be the secured creditor.
Yes.
That has changed the scenario to the many resolution plans. To my understanding, it is only the VAT department which are the secured one, not other departments. Central legislation does not provide for any of the government agencies to become the secured creditor. But yes, the state government legislations provide by operation of law. And that is a controversy, I think, which is on the table.
Yes, that is on the table till. But when the VAT, the judgment is in favor that because VAT is treating them as a secure creditor, so they should be treated as a secure creditor.
Yeah, but issue, ma'am, what we are facing is here, you start moratorium and they start doing it, your assessment. Because
Yes.
moment they came to know that company has gone to the CRP, what is the new practice nowadays? They start doing all kind of the assessment.
Yes.
10 years they have not touched the file, but today they touched the file and came out with the assessment order and put it to your table. No, it's up to you. You go to the appeal as a corporate debtor or you take their claim. So their claim relating to the previous period is fine, can be as a claim. But what is happening and what will happen for the CRP period claims going into the assessment and coming in the form of orders as penalties in liquidation? This has become a difficult situation. This is not protected by any kind of moratorium.
I
They
think
are not demanding. You have to just accept it as a claim. No, they are not demanding.
No, sir. This is a CRP cost. If during the CRP period you have defaulted something and they have done the assessment, claim can be the part before the commencement of the CRP is a claim. After then there is no claim. This is a priority cost. It could be anything. This is a difficulty, sir. This is something which is haunting.
to the extent, yes, I agree that during CIRP, whatever I draw this conclusion from the point that during CIRP, whatever are the facilities being taken by the corporate debtor, it has to pay for the same, whether it is electricity bill, whether it is income tax, whether it is GST, they are to be paid.
Yes.
But they shall pertain to the period of CIRP.
Yeah.
That is the only requirement.
That is the only requirement. So anyway, today we are dealing with the issue that what will happen to the claim which are before the commencement period. Maybe the assessment has taken place after the initiation of the CIRP, which has to be dealt with in 90 days period. If they are filing is fine. Going beyond 90 days, then has to be dealt with different way.
But yes, as far as this SEBI is concerned, different opinions are there.
To my understanding, ma'am, central legislation, they do not have any priority at all. They cannot.
Yes, one thing is they state what this SEBI Act is also how SEBI Act is also the specialized act, and this IBC is also a specialized act. Both
No,
of the
IBC is only specialized the code. Again, we have been talking about in the morning. It says the code. This is a special legislation to deal with the insolvency. SEBI law is to protect the interest of the investor, but in the name of the interest protection, they cannot override the specific laws which meant for the resolution of insolvency. So I think SEBI law is not having overriding effect on the IBC. It's very clear.
I also go by this, but my view only is in this regard, SEBI is dealing with the investor and the IBC wants an infrastructure to run. That is for the economy. That's the only way where the priority of the objective of the IBC is there. To the extent I perceive the objective of the IBC is superior to the objective of SEBI. Though both try to achieve the same target with the same intent. Even if IBC is talking, it is talking about stakeholders. These stakeholders have the investors in the company. The shareholders are also counted as the stakeholders in the company.
Correct, correct.
So it's not that IBC is not trying to protect the investors in form of their shareholders.
So that's what I'm saying, ma'am. I think the more classes are required by the government and regulatory bodies. I would request you to an IPO to hold the programs for the various government bodies and departments by which they can
absolutely correct. You are absolutely
and appreciate
correct.
the provisions and objectivity of this law and their laws.
Yes, they should understand about the difference between the two.
That will make the life easy.
Even government department itself, even the government officers are not clear with this IBC.
That's right.
Not only the private sector, private sector is scared. Once this CIRP notification is there, they are scared. Those who are creditors, they are scared. They think that IRP would pay everything. So he is the person who is the culprit. Let's have hold over him. This is what I have to counsel.
Madam, as far as these clarity of law is concerned, there are, it's a subjective issue. There are various bodies which are associated with the insolvency regime. Then everybody has different kind of understanding and maturity. Even for COC members, the COC members are not at all aware of the objective of IBC in some cases. I was shocked when in one of the meeting, one of the COC member asked me that why you were thinking that the company should continue to work even after this resolution plan. I thought that this is the main objective of the IBC, that we have to ensure that the company revives. So then, no, I am not concerned. मेरे को तो पैसा लेके company बंद चले या ना चले उससे मुझे कोई मतलब. That was the literal Hindi में he told like this कि मुझे कोई फर्क नहीं पड़ता. Then I have to strongly object. I told him that although sir you have appointed me, you are having the decision making power, but let me tell you that I have little bit more role to play here. I will come to you for the protection of all stakeholders. Maybe shareholders, maybe workers, maybe vendors, maybe all. It is absolutely you are having the decision making power, but you cannot say in front of me that let the company be closed after this resolution plan.
That is the normal approach of financial creditors. Yeah, we are used to it.
So it's a subjective issue, you know. It will take time to get to that level where people are appreciating the true spirit of the IBC.
Yes, it will definitely take. And what I have observed just a few days ago, I have counseled one particular organization regarding the role of IRP. Though I was not there, somebody else was appointed, and they contacted me in the case that it's only IRP who can pay. He will play fraud. He will play like that, because they were common person. They were executors in the company. So I just hold a counseling for them regarding the provision of IBC and clarifying them. IRP is there to assist you. He is not there to take anything from you.
No, this is normal with the financial creditors, ma'am. They don't, if there is any case filed by OC and IRP is appointed through OC only, then or by court, they will replace, financial creditor will replace that IRP. They no longer continue the same IRP. That has been not practical. That is the impact right now.
This is even if IRP is appointed by one financial creditor, the committee doesn't approve. He said, no, let's go with the another resolution professional we want to be in. I don't know, but this is going on, and if this is permitted, it's okay. At least for 30 days we can work.
No, 30 days, no, we are working more than that, because till the receipt of the order. So by the grace of God, the order is coming after a month. Still, you get another month to work.
And this all credit goes to the shortage of staff and shortage of resources as far as these tribunals are concerned.
Yes.
And
no, but I must say that it requires a lot of patience and energy at the level of IPs to be in this profession.
Right.
Because let me tell you that I was not on a panel of the lead bank this time. Okay. And I persuaded them that because of my experience, I will be able to deliver the result. Why you want to change? So I made a presentation to the, fortunately in my case, though, that lead banker was convinced and he said, I agree with you and we'll go by you. And then another banker, they opposed, they strictly said, though he is not on our panel list, so we are opposing it. But that COC had, that member had only 13% voting power. So in my case, I was able to get the reappointment or appointment as an RP from IRP. So, but it took a lot of pain and energy to convince those people. So, but what I could found that, you know, COC members, genuine COC members, bankers, they are also finding it very challenging as far as delivery from IPs are concerned.
Yes.
So maybe that is also one of the contributory reason where these bankers, they are not they are not comfortable with IPs also. This I could make out. So it is very challenging.
The bankers are
really dynamic field.
Bankers are not comfortable with their statutory auditor, with their concurrent auditor, with their IPs. I mean, in that way, they are always crib about one or other things.
No, sir. Therefore, it is subjective. You know, you see, bankers, they don't pay to their auditors, their stock auditors. Because in my case also, I told the bankers that you have given the working capital which has vanished. You tell me how much you pay to your stock auditors, 10,000, 20,000. And the corporate debtor director, he will pay him 1 lakh to hide the truth. So what will happen? So bankers are helpless. They don't pay. That's true. They are not going by the market dynamics.
Sir, thanks to IBBI, they have prescribed the minimum fee. Otherwise, IPs were competing and they were willing to work at 30,000 monthly fee. There were IPs who were working at 30,000.
Yeah, you are right. You are right. At least
In this,
some ground IPs have got to say that this is the minimum fee they should get.
This was the main thing, because what I went through is underestimation of the professional, and that's one professional is underestimating the other is underestimating the other. That's why what they want a client. That's true. It may be at any cost. To begin with, and initially with the beginners, this is a problem. Not with the one who are settled one, but with the one who are initially beginning. They take it at any price.
So now, at least thanks to IBBI, now there is a minimum.
That's why and even the client is also said, no, what's in it? What is there in it? Then explaining ourselves is really difficult. In fact, once I got a call, and that's too from a professional who was not RV and IP, and that was an RV assignment by chance. And he told me, ma'am, what is to be done in this? The evaluation is to be done like this. You do like this, you do like this. I just listened and I said, if you know how to do it yourself. That is.
Oh, maybe, he was right, because most of the people are doing like this only. They sit in their cabin and they are in chamber and they prepare the report and send. They depute one of or two their assistants. They go and they click the pictures. That's it.
Means that's is happening, and that's why I would say that on the professional front, we have to uphold ourselves. Means if a client is saying, okay, you do like this, it is okay. But if a professional is saying like this,
that is what I'm saying. There are different kind of challenges are from both sides. This is what I could feel with my limited experience of 2 years in this profession, out of which 1 year was only for searching the assignments, and last 1 year I have been actively involved. So, but since I am having the corporate background, that's why I could feel that delivery is very important. Your contribution is very important. Of course, your remuneration will be driven through market forces only. But fortunately, unfortunately, this is only we have to deal with people of the COC member who are of not of that level. Assuming you can't authorize a person of a managerial level or GM level person to interview the COC for their organization, even if they are HR head, correct? So, but unfortunately, they are given the responsibility and authority to interview a person who has to deliver like a CEO in case of corporate data.
Yes, absolutely right.
So this will take time to this gap. It will take time to bridge, I think.
Yes, it will take time, but as far as I perceive the scenario that was started from 2016 till now date has been changed a lot. And now they're also proposing different changes also to reduce these timelines, like giving the power to the information utility. The application is to be moved through information utility, confirming the debt and all. Changes are planned, and every year there are so many changes that the one who has read IBC properly in 2016, now if out means it is difficult to connect all the points.
Law is very, I must appreciate that, because after having spent 30-35 years of corporate experience, I found that the spirit of the law is perfectly fine.
Yes.
But it is finding various challenges in the road ahead, actually.
Practically the various, and I have not seen any action faster than that in IBBI for any particular change that is perceived in the market. Whether it was a case of PPIRP, now they are going to implement changes in the fast track insolvency profession process also. Means there is a continuous watch in the market. What are the problems being faced, that are being perceived, that are being discussed, and it's on a platform. Even I would say IP are also contributing what the difficulties we are facing. That is the point where somehow some things are being resolved, some are being left out. But with the passage within 10 or 15 years, I think this code will be entirely different and it will be easy for us to go ahead with that also.
Sure, sure. I agree with you that you see, IBBI is definitely contributing a lot to make this realistic and practical oriented. That is why we find so much and so many changes.
Yes, fast and means whenever there are changes, they are continuously in the vision to implement it practically to make it a success. That's the objective behind it.
And I really feel I really felt privileged when I interacted with various government authorities, and I could feel the pride that you are representing as an authority. You know, in my case, even the electricity department, they disconnected the electricity based on the some undesirable attempt on the part of the corporate debtor. But when I sent my person there, and they immediately reconnected, and I told them and guided them to file their claim, and they have filed the claim, and I am enjoying the electricity and paying their dues.
Yes, this is way how it is being resolved, because once they are convinced that okay, during CIRP period, whatever we are giving, we will be paid for, and this is the responsibility being taken by a authority that is having the power in under IBC. So that's why they are cooperating. Many things we have to resolve. I have heard so many experience regarding this, how they have resolved it. Earlier it was difficult to resolve, but it is now, it is comparatively easy.
Sure, sure.
The approach, what is the impact if the resolution plan is approved? The approach of granting precedence to IBC has been further fine-tuned by SAT as well as in spate of a decision, including Moneth Ispat Energy, Diwan Housing Finance, and Messrs Tata Steel Limited. In all these, they have clearly stated that yes, once the resolution plan has been approved, SEBI loses the ability to initiate proceedings or pass any penalty orders pertaining to the pre-CIRP period. So the only action that could be taken is by filing the claim as an operational creditor. If it is thought okay after the resolution plan, no gateway is available. Because once it is approved, it will be applicable to all the stakeholders, including government authorities. The enactment of IBC has a significant ongoing impact on the operation of several statutes, especially the SEBI Act. The SEBI report has rightly expounded on the need to further define the counters of Section 14 of IBC so as to avoid curtailment of regulatory powers of SEBI. Now, Section 24 of the SEBI Act makes it an offense whosoever contravene the provisions of the Act. But Section 32 capital A of the IBC may render SEBI powerless to take necessary action against any property of the corporate debtor that forms part of the resolution plan. We all know Section 32 capital A of the IBC. What is it? Anybody?
Protection from past offenses.
Who is being protected from past offenses?
Prospective resolution applicant.
Prospective.
Oh, sorry, successful resolution.
Successful resolution applicant. So then can action be taken against corporate debtor after the resolution plan is approved?
No, only against promoters.
Only against promoters and directors. So that's why SEBI is saying, now where we shall go? We shall go after individual person. We cannot look for the corporate debtor. They are saying this. The liability, what they are saying, notwithstanding anything to the contrary contained in the code or any other law, the liability of the corporate debtor, which is committed prior to the commencement of CIRP shall cease. So as far as corporate debtor is concerned, if it has committed an offense under SEBI, because the contraventions under SEBI are constituted as an offense under the Act itself. They are saying no action can be initiated against corporate debtor once the resolution plan is approved. Simultaneously, what they are saying is the corporate debtor shall not be prosecuted for an offense from the date the resolution plan has been approved. Why? If the management has been changed. Because what they are saying, the management has changed hands, same persons are not in the management of the company. Then in that case, or any person who was party to that particular offense is right now not in the new management. If that is the case, neither the corporate debtor will be liable, means neither any monetary penalty can be levied once the resolution plan is approved, nor any criminal action can be taken against the corporate debtor. You can go ahead, though an obligation has been implemented. What they are saying, you cannot take any action against the property of the corporate debtor with respect to the offense which are committed prior to CIRP, provided such property is covered under resolution plan which is approved under section 31, and there has been change in the control of the corporate debtor or sale of liquidation to a person who was not a promoter earlier or who was not a part of the offense. So even in fact against the property, no action can be initiated. What would you say in this regard? Once CIRP is there, you are saying moratorium. Now you are saying even after moratorium resolution plan is approved, the management hands are changed, new person is in control. Even the regulatory authorities can't initiate action against the corporate debtor, nor any monetary liability can be imposed, nor any criminal prosecutions can be taken, nor any property of the corporate debtor which is a part of resolution plan could be attached. So what would you say regarding this?
And this protection is required, then only the new person will take the company, no? Then only you will get the resolution plan. No? Otherwise, what is the liability or and the ultimate objective of IBC is to reorganize the company.
Then what about the regulatory authorities?
Even after introduction of this law, this has not percolated down to all prospective resolution applicants. Still in the market, people are not aware that they will get the protection, and they are, by and large, they are shying away from buying corporate debtors under the NCLT. This I have felt. I have to convince people, you don't worry, you buy this company, you submit resolution plan, but people are, promoters are reluctant.
Sir,
even now.
They are right. That was my question was there, whether it is automatic applicability of 32A or you have to seek the special exemption from the regulatory bodies like PMLA. You have to go and say, I have got these assets through resolution plus and the attachment which you have made on the assets, kindly be free that. This matter is still a sub judice before the PMLA court. Delhi High Court, various orders are there which has been hanged up. The last matter, which was the batch matter of the 35 cases, last week it was listed in Delhi High Court. It has been posted in September.
And madam, what shall be the fate of those who are from MSME taking their own company under resolution?
So there is no protection for that.
And that is actually very tricky.
If you will undergo the word they are saying,
the protection, sir. 32A is equally the protection is available to them.
The
also.
resolution plan results in change in the management or control.
So
only then this protection is available.
Yes.
My question is little different. Suppose MSME changes its directors, but MSME remains MSME. The legal form is the same, and then they take the company under resolution because they are not debarred under the court. What shall be the fate of that?
Anupji, then there is no change in control.
There is change in control, na sir. There is change in management. What he is saying.
No. Just changing director doesn't mean that there is a change in control.
Then where is the control? What has been used, sir? Change in management and control of the corporate debtor automatically change.
No, sir. This is specifically written there. There is, if the resolution plan results in change in management and control of the corporate debtor to a person who was not a promoter, or who was not in the management, or who was not in the control, or even he shall not be a related party to such promoter, previous promoter, management or controlling person.
It is clear, very much clear. 32 is very much clear.
Lot of difficulty we are facing in various NCLTs on the interpretation, and especially there is another issue. Suppose ED has attached the property much prior to commencement of CIRP. They are not actually going to give it to the new management. That difficulty is coming. They are saying that had it been during the course of CIRP, attachment has been there, then the protection of IBC was available. Otherwise, it is not. And that issue is also under adjudication.
But what the law says, ultimately some conclusion would be drawn up and it will not go beyond what is written in IBC. Basically, it has to be interpreted. A conclusion will be drawn, but it has to be convinced. What the legislature do, they draft it, and now it is up to us to explain it to the judiciary that what is the content of the law says, in spirit also and in words also. Right? So that's why issue is coming that you don't have any way out to go once CIRP is there. Many, including say Diwan Housing Finance, have placed reliance on 2018 report of the ILC, which is creating a distinction between a proceeding to assess or determine the liability and proceeding to recover. Rejecting the contention of SEBI, Securities Appellate Tribunal held that provisions of Section 14 were patently clear and simple with no degree of ambiguity. In absence of any ambiguity, it was erroneous to rely on an external aid like the report of the Insolvency Law Committee. The provision was clear in stipulating no proceedings can be initiated, no pending proceedings can be continued. Therefore, a petition for assessing or determining the liability was barred under Section 14. Further, SAT held that there were direct decisions of the Supreme Court on the overriding nature of the moratorium, and that's why if you are placing a reliance on an external aid, like report of the ILC, which have no legal authority, then it would amount to contempt. The one Viniji was saying that contempt should be there. The word contempt should be used. That has come into pick right now. It can be concluded that SEBI's reliance on ILC reports to justify action is bad in law. So it was assumed to be a contempt of court. If I will summarize that on admitting an application for initiating CIRP, the adjudicating authority under Section 14 issues a moratorium prohibiting the institution of suits, continuation of pending suits, execution means if there has been any judgment also, their decree also, they have been given, their judgment has been delivered. See how important it is saying even you cannot execute. So if there is a judgment of recovery proceedings, that cannot be executed once the company is admitted in CIRP. And even after that, if the resolution plan is approved, you cannot take an action even against the property of the corporate debtor for the recovery procedure. Thus, till the it is saying till the completion of CIRP, Section 14 is a protective shield for the corporate debtor against any form of legal proceedings. Protection under Section 14 is further strengthened by Section 238, which gives the provision of the code an overriding effect over every other law by virtue of the non-obstant clause contained therein. There are the judicial pronouncements on the overriding nature of IBC, and the moratorium related provisions thereunder have largely been consistent. This is what I said from the beginning, that the decision of the Supreme Court, apex court in the country with respect to overriding nature of IBC and moratorium is consistent from the beginning. But at the lower forum of the NCLT and NECLAT, there is a series of conflicting decisions when the SEBI sought to initiate or continue proceedings or enforce recovery amounts against the corporate debtor while a moratorium was in place. And why they are doing so? Because they don't have any other way out to recover once the moratorium is there. These decisions emanate from the authorities like Securities Appellate Tribunal, NCLT, and National Company Law Appellate Tribunal, that is NCLAT. SEBI relied upon Section 28 capital A and 11B of the Securities and Exchange Board of India Act for justifying its section. Subsection 1 of Section 28 capital A empowers SEBI to recover penalty from any person by attaching and selling their movable and immovable properties without any other recourse of law. Subsection 3, which of the Section 28 contains a non-obstinate clause, fortifies the provision by stipulating that penalty to be recovered by SEBI against any person shall have precedence over any other claim against such person. In this apparent conflict between SEBI's power to recover money, sometimes by attaching the property of the corporate debtor, and the moratorium-related provisions which strictly prohibit such actions, the question of which legislation shall take precedence arise. The issue is still awaiting final determination by the Supreme Court in 3 petitions, namely SEBI versus Moneth Ispat and Energy Limited, SEBI versus Rohit Sehgal and others, SEBI versus Raj Oils Limited. Pertinently, in SEBI versus Rohit Sehgal and others, SEBI challenged the NCLT order in Bhanu Ram versus HBN Dairies and Elite Limited, where Rohit Sehgal is an RP. In HBN Dairies, the NCLT ruled that in case of conflicting arising between IBC and SEBI Act, IBC overrides. Now, SEBI has contended before the Supreme Court that the IBC cannot be invoked to usurp its jurisdiction under the SEBI Act 1992 because both are the special legislation and therefore one cannot trump the other. Supreme Court till now has ordered that in meanwhile, the resolution professional may continue to perform his functions. We, however, only grant stay to the direction of the NCLT insofar as it has directed SEBI to hand over the title deeds to the resolution professional. It is further made clear that SEBI shall not in any manner create any encumbrance on the properties which is held by them by virtue of the title deeds. Till now, this decision is there. This is still awaited. As far as SEBI versus Moneth Ispat and Energy Limited is concerned, the question that arises for the consideration is that whether Securities and Exchange Board of India was justified in initiating the proceeding and passing an order of penalty in view of the resolution plan being approved under Section 31 of the IBC, which is read with Section 32 capital A and 238 of the said Act. Securities Appellate Tribunal said that resolution plan, once approved by the appropriate authority, is binding on SEBI as well. Therefore, once the resolution plan has been approved, SEBI is barred from issuing a show cause notice or passing an order of penalty pertaining to the period before the CIRP for violations pertaining to pre-CIRP period. That's why what they are saying, it has upheld the provisions which are there in Section 32 capital A of the IBC, again stating that because the resolution plan has been approved, now you cannot issue show cause notice. You cannot levy the penalty for the offenses, for the violations which were made before the pre-CIRP period. In Moneth Ispat Limited, SEBI has placed reliance on Section 31 subclause 1 of the IBC, which provides that once a resolution plan is approved, it is binding on the corporate debtor, its employees, members, creditors, including central government, state government, local authority to whom a debt in respect of the payment dues under any law for the time being in force is pending, such as the authority to whom statutory dues are owed. Even if this is applicable, once it is approved, it is applicable to guarantor and it is applicable to all other stakeholders which can come in the fit in the definition of stakeholders involved in the resolution plan. The rationale behind the provision is to provide a clean slate to the new management of the corporate debtor, so that once the new management takes control, erstwhile creditors and claims against the corporate debtor do not resurface by incentivizing resolution applicants to acquire business through the IBC route. Yes, but you were saying you have to convince, being an IP, I have to convince the new resolution applicant that you are not going to be touched for the pre-CIRP non-compliances or the offenses. In Raj Oil Mills Limited, the Security Appellate Tribunal has followed the decision in Monnet Ispat Energy Limited. Till now, SAT is in favor of what is there in IBC. But now, we have to check out what will be the decision of the Supreme Court for the same, right? So this was the discussion till now held for the SEBI, and it's a very fruitful participation by all of you too in this. Anything you want to discuss right now regarding the same, or if you could now switch on the video. Yes. Vinay sir is there. Okay.
I'm there.
Okay.
It was
So,
wonderful discussion. You have put up a lot of efforts to make all these case laws together and to put the issues together.
yes, because this is still not finally decided.
Yes. You have collected very well.
Yeah, thank you very much.
Possible is today's scenario that we can discuss.
Yes, but this is an insight, and furthermore, this would pave the way for all of us to go ahead for the same. Thank you, Vinay sir, and anyone else who wish to anyone else who wish to say anything regarding the topic or something else to be discussed. We have a few more minutes.
I would request all the participants to please put up their question or any topic of discussion that we need, because it has been an interactive section throughout the day today.
My submission would be that maybe there was a lot of good discussion in this platform as far as the inconsistencies are concerned. So I request ICSI to please do not break this lead now, and we should continue some kind of either maybe making a memorandum or something, or formulate some team or so that this should not leave here, because many have expressed a lot of pain, practical pain actually.
Yes.
So unless we take this forward, this will not get resolved.
For this, I just know right now here, Vinay sir.
Yes, ma'am.
And I think Monica College, you people can lead us, right?
I think Mr. Sandeep Kejriwal, me and Monica may not be the part of the system today, but Sandeep Bhai is here. Sandeep, you there? Sandeep Kejriwal is our sitting central council member, and I think we all have to together. I think ICSI, IPA is expected to collate, compile all those suggestions and issues which has been flagged today, which has been discussed. And in the form of memorandum, you can discuss it with the Ministry of Corporate Affairs or with the, the IBBI to find out a resolution to that. Maybe in the education part is more important towards the regulatory bodies. So like the Preeti may be invited to some regulators to collect together and to tell them how their right can be protected and how they can become the part of resolution mechanism, ultimately channelizing the resources of the country, which Preeti is talking about again and again, a great infrastructure.
Yes. I think actually I have also realized in some of the issues, they have come for the consultancy basically, that they are scared of. Main part.
I'm sure you have taken note of it now. Who else is with you from the IPA here?
Pardon, sir?
Who else is with you here in today's program from your side?
Sir, today I think Anjali ma'am was connected with me, but I think she logged in and my network got disturbed. That's why I got logged out from.
Not a problem.
But we can submit it to ICSI IPA.
Yes.
They are holding so many discussions. So I think Trashla, you can communicate this with the IPA, and even I will also communicate.
Actually, I just missed the point due to the network. If you could please let me know what was being talked
I will
about.
WhatsApp you. No issues.
All right, ma'am. No issues.
Rashla, the ma'am has got very good compilation of these cases. So I want this presentation to be shared with the participants.
Sir, as soon as I'll get it from ma'am, I will share it with everyone.
I will.
Both the presentation.
Preeti and Prashila,
Participants.
I have some submission to you, ma'am.
Yes.
Other institutes and some associations in even Hyderabad and Amaravati, some nearby areas, what I observed, when they conduct such discussion programs, they will write the discussion points. They will give it to all the members so that it will be useful for those people, because this is the occasion where we can have that the discussion, interactions, and get the good theme and also concepts also. It is good that our institute also make use of the discussions and give the certain discussion points to us, so that it will be useful for us, not only for IP profession, but also bankers also we can give those to people also. This is the case going on, this is the case going on, where we can fight for with. Like that is all the discussion where we can use that. In that way, why not you take the some steps with regard to giving some discussion points to the members who are participating here or members of our ICSI IPPL. This is my submission, ma'am.
Sure, sir. I will communicate this to the team as well on Monday, and then we'll surely come up with something. And I will also try and communicate to the sir that this session should be shared on our YouTube channel, so that whosoever wants to have a go through, they can always go through the link and have this session.
Yes, madam. It's good if you share the recording through the mails so that we can watch.
Through mail, we don't share recording. What we do is we have our YouTube channel. So we share all the sessions recording there. We upload with the name and date on the which session took place. So I'll communicate this to our senior on Monday. And hopefully in a day or two, it will be shared on YouTube channel.
At least you can communicate
is it possible to link for
when it is uploaded on the YouTube?
I will share the mail with the link once it is uploaded. I will share it to all the participants.
Thank you, madam.
Thank you, Preeti ji, and thank you, IPA.
Thank you, everyone. Thank you. It was an interactive session, and Vineet sir was also very interactive, and I'm happy that you all listened to it, basically. Thank you, everyone. Thank you. Thanks a lot. I will share my PPT with Rashla, and he will share with all of you. Right?
Yes,
he will share with all of you, right?
Sure,
So,
Thank you.
Thank you. Thank you very much. Thank you, everyone. Yeah. Thank you.
Namaste.